Can you help them get around?
All right.
I have a little IT. You should get going, but
Okay.
don't be surprised. This guy's gonna here to deal with a little
Okay.
IT.
Thank you, Judge. Morning, ladies and gentlemen. Obviously, next door neighbors should be able to resolve their differences without having to bother judges and juries who have better things to do. But here we are. So why are we here and what do we need y'all to do about it? What brings us here today are the rules that allow property owners to use and enjoy their property in peace, quiet. And the first rule is this: don't go out of your way to annoy, harass, cause harm, and inconvenience to your neighbors. That's called a nuisance. And the second rule is, for property, use it or lose it. And what that means is, if you don't use your property for long enough, we're talking years and years and years, decades, you can lose the right to that property. And it also means, and that applies to people that you bought your property from. If they didn't use it for a long enough period of time, what you bought from them is not what you thought you bought. So let me tell you the story of why we're here and what happened. Next. So Mr. Logan and I are trying to do this, and it's sort of like a quarterback. Put it in motion. Hit the next slide, down button. There you go. Next. Keep going. So next. John Noel and David and Stacy David moved in next door to the Andersons. We're talking about these two properties. Keep going. At the corner of West Andrews and Haversham Road. And that's the David property here on the left, and the Andrews property here that fronts on West Andrews. Next. So the timeline is that the Andersons bought their property in September of 2018, and the Davids bought their property in March of 2020. So the Andersons lived there for a few years before the Davids did. Next. When the Davids bought their property, before they moved in, they started doing construction on their property, which obviously they have every right to do. Did some painting, did some work on the interior. We don't know. They've obviously never had the Andersons over for dinner or cocktails. But the problem started immediately with the construction. Next. What happened is, keep going. What happened is the Davids workers who were working on their house, they didn't park on Haversham, they didn't park in the Davids driveway. They parked here on the frontage of West Andrews, in front of the Andersons' house. Next. And in order to get from West Andrews to the Davids property, they walked all over the Andersons property. Okay? So why'd they do that? Well, it turns out that the Andersons' property has a couple of easements on it. Next. The first is what we call easement 1, which is parking pad, and actually the Andersons own the parking pad. The Davids have an easement to use the parking pad. And then there's also this easement down here, which we call easement number 2, which is the main issue of dispute in this case. So in theory, the workers had the right to use easement 2 next. But they didn't. They used virtually everything other than easement 2. Next. So going back to the timeline, what we see is in April of 1996, 24 years before the Davids bought their property, this lady named Martha Reeves Smith created these easements. Why? That's not for y'all to worry about. That's construction of an easement. The judge is going to tell you what the easement means. So you don't need to speculate as to why she did it or what she meant or what the purpose is. The judge is going to tell you all that. Okay. So we started having encounters almost immediately. The first encounter was over these construction workers. The Andersons tried to reach out, send an email Don't know if it was the right email, but they tried to complain about it, nothing happened. Next. And then there was an encounter over trash. The Andersons or someone from the Andersons' house had the audacity to put a piece of trash in the big construction roll-off dumpster in the David property. And they did this because these workers, when they're blocking West Andrews, they're blocking access to the Andersons' trash cans. In the city of Atlanta, when they come by and they see a truck blocking the trash can, they're gonna go on down the road. So the Andersons' trash wouldn't get picked up like it should have been. So they put some trash in the David dumpster. Mr. David came over, saw Mr. Anderson's cooking something on the grill, complained about it. Mr. Anderson explained why they did that. Oh, okay. And that was it. That issue went away. Next, the Andersons were doing some work on their garage. They have a detached house. They have the house here and the garage over here, detached garage. They were cleaning out the space above the garage. They were going to finish it and maybe make it into a bedroom or something like that. Which they have every right to do, obviously. Mr. David disagreed. He came over, knocked on the door. Claire Anderson answered the door, and he told her, "You have no right to do that. People can't live above your garage." And she's like, "Okay, thank you very much," and closed the door. Next, we have disputes over fence and facade. Go to the next one. So as a result of the construction workers going across the Andersons' property, they built this fence that divides their property. And we see sod here, and we see pine straw here, and we see these big bold stakes and pink and yellow ribbons. This is the Andersons' property. This is easement area 2. These big bold pink and yellow ribbons have been placed there during this litigation by Mr. David to make sure that the Andersons know, don't step on my property. But the problem is, and the reason we're here is because February 21st, 2021, the Andersons were doing some landscape. They were having sod put on their property. This is their property, no easement whatsoever. None, no easement. And they're planning to do some landscaping here in the easement, but they never did. We'll get to that. So that morning, Mrs. David sees these workers, these landscapers, delivering sod, pallets of sod. And the sod is placed on the street and in the yard in front of the Andersons' property. She does not like it at all. She gets in her car, drives down her driveway, turns right on Haversham, turns right on West Andrews, drives down there, rolls down her window. And Mr. Anderson is working in his basement office. His basement office kind of faces the same way as this part of the garage. He's facing all of this. He can see what's going on, and he can hear the noise. He hears Mrs. David yelling at his workers, telling them, "That's my property. You can't put sod on my property. I'm going to call the police if you don't stop." And Tracy gets up and he's on his way to talk to her, and she storms off. He has to go to a meeting at the office. He comes back around lunchtime. He's up in his dining room. He sees Mrs. David driving in the driveway, because the driveway is about 10 feet from the Anderson property. So he's mad. He's also received a phone call from the landscaping boss. I'm not going to tell you what it said, but he was very mad as a result of that phone call. So he goes out to talk to Mrs. David about this. And he walks out there and take that down. And he says, he starts walking up to her like this, wants to talk to her. She rolls down her window. He's on the same side. And he says, "You can't yell at my workers like that. Don't yell at my workers." Rather than saying, "I'm sorry, apologize," explaining, she says, You're a horrible man. You're a horrible man. You've had multiple wives, which is not true. Claire is Tracy's one and only wife, but she calls him a horrible man. You've had multiple wives, and he lost it. He lost his temper. He was mad when he got there, and she added fuel to the fire, and he lost it. He called her a fat bitch. And he regrets it. Well, number one, he's going to admit saying it. He's also going to explain to you that he regrets it. He's apologized. Not his finest moment. All of that stuff. Does not matter. Next. So this is, on my timeline, this is in red. Because this is why we're here. Because of that. Next. 2 days later, Ms. Sturm sends a letter to the Andersons. Next. Next. It's a 3-page letter, and it's a very, clearly it's a cease and desist or else letter. She tells him, go back. The Davids have sole and exclusive use. Unfortunately, you continue to engage in conduct that intentionally and blatantly disregards and tramples upon the Davids' exclusive rights to use and enjoy the easement areas. Next. She says you have trespassed, engaged in unlawful clearing and cutting of trees without an arborist permit, which I think is a crime in the city of Atlanta, I'm not sure, and other vegetation. She says this. She says you've also installed illegal surveillance cameras on your property. He says down here, please be advised that such conduct is not only illegal, but constitutes criminal conduct. Is accusing him of multiple crimes in this letter. Next. She concludes by saying this, if you don't give me everything I have demanded, we are going to sue you. We're going to seek all damages, we're going to seek an injunction, and she finishes by saying this. Next. Including placement of any and all appropriate liens on your property. That's pretty serious letter from a lawyer. Now, bear in mind, all this other stuff we've heard about, the removal of the trees, the removal of the vegetation, the surveillance, they've been there for 11 months. We haven't heard one word about any of that. This is all raised for the first time 2 days later, 2 days after what I call the incident. Next. In response, Mr. Anderson, as a lawyer from Alston and Bird, a very, very big, very well-recognized firm here in Atlanta. Mark Rushi writes a letter, brushes back on everything. Tracy thinks it's resolved. Doesn't hear anything for the better part of the rest of the month. Next. Little did he know that the next thing that happens is Ms. Sturm's office prepares what is called a verified petition for stalking temporary protective order. Basically accusing Mr. Anderson of committing the crime of stalking. And Mrs. David verifies this. She signs it. It's a verification. She takes an oath, just like the witnesses who testified in front of you are going to take an oath. She's swearing that everything in here is true and correct. Accusing Mr. Anderson of crimes. Next. But they don't file it for a few weeks. The next thing they do, and we didn't know this at the time, we have since learned it, on March 18th, 2021, Ms. Sturm has a discussion with a fellow named David Shostak. He is an arborist. And what they are talking about is building a claim for damages for the removal of vegetation and trees from the easement. Next. The petition. Keep going. Next, the TPO petition is filed on April 2nd, and these these things, I don't know if y'all know anything about it, but you can get a temporary protective order, 30-day order. It's ex parte, meaning it's just you and the judge. The other side doesn't know about it, doesn't have an opportunity to respond or be heard. So this is issued ex parte by a judge and is served on Mr. Anderson by the Fulton County Sheriff. That's when we get involved. So we have to defend the TPO petition, but we know beyond any shadow of a doubt that a lawsuit is going to be filed between these parties over this relationship. So we filed the lawsuit on April 12th of 2021 because we have a joke around my office. What do you call somebody who threatens a lawsuit? You call them a defendant because we want to go first and last. Next. So we filed this lawsuit against the Davids for three things at the beginning. Number one, we wanted a declaratory judgment as to whether the Davids were right that they have exclusive use to the easement, meaning if this is the easement line, Mr. Anderson steps across it, he can be arrested for criminal trespass, even though he owns the property and pays taxes on it. So we wanted to get the court to rule on that. And that's an issue of law for the court, just like these objections and other things Judge McBurney said. And I don't know exactly how he's going to phrase it, but I'm confident that at the end of this trial, he will tell you as a matter of law that the Andersons have the right to use their easement areas as long as they don't actually interfere with the Davis uses. Next, we wanted a jury to tell us whether the easements had been abandoned or extinguished, because Mr. Anderson will tell you when they moved in 2018, though that easement was a complete hodgepodge. It was a junkyard. There wasn't any beautiful landscaping. It was a dumping ground for yard waste. His prior owners had some railroad cross ties that they used as a walkway. Whenever those would rot, they'd pick them up and throw them into the easement. And also that easement area, which the Davids will tell you is beautiful in nature, we loved walking on it. It was a snake pit. It was filled with copperheads. Mr. Anderson killed 14 copperheads, but now that's a trespass. So we also filed suit over the trespass by the workers. That's not really that big a deal. If none of this had happened, we wouldn't be here about that, I guarantee you. Next. Now, by this time, April, when we filed the lawsuit in April, it didn't appear that the Davids had actually done any uses of the property that we could tell. But starting in August of 2021, after the lawsuit's been pending for a few months, the Davids actually start using the easements. Next. Now, I've got three videos here I want to show you. They're just a few seconds each. This first video is the frontage of West Andrews, the easement area, the frontage area. So you can see that there's no path. There's no way for workers to carry their tool belts and heavy equipment to get back there to do construction. It's in the path that somebody uses for their morning runs. It's impassable. Hadn't been used in decades. You see here we have the ribbons showing up. So that's the entire frontage of the easement. That video is taken August 12th, 2021. Next video is literally a few hours later that very day. Here's Mr. David. Decides to install some sports nets on this wet, mushy ground. He sees Mr. Anderson videoing him. He picks up his phone and calls somebody. Who does he call? We do not know. We asked him, he doesn't remember. We put his lawyer on notice to preserve his call log. Disappeared. Don't have it. Next video. No, it's all right. Black spot. There you go. A few hours later,
Here's the net thing they put up.
Mr. Anderson, there it.
They're over there cleaning out something. Don't know what, but they're tearing up my property.
Okay. Next slide. So the first time we actually see any uses is during the lawsuit, and all of this happens on August 12th. Over the weekend, this is a before picture, Friday, August 12th, after picture, August 15th. Next. They've cleared the easement and left a nice little thank you here for Mr. Anderson and the city of Atlanta. That's not the only way they've used the easement during this lawsuit. Next. Next. Mr. David has put the lawn chairs out there because he supposedly likes to use easement too for ingress and egress for his runs, and he likes to sit here afterwards and have his morning coffee after running. Put these big sports nets up in this mushy, worthless area.
So you're doing some closing argument here as well? If you want to give a preview to the jurors of what the evidence may show, you can hang adjectives on those potential facts in your closing.
I apologize for them.
It's okay.
The evidence will show that the Davids have installed these nets in the easement area. We'll also show that the Davids have a very nice, well-manicured lawn in their backyard, which some people might think would be a better area for this type of work. We've complained about these nets. They're still there this morning. Next. So after this, we amended the complaint and we added a claim for nuisance because of the intentional actions in putting these nets up there for what we contend is not a legitimate purpose. Next. Next slide. Now, the Davids filed some counterclaims against us. Mainly trespass. And the trespass, as I understand it, I stand to be corrected during the trial if necessary. But as I understand it, the trespass, or one of the trespass claims, relates to throwing trash in the dumpster. Next. Well, somebody in the David household was so upset about the trash in the dumpster that they actually took a picture of the trash in the dumpster. A couple of pictures, and I don't have it on this, but they zoomed in and you can see that this is actually addressed to Tracy Anderson. So we didn't hear anything about this before the lawsuit, but now it's a big issue. Next is, they say that Mr. Anderson has removed all sorts of vegetation from their yard. Remember, next slide, before the TPO petition was filed, next, Mr. was having these discussions with this arborist about their damages model. And the arborist prepares a report, next. And he's claiming down here $87,000 in damages to replace the landscaping that has been removed. And of the 87,000, 65,000 of it is to replace this one 10x15 bush, 10x15 one. He's going to replace it with 2,250 3-gallon plants, potted plants. Next. So it's, the ratio for that is 2,250 to 1. That's in Mr. Showtack's report. We don't know if he's going to come in here and tell you, I made a mistake, it should have been 250 or 225. We'll just wait and see. But next. What we do know from his report is he calculated the area of what we're talking about. The area was approximately 1,800 square feet. So he's planning to put 2,250 3-gallon buckets of this stuff. And that doesn't count all the other stuff that he's calculated. 2,250 3-gallon buckets in an 1,800 square foot area. So we'll see. We'll see. Next. Now, we'll see if or how they can continue to use the easement for the sports nets and their walkways that they've cut in, if they put 2,250 of these buckets in here. Next. So when you look at the timeline of key events, the evidence will be, I believe, at the end of this trial, you'll agree, that none of the trash removal, none of the putting that FedEx box in the dumpster, that's not why we're here. Next. We're here for one reason only. Because Tracy Anderson, after being provoked, lost his temper and used a bad word. He's apologized to it or for it multiple times. He owns it. He's the CEO of a company with 265 employees. He'll tell you he referees fights all the time. Not proud of this, but that's why we're here. Mrs. David, I doubt if she will accept any responsibility for what happened here. Next. At the end of this trial, we're going to ask you for several things. First, we're going to ask you to extinguish easement 2 for two simple reasons. Number one, factually, it was extinguished because it was formed in 1996. It had not been used in the 24 intervening years. So it was gone. They had nothing to buy. Now you're going to hear, I anticipate, from the prior owner, Mr. or Mrs. Darby, maybe both of them, who may tell you, oh yeah, we loved it, we used it for its peace and beauty and this, that, and the other. But we will prove actual adverse use by using it as a dumping ground. And Nikirk used to own the Anderson's property. She will testify by Zoom tomorrow. She will tell you that their landscaper used it as a dumping ground, and she never saw the Darbys use it. Now, Miss Darby, Mr. and Ms. Darby, they both tell you, oh, we loved it, we used it. They moved to Florida in 2001, became permanent full-time tax residents of the state of Florida, meaning you have to live there for at least half a year plus a day. So we think that's sufficient to prove abandonment and adverse possession. The other reason is this: we all know if they continue to have rights to this easement, you are not the only jury who's going to have to spend 2 or 3 days of your lives refereeing a fight between the Andersons. Next. Next, we want a jury verdict in our favor on the nuisance claim. And the measure of damages for that is the enlightened conscience of a jury. So whatever y'all think is fair. Next, for compensatory damages for that. And also, we have a claim for bad faith attorney's fees and for putting these nets up in the course of this litigation. We think we will prove that they did so with the specific intent of trying to escalate tensions between the parties as opposed to trying to de-escalate tensions between the parties. So we think that's bad faith in the underlying force of the conduct. And finally, you're going to have a box on your verdict form for punitive damages. It says if they've acted intentionally or with conscious indifference to the consequences of their actions, yes, and we can get punitive damages against them. And on their counterclaims, obviously, want to reject all counterclaims. Or on the off chance that you think putting that cardboard FedEx box and that chimney screen in this big old, whatever it is, 15-foot dumpster, actually did interfere with their use of that dumpster, give them $1. We don't care. But as for the interference, next. Because on the Bush's claim, the $65,000 to replace that one bush, you're going to see lots of pictures that the Davids took of the Anderson property and the easement and all this stuff when they got mad. When they thought the Andersons were doing something they shouldn't do. You're gonna see lots of pictures of that. What you're not going to see is a picture of this beautiful 8x10 bush that used to be there and has been removed. Pure speculation, pure speculation. So you're gonna have to, we're gonna ask you to reject that. And the trash and dumpster, I've talked about that. So at the end of the trial, we're gonna ask for a verdict in our favor on all counts and ask for a verdict in our favor on all of their counterclaims. So before I sit down, let me say this. Go ahead next. You know, I'm a lawyer, and I know a lot of people don't like lawyers, but I'm proud to be a lawyer. I take an oath to do what I do. And our job here this week is to help you find the truth and do justice between these parties who can't figure it out for themselves. And y'all got a jury summons and you're here and it's a big inconvenience for you. Some of you have travel plans later in the week. I understand that, and we certainly appreciate you being here. My job is not to make your job one bit harder than it needs to be or take one bit longer than it needs to be. And if I do, I want you to hold it against the Andersons because I'm their lawyer. I represent them and I speak for them. So if I do something wrong, hold it against, if I intentionally do something wrong, hold it against them. And my friends here on the other side, they're lawyers just like I am. They take the same oath that I take. They have the same duties and responsibilities to you that I have. And I'm sure they will agree with me that if they waste your time, if they make your job harder, if they try to make up a claim out of whole cloth, you should hold it against them.
Yeah, I hate to object to someone's opening statement, but this is a closing argument.
I think he's closing, so
I'm
we
done.
don't have to do any more closing in his opening.
I'm done, Your Honor, so
All right,
thank y'all.
we will pivot to counsel for the Davids.
Yeah.
Sir.
Thank you, Judge. Good morning. I'm Casey Sturm. Along with my colleague Jeff Schneider, we represent Jean-Noel and Stacy David. I do not disagree at all that all of us probably sitting here believe that neighbors should be able to work things out. That you should be able to knock on that door, on your neighbor's door, and say, "Hi, I'm your new neighbor." That's not what happened, and that's why we're here. Let's also be real clear, just like we tell our kids. We know there are always two sides to every story. And I'm going to talk to you about what really happened here. Okay? And that's on March 27th, 2020, my clients, they bought their dream home. Okay? We all can envision what that may be like. We're going to take that next step, right? We're about to open that new chapter in our life. We're full of hope. We're full of excitement, right? They've got two young teenage kids at the time, and they're ready, right? We're going to make this place our home. We are excited. At this time, they don't know the Andersons. They don't know their next door neighbors. They've never met them before. They're excited though. They could have never fathomed what was about to take place. Okay. This is not your normal, oh my goodness, what have I walked into with my next door neighbor? Okay, you could never fathom what was about to happen. It started almost immediately after they moved in. And yes, they bought the house, they had plans to renovate it. They started renovation shortly after they moved in. What happened though is not the picture Mr. Anderson wants you to see. What happened is there was a pattern of abuse, of aggression, of willful disregard for their new neighbors. They haven't even said hello to. Their new neighbors who have just moved in. You heard Mr. Anderson, Mr. Edwards admit his client yelled at Mrs. David. He called her a fat bitch. He also said, "You're going to die." Mrs. David's husband travels internationally. He's gone almost every day of the week, Monday to Friday. You think about how those kind of comments would make you feel if you just moved into a house. Can hear me. They make me feel like that. How does that make you feel when you just move in? You are scared. What am I living next to? How do I handle this? Do I need somebody to protect me? So since shortly after they moved in, what we will show you is that there is a pattern of this aggression, of this abuse, of this harassment. Let's make no mistake about it. They're going to admit several things. They admitted they cleared easement too. They will admit that they attempted to fence it off completely so that the Davids could not access it. They yelled rude comments. I'll tell you more about that because Mr. Edwards said, "Oh, Mr. Anderson regretted it." You didn't hear him say, "Hey, he went back over to the neighbor's door and knocked on it and said, 'Hey, I'm real sorry about that. Can we start over?'" Didn't hear that, and you won't hear that. Didn't happen. This harassing continued from the day they purchased to today. It's ongoing. That's why we're here. So as you can see, this dream home has for them become a living nightmare. This is their day to day. What is this man going to say? What is he going to do next? Let's talk about a few things. This case, it involves easement rights. These are property issues. The judge is going to talk to you about the law on that. Easements generally, layman's terms, the right to use somebody else's property. The facts surrounding the grant of these easements, they're not in dispute. Easements were created by prior property owners in 1996. You're going to see the easement agreement. It's going to say it's a perpetual easement over and across what is now the Anderson property, two separate areas, easement 1, easement 2. You're going to hear, you heard from Mr. Edwards. The Andersons bought their property from Ann Nikirk. Ann Nikirk's a real estate agent in Atlanta. She sold the property to the Andersons. Their deed says your property is subject to the same easement agreement. Certainly, if this easement agreement had been extinguished or easement 2 no longer was in existence, certainly Ann Nikirk, a real estate agent, a prominent one in the Atlanta area, wouldn't have put into the deed that this property is subject to these 2 easements. The closing attorneys, same closing firm for both sides. Andersons buy their property in September of 2018. A year and a half later, the Davids buy their property, March 27, 2020. Same closing firm. Their deed also mentions your property is subject to the same easement agreements, giving you rights to the use of 2 easements on what is the Anderson property. You're here that not only did they have the same closing firm, but the understanding that was provided to the Davids when they asked about the easements was you have the sole and exclusive use.
Object, she's getting to legal arguments. She's giving legal advice as to what closing attorneys may have said, that's improper.
I'm not here, I know this was one of the issues we talked about before as to what the understanding of the clients were when they purchased the property.
Okay, just make sure it's not coming from the mouth of the closing attorney.
Sure. So the understanding of the Davids when they purchased sole and exclusive use of these easement areas. What does the easement agreement say? You're going to see it. It's tiny, so hopefully we'll be able to also show you it blown up in size. 2 easement area. This easement agreement is recorded. That means it's in the Fulton County property records. If you look it up, you're going to see hey, here's reference to this easement agreement, and then you can go find the recorded and filed easement agreement. Easement 1, it consists of a brick parking pad. It's part of the natural drive parking turnaround area for the Dobbies. It's built in the same characteristic and style as their home. They use it to park. Okay, it's surrounded by a brick wall. It specifically says in the agreement, and again, you can read it, the Andersons are not to interfere with the use of that by the Dobbies. Easement 2, language in the easement agreement. Sole, and it says, for any legal purpose, you can use this area for any legal purpose whatsoever in the easement agreement. Both sides have, both sides got. Both sides knew about. Those are the rules under which we're operating. Those are the rules under which these parties come to this property. Despite those explicit rules in the agreement, and both, I should say, both easements also say, easement 2 in the agreement says the same thing. Andersons, you have no right to interfere with the Dobbies' use of easement 2. And despite that, that is what has continued to happen throughout this case. Since the day the Dobbies purchased their property. I want to take a moment because what you heard Mr. Edwards say is they want to distract you really from all their conduct and activity. They want to say, hey, look, this was extinguished. Don't be fooled. The judge will give you the law, but don't be fooled on what they're saying. Again, they bought this property subject to this easement agreement. It was sold to them from a real estate agent prominent in this area with the full understanding that that easement agreement was there. There is no evidence that they can offer that anybody has modified this agreement or anybody has rescinded it. Has not happened. Evidence will also show that my clients, before they purchased their property, they walked through easement 2. I know, crazy, right? That wooded area that has ivy in it. They hiked right through it. Went through the woods up to the back of their property. You'll hear other people have done it too. There is no extinguishment here. Even if they did use it to throw refuse in, it doesn't defeat the purpose of it. It says you can use it for any legal purpose. You will hear from the Dobbies that for them, it was one of the selling points. One, we've all heard Atlanta, it's the city in the forest, right? They really liked the fact that it was wooded. It gave their backyard this sense of real privacy and shielding. They also liked another feature of it. The fact that you could get to West Andrews. Haversham is a busy road. They have young kids. This concept that you can park on West Andrews, you can go up through the woods and you can get to the house. You've got options. They like that. That was attractive to them in the purchase. And so don't be fooled about this concept, oh, it was extinguished and so we had every right. They bought it knowing full well there was an easement agreement on it. Also want you to pay attention to the fact that you hear me say Andersons bought in September 2018. The Davids purchased their property a year and a half later. The Andersons made no use of easement 2 until after the Davids moved in. Let's talk about a few things that came up. The Davids were renovating. They had workers. They had workers that parked on West Andrews. West Andrews is a public street. You can park on West Andrews. They had workers who knew you could go up through the woods to our house. We all understand how construction can go. It's annoying, sure. And it's annoying when a neighbor does it and we live through it and we try to work through it. And the thing to do is knock on the door. right? You got a problem, knock on the door. So he didn't hear about these workers. The storyline that's been passed for you is not the same. The trash. Yeah, they threw trash in their dumpster. Anybody that's done a construction project knows you pay by what goes in there and you pay for the new dumpsters. Was the trash really a big deal? No. They would have liked for the Andersons to have asked, hey, are you cool with us throwing, these are kind of big things, can we throw them in your dumpster, you got it next door? Yeah, sure, probably would have been fine. What happened, Mr. David went next door and knocked on the door to try to, he thought, this would be a good chance to maybe go and introduce him, say, hey, I'm your trash, you my dumpster, I'm your neighbor type of thing. You'll hear from Mr. David, that did not go well. That did not go well. His neighbor did not want to talk about that. Shortly after the Davids moved in, shortly after these incidents, these supposed incidents that the Andersons talk about with the workers, the Andersons decide they're going to clear easement to a portion of it. They don't contact the Davids. They don't notify the Davids. They just go in and clear it. The Davids are upset by that. I mean, they purchased it. One of the features that they liked was this wooded area. No notice, no contact. They didn't just do that. They put up a fence. You can put up a fence. You can fence your property line, right? They didn't just put up a fence on their property line. The intent was to run it all the way down, not just their property line, but the easement too, so that it would block via a fence any access the Davids would have to easement too. You heard Mr. Edwards say this all started in February of 2021 when there was the yelling, Mr. Anderson yelling at Mrs. David. But I'm going to show you their landscape plan from August of 2020. The Andersons' landscape plan for their property shows them using all of easement 2. It shows them extending a fence down all of their property to block easement 2. It shows them putting a fence along the easement area and West Andrews, so that you're really fencing off this whole easement area that they knew and the Davids know the Davids have the right to use. So this didn't start in 2021 with the yelling incident. This was an intentional design and pattern by the Andersons. And they may have been angry. They may have been angry that there were workers. They may have been angry that there was construction. But this type of action is not justified for such anger.
I'm sorry, justified for, I'm sorry.
Such anger.
Thank you.
The Andersons, there was some mention of sod. Davids have no problem with the Andersons sodding their property. Again, look at the landscape plan we're going to show you. 2020. It clearly shows that the intent was to sod easement 2 as well. They admit they sodded the area. They admit they put in an irrigation system. Oh, it just so happened that one of the irrigation head sprinklers is on the easement. That's what they're going to tell you. It just so happened, but it's a plan. They have a landscape plan. It says we're going to do this. They put lighting in trees in the easement area. This all happens. This all happens before there's any legal action. This all happens, and then Mr. Anderson yells, "You fat bitch, you're gonna die," at Mrs. David. And again, he said, Mr. Edwards says he regrets it. He's sorry. You did not hear anyone knocking on a door. You did not hear any apology. But it's not the first time Mr. Anderson has made remarks. They want to try to claim, hey, look, I lost my cool. It happens. It's not the first time. It continued. After this lawsuit was filed and you saw the videos, you will see that the Andersons have taken it upon themselves to film the Davids when they're out on the easement area. You're going to see Mr. Anderson filming the David's teenage son. You're going to hear from the son in that video. I don't like it, I'm 13. Please don't do that. It's weird. Who does that? Who films a kid out on an easement? He's got a little cross and a lacrosse ball. You're gonna see him film Mr. David. You're gonna hear from Mrs. David. And again, keep in mind, her husband travels for work. So he is gone Monday to Friday most of the time. You're gonna hear from Mrs. David that on 2 occasions, Mr. Anderson yelled racial slurs at the Davids in front of their son. He called them Algerian niggers. Who says that? Who says that? This is not a man that yelled at a lady one time, calling her a fat bitch. This is a repeated conduct and disclosure. Does not like his neighbors, and he wants them to understand that they are not welcome near his property. He does not want them to use easement 2. You will also hear that at one point, Mr. Anderson, he owns a shotgun. You will hear that he took that out of his car, supposedly carried it to his garage. You will hear that that was done in front of one of the David's children. Again, these folks are already on edge. Their new neighbors are not at all what they had envisioned when they purchased that home to be. This is not the neighborly situation they were hoping to walk into. And what we will show to you through this pattern of activity and conduct that has happened is that this is intentional. It is designed to prevent them from accessing and using these easement areas. It is designed to interfere with the rights that they acquired under that easement agreement. Says you can use easement 2 for any legal purpose. That can be for woods, that can be for walking, that could be for playing ball. Regardless of how they want to characterize the area, the Davids have the right to use it for any legal purpose. And there is a pattern to what is going on here with the conduct of the Andersons. Make no mistake about it. Nobody yells those kind of things at their neighbors. Nobody behaves in that kind of way. What we hope is for that knock on the door. That is not what Mr. Anderson has done here. And then they sued us. They sued us. You heard Mr. Edwards. Yeah, we got your letter. We decided to sue you, right? You heard him. We don't want to be the defendant. We want to be the plaintiff. And so we're going to sue you. So here we are with all of you all, hoping that you can help us put an end to this living nightmare. Yes, we hired someone to assess value of a cleared area. Mr. Shostak. You'll hear that he did what anybody would do when at the time you don't have information about what was actually cleared. Okay? If you have information, you use the information. If you don't have information, is there stuff on the ground? If you don't have stuff on the ground, is there another way to do it? And so he'll tell you why he did the appraisal analysis he did, and why he came up with the analysis he did. The reality here is that the focus is on this blatant and constant barrage against the Davids that has interfered with any right to use easement 2. We are blocking you from this. We want to end this nightmare. We need you all to help us. You heard Mr. Anderson, Mr. Edwards talk about some property stakes, survey markers. It's pretty common when you have property and you want to know where the boundaries are. You have somebody flag it, stake it, and put up markers. What you'll hear is that Mr. Anderson took those down. Again, we've got young kids. So the fact that somebody went out there and take back up, that is to be certain, right? That is to be clear. You are on the easement and you are not on the Anderson property, right? There's nothing untoward about that. The purpose of those stakes and those markers is to make sure everybody knows this is easement, this is Anderson property. Don't go on Anderson property, you can be on easement 2. But apparently, that's unsightly. And so the Andersons pull it down multiple times and the parties attempt to put it back so that everybody can be real clear. I will close with this. Again, my clients didn't bring this lawsuit. The Anderson product, the conduct, the pattern of conduct, the reprehensible yelling, name calling, what have you. It's not neighborly. It's not kind. It's not a way any neighbor should act, regardless of whether you lose your cool. The Davids need your assistance in making this stop. And after you've heard all the evidence in this case, and the judge explains the law to you, we are going to be asking you to return a verdict in favor of the Davids. Appreciate your time and attention this morning and throughout this case, and for your service. Thank you.
Thank you, Ms. Sturm. Ladies and gentlemen, before I ask Mr. Edwards to call the first witness on behalf of the Andersons, I'm going to give you the morning break. You've been focused on the openings, and I want to make sure you're refreshed. We'll go. Our lunch break is going to be just a little bit before 12:30. It will be an hour. Lunch will always be at least an hour. I have a meeting back in my chambers at 12:30, so we're going to need to break a little before 12:30. Take that hour lunch and then
May we approach?
She wants to do her brief opening.
Oh, you don't even need to approach.
Okay.
There's a funny third, it's not funny as in funny, haha. There's a necessary third piece to the openings because Ms. Medwick has a specific role on the team with the Andersons. She is handling the defense of the counterclaims. I mentioned to you all that even though the Andersons are listed as plaintiffs, it's Andersons versus Davids. I didn't mean to leave you out of this. The Davids brought counterclaims. They are the plaintiffs, if you will. They have the burden of proof, preponderance of the evidence as to the counterclaims. And the way that the Andersons team has divided this up is Mr. Edwards is focused on, if you will, prosecuting, proving up the Andersons' claims. And Ms. Medwick is much more defending against the Davids' counterclaims. And so it is appropriate for her to speak as well. Don't apologize. I forgot the way we're going to flow. So you may from time, we may every once in a while have a witness where both Mr. Edwards and Ms. Medwick ask questions of that witness, even though, wait a minute, the lawyers are all right there. It will only be one lawyer from the David's side who gives an opening or handles a witness, but the Andersons have this kind of dual role because the counterclaims were brought. And so I didn't mean to shortchange you at all. You'll still get your morning break, but we are going to hear from Ms. Medwick. She said it's super brief. Let's hold her to that.
Yes.
Her opening statement about the David's counterclaims. Ms. Medwick, if you would, please.
Thank you. I'm sorry to interrupt you, Ron.
No.
Good morning, and I am going to be very brief. What I cannot impress upon enough is what you're going to be asked to decide in this case concerns easement two. You're not going to be asked to decide if these neighbors should like each other, if they should like each other. You know, you're not going to be asked to decide that. You're not going to be asked to help them like each other. That's not what this case is about. And when it comes to the counterclaims that the Davids brought, it's about easement two. And whether or not anything that the Andersons did interfered with their reasonable use of it. So I want you to look out for evidence that talks about what was easement two like? What was easement two like when the Andersons bought it? You're gonna hear evidence. Weeds, poison ivy. If you don't know what railroad ties are, they're wood. So I did have to look that up at one point in time, so I'll admit that. And that it was rotten, thrown back there, trash, plastic bottles, venomous snakes. You'll hear evidence that it was like that for a long time. And so that's why they cleaned it up. Did cleaning that up interfere with the David's use? You can decide for yourself about that. Pay attention to evidence about who didn't use easement two. When people did start using easement two, and by people, I do mean the Davids, when they started using easement two, when did they start using it? How did they start using it? How often did they start using it? And clearly there's one very uncomfortable interaction that has been admitted by the Andersons that was addressed to you. Other interactions are disputed as to if they ever took place, what, if anything, was ever said. So that'll be something for you to decide. But look at the timeline, look at the evidence. If there was continued use after uncomfortable conversations, decide for yourself. Was that an interference? It didn't stop somebody from using it. Did it interfere? So look out for evidence about that, because it's not about I didn't like something, I don't like you. It's about interference. So when it comes to the counterclaim, that's really what it's about. It's about interference. It's not about liking, disliking somebody. Certainly everybody's entitled to their feelings, but we need to stay focused on what this trial is actually about, what the evidence really says, and that'll help you make your decision. And one of the most important things that you have with you as you're listening to the evidence, as you're making your decisions, is your common sense. You answered a lot of questions yesterday. You're here. Thank you. You all have common sense. It's a really wonderful guide. So let it help you determine everything, determine the evidence you believe, apply the law when Judge McBurney gives it to you. And, you know, this decision is going to be your collective decision. We really do appreciate your time today. So I know you want that morning break. So I'm going to stop talking. Thank you so much.
Thank you, Ms. Medwick, and I apologize again for
I'm
making any
sorry.
decision that could be deemed as not acknowledging your right to address the group as well. I appreciate it.
Thank you.
So now we are going to take our morning break. This is your first break since the trial has started. You haven't heard any evidence yet, so there's really not a whole lot to talk about back there about the case, but you shouldn't do that anyway. Don't talk about the case. No outside research. If you didn't know what a railroad tie is now, Ms. Medwick has told you what she thinks one is. It's still not evidence, but don't research anything. Enjoy as best you can the space back there. If you are low on any supplies back there, let us know and we will do our best to restock.
Very nice. And you probably call-
May I see it? Welcome on board.
You guys don't listen to what Deputy Gordon says. Repeat what you said, Deputy Gordon.
May I see it? Of course.
There you go. Logan is the only one who listens. Judge, sir.
As I recall from yesterday, you told defense counsel that they should approach before we raise this issue of the Algerian N-word, the verbal harassment. Ms. Sturm obviously did not do that. I just want to let everybody know, in my opinion, and you can correct me if I'm wrong, obviously.
Okay.
She's opened the door to the timing of when this claim was first raised. I had the very first email from Ms. Sturm where this issue was raised, which was November 9th, 2023, which is 2 days after the Supreme Court denied cert. So I intend to go into that with Ms. Rangers.
Okay, so two things. One, I don't recall saying that we needed to discuss again anything about any defense evidence that one of your clients said something racially insensitive. We talked about it, and my ruling was if it's coming in not as hearsay, obviously it's a statement alleged to have been made by Mr. Anderson. That part's not hearsay, but it's not Mr. David saying, my son told me that Mr. Anderson said that, then it can come in if that's where the defense wants to go. So I don't believe that Ms. Sturm crossed a line that I drew, but I understand what you want to do. And I guess you're gonna, where you'll need to be a little careful is getting into lawyer communications and what the significance of the Supreme Court's ruling was.
Just something to the effect of when's the first time you heard it? Does this refresh your recollection?
Yep.
Yes. Is there anything significant that happened in this case around that time? Yes, the Supreme Court ruled in our favor.
Okay. I mean, as long as I don't have an issue with that. I'll hear from defense counsel in just a moment, but I appreciate you managing it that way as opposed to diving into, well, they ruled in your favor on what? What did this? Actually, the Supreme Court just said we deny cert.
Well, that's.
That would then, but there's nothing wrong with you characterizing it that way. And that kind of shorthand is helpful because what I want to avoid is the lawyers diving into, well, here's what the Court of Appeals said or didn't say. And that's really not a jury matter. But the significance of that to what people or the connection of the procedural timeline with what's going on substantively, I think is fair game for you to explore.
Thank you.
Ms. Sturm, any issue if Mr. Edwards handles it the way more or less he described?
If it gets handled that way, that's fine. My big concern again is the kind of cherry picking of counsel communications. And I guess we'll just have to pay close attention.
Sure, and I don't know that there's an objection to Mr. Edwards picking Exhibit X, because then you'd be able to say, look at Exhibit Y, Z, A, B, and C. If you think that that paints a more complete picture in terms of refreshing recollection. I didn't hear Mr. Edwards say, and I'm putting any of these up. These are all, let me refresh your recollection, or I'd like you to refer to witnesses can look at things. If he's going to want to tender it, that's a different discussion. And I didn't hear him say he was going to tender it.
Correct.
That we would need to be much more careful about. Okay.
And that's fine. I guess my concern a little bit is around this concept that, you know, there's some kind of settlement discussion happening and they're claiming that that's the first time they heard it. But I will just pay close attention to what's going on.
Okay. Got it.
And Judge, by all means, if she has another email, settlement discussion or otherwise, before November 9th, where she used that, accused Mr. Anderson of using that language, by all means, offer it. I mean, actually offer it. I'm glad to have the jury see it
Okay.
because it doesn't exist.
Okay. All right. Let's bring the juror. Was there anything, Ms. Sturm, from the defense side? Okay. Anything from the counterclaim defense side?
No, Your Honor.
No. Okay. Let's bring the jurors in. We're ready for the Anderson's first witness.
We call Claire Anderson.
Ms. Anderson, come on up, please.
What you said, can you raise your right hand? And you swear affirm that the testimony will be the truth, the whole truth, and about the truth of the God. Fill in your seat.
All right.
Can you state and spell your name for the record?
Yes, but first let's make sure that the microphone is near you and that it's on. You can bend it right around. I don't see a little light on it. Does it have to work? It's
Says
working.
unmute.
Great. Okay. So if you would state your name and spell your name for the record, please.
Okay, Claire Anderson, CLAIREANDERSON.
Edwards.
All right, Claire, I know we kind of talked about the order of how I was going to do this, but I want to change it based on Ms. Sturm's opening.
Okay.
I'm going to talk about the elephant in the room, so to speak. The Algerian N-word. Is that a word or phrase that your husband would ever use?
Absolutely not.
Why not? Well, let me ask you this. Is he a racist?
Absolutely not.
Everybody denies being a racist. What can you point to support that?
Well, I was thinking about that, when I heard that. Our daughter is a teacher and this is an example. Our daughter is a teacher and she taught at KIP Academy. It's by the airport. And, it's a charter school, but very, very poor students, are there. And she came home soon after she had started and was talking about a family. They had 11 children, 2 she had taught. And
Objection, Your Honor. Are we getting into hearsay on what the daughter?
Right, this is getting a little far afield.
It's leading to what she and her husband did. It explains their conduct and rebuts this totally.
Okay, you don't comment, you.
And
You can comment.
it rebuts this
Allegation.
allegation.
Okay. Okay.
and she was real worried because the mother was in jail and she came home and was real upset about it. And Tracy, we were just talking about what we could do. Well, we took these children in. Tracy, it was his idea, bring them home, feed them, give them a good place, to sleep, take them back to school. And just to prove our relationship with them, my daughter, the teacher, just got married. They were in the wedding. It was Tracy's idea to take care of them. And, it's something that none of us will forget. So that kind of shows that he is not a racist at all.
Thank you. Now, let's kind of circle back to where I originally planned
Okay.
to start. Tell us a little bit about yourself, just a minute. Where are you from? What do you do?
I'm from here. I'm from Atlanta, have 3 kids, all have graduated from college. And since then, I've really just spent my time, with them and painting, taking classes, and really selling my art, which I love. So it's a good distraction from not having any children at home.
And when did you and Tracy get married?
Wait, 97, God, 97.
Okay. And y'all live where?
Andrews, West Andrews.
When's the first time y'all looked at buying the property that you currently live in?
Right when we were married, it was for sale, and we rode by and we loved it. We looked at it, and then we just decided we were going to rent right when we first got married. So we didn't buy anything. Then, when we were ready to buy, I saw that it was on the market again, and we just were excited and remembered how much we liked it.
You toured the house on both occasions in
Yes.
97 and 18?
Yes.
Did you ever look at easement 2 on either occasion?
No.
Was it a big deal to you one way or the other?
No.
Did it appear to you, based on what you actually saw, that it had been used by the next door neighbors for any period of time?
No.
Okay. So you bought the house in 18. The David's bought in March of 20, right? Do you recall any, hey, we're your new neighbors, anything like that?
No.
What happened after well, let's strike that. In the year and a half between when y'all bought and the Davids bought, did y'all do anything to easement 2?
No.
No? They bought their house. What happened next?
Well, you know, when, like we've talked about, when you buy a new house, you make improvements. So we started with the yard. We had noticed that area, easement 2, was just a mess. I mean, all I remember thinking is there was just a huge pile. And it had debris and leaves and, you know, so Tracy said that he wanted to just clean it out, just make it look nicer. But that's all we did was just clean it out. Got rid of the railroad ties, got rid of the bottles, I remember there were plastic water bottles. So just, that was our discussion. For safety's sake, the light, we did put lighting in over that easement, but we also put it on the other end of our property. So we just did all that at once.
Landscape lighting, is that what it is?
Yes, landscape lighting.
Did y'all put the David's property under surveillance?
No.
After the Davids bought the property, what was your first interaction with either I keep saying Davids. What was your first interaction either with them or people coming and going to their property?
I just remember when they were moving in and there would be all the cars parked in front of our house and people would be just walking in our yard, cutting through, but not down by the easement, just up on our grass, by our garage.
On both sides of the garage or the far side?
Far side.
The far side of the garage?
Mm-hmm.
But the east.
Just a yes or no.
Oh, okay, okay,
Yeah, thank you. I should have told you.
okay.
Saw them coming and going on the far side of the garage, but the easement's on the far side of the garage, right?
Correct.
Did they go all the way down to the easement area and go way down through the easement and then up to David's backyard, or did they cross over your yard?
They crossed over our yard. They did not go by the easement at all.
Do you remember what the street frontage of the easement looked like at that time?
Just overgrown?
Was there any path where workers could get in and out?
No.
So with your own 2 eyes, you saw people using your own property?
Yes.
And did you personally ever attempt to complain to the Davids about that?
No.
Okay. Did the Davids ever come and knock on your door and say, hey, we're having construction. If it's a problem, let us know?
No.
There's an incident with the trash. Do you know anything about that on your personal knowledge?
Yes.
Tell us what you know.
That we could not get to our garbage
Why not?
because of the cars
Why? Because-
blocking our garbage cans. And personally, I just remember one piece of trash that we had, and my son-in-law at the time was at our house, and he's 6'9", and he could reach over. Like normally, I couldn't have reached over into the trash bin. And we asked him to put a table in the David's trash bin.
Okay. So it took somebody 6'9" to do it. It's not something
Yes.
that even Tracy or I could do.
Right.
Okay. And did you ever have any discussions with either of the Davids about putting trash in their dumpster?
No.
Do you know where the dumpster was at that time? And by that, I mean, was it on easement 1 in the parking pad, or was it somewhere else, or do you know?
I think it was on easement 1, if not further down the driveway, but I can't swear to it.
Okay. Did you ever personally have any interactions with either Mr. or Mrs. David before this lawsuit was filed?
Only Mr.
Tell us about that.
He came to our house one night and he knocked on the door and asked for Tracy. Tracy was out of town and he said, okay. So he kind of turned and then he said, oh, you can't have anybody live over your garage. And I just went, I kind of was dumbfounded. I just, okay. And I shut the door. I thought, I don't even know how to respond to that.
Did he try to give any explanation?
Nope,
Did he knock on the door again and say, you don't understand?
no,
Were y'all having work done above the garage at that time?
not really. We just cleaned it out. It's studded for, plumbing and all that, but nothing has been done. We had just cleaned trash out of there. That's all.
Okay. And he didn't like you doing that?
I guess not. I
Uh,
understand.
Did you get a lawyer letter from somebody saying, hey, you don't have a right to do this? Knock it off? Okay. What about the trash? Did you get a lawyer letter about the trash saying, hey, knock this off?
No,
Stop. But you got a lawyer letter in February of 21, February 26th. It's written, I think it was delivered on the 27th. Does that sound about right?
I don't know what you're talking about.
Okay, I'll move on.
Okay.
Were you present at the house the morning where the incident occurred with the landscaping and the sod and Mrs. David?
Yes.
Tell me what you saw first.
Okay. I didn't see anything going on when I was inside the house. I came down, was going to the garage to get in my car, and one of the workers came up to me and he looked horrified. His eyes were he did not speak English very well, but he said, we can't plant. She said, we can't plant. And I was like, what? Well, by that time, she was gone. Stacy was gone. But then I didn't do anything else. I was just going to call Tracy, and then he had talked to Jose,
Okay.
head of the landscapers, and he took care of it.
And then a little while later, there was this interaction between Tracy and Mrs. David.
Yes.
Were you present for that?
No.
You didn't see it or hear it?
No.
Okay. Let me ask you this. You heard my opening that she said that he had multiple marriages. How many wives has Tracy had?
One.
So he's had one successful marriage?
Yeah.
Okay. You mentioned earlier that he was out of town when Mr. David came and knocked on the door. Tracy traveled a lot?
He used to. He used to travel a lot more than he does now.
So back in this 2021 timeframe, how much was he traveling?
Almost every week.
Okay. Other than this one incident, to your knowledge, has Tracy had any interactions with Mrs. David?
Not that I know of.
And before the TPO was served by the sheriff, did anybody come knock on the door and say, hey, we need to talk about this? Can we just agree to keep our distance?
No, I wish.
Have you ever intentionally interfered with the David's rights to use easement 2, you personally?
No.
What do you want to come out of this lawsuit?
I just want what's fair. It's just a little embarrassing to me that we're all here doing this, to be honest. We don't want the easement in their driveway. Why would we want that? And easement 2 is on our property. Tracy's paid taxes. It's just silly to me that all this is going on. I guess that's pretty simplified, but If they want to walk through, we've offered to give them a path. What's wrong with that? You take your easement on number 1, easement 2, we'll make a path for you. Let us landscape it, make it look nice. You can see it from our house. I mean, I just don't understand.
Judge, I'm going to show this as witness. This has been marked as defendant's exhibit 14.
Okay, not in the binder?
That is that's my binder. I don't know if they've given you their binder.
No, right, so this is in your binder.
It is not in my binder.
Oh.
It's supposed to be in their binder.
Oh, okay.
That's defendant's exhibit 14. Claire, I'm going to share my iPad with you.
Okay.
It's showing you what the defense has marked as defendant's exhibit 14.
Oh, yeah, okay.
Have you ever seen that document before?
I saw this on Saturday.
How'd you get it?
I guess you sent it to me you sent it to me.
And did you go back and check your social media, your cell phone and other things to see if you had received that and missed it?
Yes, and
Could you find it?
I'm not real tech savvy. I even had my college, 1 year out of college, student daughter come down and help me look for it, and she couldn't find it.
So until Saturday, had you ever seen that document before?
No.
Thank Nothing further, Judge.
Do you have any questions?
No, Your Honor.
Okay. Ms. Stern?
Yes, thank you, Your Honor. Good morning, Mrs. Anderson.
Good morning.
We've met previously.
Yes.
Okay, good to see you again. Your husband, he's admitted he called Mrs. David a fat bitch, told her he hoped she was going to die.
Your question?
You heard that?
Yes,
And
but,
you're aware he said that?
but the end, what I've heard and what I understand from my husband is he hopes that, about dying, that he was going to die from being so,
She was gonna die because she's so fat.
yes,
Okay. So those are the kinds of
Not-
things that your husband says.
no,
He said it to Mrs.
said that,
David.
yes.
Look, this is gonna go poorly if you talk over each other. So, Ms. Stern, one, make sure you're posing a question. It can be a statement, but it needs to end with a question mark. And then make sure Ms. Anderson has finished answering before you move forcefully or not to your next question. Because our court reporter can take down only one voice at a time. So when Ms. Anderson is done, then you can go on to your next question.
Thank you, Judge.
Sure.
Ms. Anderson, you have an Instagram account, don't you?
Yes,
Okay. You're a painter.
yes.
Okay. What's your Instagram handle?
Well, I have a regular Instagram, then I have my art Instagram. It is, and I haven't posted on it in probably over a year. So, I think it's CH Anderson Art. I can't, to be honest, I can't even remember for sure.
That's the art Instagram?
Yes.
Personal one.
Art. But I maybe even a year and a half, I haven't used it.
Okay. So it's possible that if somebody messaged you at that account, you didn't see it.
Lately, but I did look at that account on Saturday when I was looking for that text. My daughter and I did look at that account and my regular.
Okay. Have you changed your Instagram account?
No,
Never.
no.
Okay. Let's talk about the purchase of your home.
Okay,
You purchased your home with your husband, correct?
yes,
Okay. And did you go out and look at the property prior to purchasing the home?
yes,
Did you walk easement too?
no,
You know Ann Nikirk, correct?
yes,
And you knew her before you bought the home?
yes.
Did you talk with Ann Nikirk about easement two prior to purchasing the home?
No,
When you purchased the property with your husband, you purchased the property subject to an easement agreement, correct?
Objection calls for legal conclusion.
When you bought the house, had someone told you that there were easements on the property?
I'm sure that they did, but not me personally. I don't remember a conversation about an easement, to
When
be
did you
honest.
first learn that there were easements on your property?
Kind of when all this came up,
Okay.
to be honest, yeah.
You didn't talk with the closing attorneys about easements on the property?
I'm sure we did, and that's just something that I didn't really zero in, to be honest. I mean, so I can't say.
When the Davids moved in, did you go over and introduce yourself to the Davids?
No, and I should have. I admit that. That was not nice.
When your husband called Mrs. David a fat bitch, did you go over and talk to Mrs. David?
No,
In fact, you never talked to Mrs. David about those statements.
no,
You talked about, were you ever actually on easement two before the Davids purchased it?
you mean
Before the Davids purchased their property?
physically walked in there? No,
So you had talked about, wait, I think you said was a huge pile
yes.
up there. Do you have any photographs of this huge pile you're talking about?
Mm-mm.
You see, yes or?
No, I'm sorry. Thanks.
How we talk.
Okay.
You have 9 security cameras on your property, is that correct?
I don't know about the total number.
Are you aware of security cameras on your
Yes,
property?
yes.
Are you aware of?
It's part of our
So
alarm.
you need to wait till Ms. Sturm is done with her question. You are anticipating the answers just fine, but she needs to finish her question, either because she throws you a curveball and says opposite of, but you can't talk over each other. So let her finish and then you'll get all the time you need to answer.
Thank you, Judge. Are you aware of how many security cameras are on your garage area?
I think either 1 or 2.
But it surprised you to learn that there's 4.
But I don't know. It's all tied into the alarm system.
Do you have any photographs from your security cameras on this garage that show any of these workers you were talking about or Mrs. David interacting with any workers on your property?
No,
Did you ever contact the Davids about clearing easement 2?
no,
Did you ever contact the Davids about putting lighting up in easement 2?
no,
Did you ever contact the Davids about installing a sprinkler system that encroaches on easement 2?
no,
The trash in the dumpster, if I heard you correctly, you testified that you asked your son-in-law to put it in the dumpster.
yes.
Okay. And you don't recall where the dumpster was located?
The general area.
Is it possible it was sitting on the David's driveway close to their garage?
Well, yes, that's that area I was talking about in the driveway.
And isn't it true that the trash that went in the dumpster was prior to any workers coming to the David property?
I don't think so. I don't think that that's true, but I can't say for sure.
You don't know?
I don't know.
Okay. Mrs. Anderson, you never approached the Davids and asked them if they would sell or release their interest in easement to you and Mr. Anderson.
No,
Did you ask Mrs. Nikirk if she would approach the Davids about selling their interest in easement too?
no,
You didn't? And after purchasing your home, did you ever approach the prior owners of the David property, the Darbys? Did you approach the Darbys about their use of easement too?
no,
You didn't ask the Darbys if you could clear easement too?
no,
Okay, and you didn't ask the Darbys if it was okay to put lights in easement too?
no,
And you didn't ask the Darbys if you could put a sprinkler, install sod, or do any of that on easement too?
no,
Did you ask the Darbys if you could fence off or block easement too?
no. I've never seen the Darbys. I don't know them.
Did you ever make any effort to reach out or contact them as your neighbors?
No, but they didn't live there when we were there.
You don't believe they live there
No,
at all?
I've never saw anybody in that house before.
You didn't see anybody in the house?
No,
Did you? Did you ever? You talked about an interaction, strike that earlier statement. You talked about an interaction with Mr. David where he knocked on the door.
yes,
Is it possible that you're misremembering the communication with him?
absolutely not.
Okay. Is it possible that you interacted with him some other time?
About that? About the garage, you mean? Or
Just-
just anytime?
Just about, did he ever knock on the door and say, hi, I'm your neighbor?
He knocked on the door and Tracy talked to him. I heard them talking and he mentioned the trash in the dumpster and Tracy said, well, we couldn't get to our trash cans because of the cars. And he was very nice. He apologized and said, I understand. I heard that. I wasn't standing up at the door. I was kind of behind Tracy when that conversation went on, but that wasn't directly with me. That was between Tracy and him.
So those are the two times that that you know of, that Mr.
Yes.
David has knocked at your door.
Yes.
Once your husband interacted with him, you were partially in earshot, and the other time, you were the only one home, and that was hey,
Correct.
no one up in your garage.
Yes,
During any of the time, we heard you talk about what you want or how you would like this to resolve. At any point in time, have you gone over neighbor to neighbor and talked to Mrs. David about what you want?
no,
At any point in time, have you gone over neighbor to neighbor and talked with Mr. David about what you want?
no,
Are you aware of comments? Well, easement one, you're familiar with easement one?
yes,
Okay, and you agree that's the parking area on the David property?
yes,
Okay. Are you aware of comments by your husband about uses of easement one?
no. But us using easement one? No,
Do you have any uses you would like to make of easement one?
no,
Are you aware of comments that, oh, well, we could go play basketball on
Your Honor,
easement?
object. We need to approach.
Question, are you aware of comments over?
Oh, I'm sorry, Mr. Williams, I didn't mean you, thank you.
Oh, I'm sorry.
Real time, I'm directing Ms. Sturm to say, all right, I'm gonna do a little reset here, and here's my question. She may want to move on, she may want to stay where she was. Free to do mine.
Do you think an appropriate use for easement one would be for you and your family to play basketball on it?
No,
Okay. Do you think an appropriate use for easement one would be for you and your family to have a barbecue on it?
Your Honor, objection, we're talking about speculation as to what we can and cannot do. Obviously, we can do anything on that easement as long as it doesn't interfere with what the Davids are doing. So all these questions are great, but if this is the path we're going down, we'll be here for days.
Well, let's not be here for days. You can ask a couple more of those questions.
Thank you. Do you think an appropriate use for easement, for the use of easement one would be for a hockey game?
no,
With regard to easement two, and let me grab one thing. I'm gonna strike that for now, so I don't take up other people's time, but, Mrs. Anderson, in talking about what you would like to accomplish here, is it your belief, that the Davids cannot use easement two?
no,
Thank you. No further questions.
Any redirect?
Do you have anything? Yes, sir, just a few. I didn't ask you this. I showed pictures of nets and ribbons and stuff like that in my opening. Are those visible from your house?
yes,
How often do you see those?
every day,
All day?
all day.
Did you see any use, did they have those nets and ribbons and everything up there before the fat bitch incident? I mean, Miss Stern asks that question all the time.
No,
Did they have nets and ribbons and chairs and all
No.
that stuff before that?
no,
That was not until after the lawsuit was filed.
right,
Okay. Do you like seeing those every day?
no,
You want them gone?
yes,
She asked you questions about whether y'all asked the Davids before doing this, that, and the other. Obviously, the Davids came over and knocked on the door and said, hey, we're getting ready to put these nets up. Do you mind? Obviously, that happened, right?
that did not happen.
Really? Why not? But never mind, that'd be speculation. The Darbys lived there, so well, strike that. The Darbys owned that house for 1.5 years before the Davids did while y'all lived there, right?
Yes,
Did you see any signs of life whatsoever from that house?
no,
Any lights on at night?
no,
How far is the driveway from your dining room?
Which driveway?
The driveway to the Davids' house? Approximately.
very good. It's really close.
From me to you?
Yes, about, yeah,
Okay. Got big windows in the dining room like
Yes.
for most people? Can you see people coming and going in that driveway?
yes,
In the 1.5 years that you lived there, did you ever see one single car come and go out of that driveway while the Darbys owned it?
no,
Did the Darbys ever complain to you guys about, we have exclusive rights to easement 2, you can't do anything, period?
no.
Ms. Anderson, a few more questions, and then if the lawyers have any follow-up, they will undoubtedly follow up. When you first started answering questions from Mr. Edwards, you shared with the jury an anecdote about your daughter as a teacher and some students that she taught. You mentioned that they were poor, economically disadvantaged. You didn't indicate white, black, Hispanic, Native American.
They were black. The whole school it's black.
Okay.
Yeah.
You referred to, or at least were asked about some landscape lighting that was
Okay.
installed on easement 2 or near easement 2?
It's way up in the trees down on easement 2.
Okay, is the tree in which the light is installed on easement 2 or on what we'll call Anderson property? If you know.
I don't know.
Okay,
I think it's on the easement, but I'm not sure. I
Okay.
think it's that far back.
And do you know if the lighting was installed up in that tree before the Davids moved in or after they moved in? And not knowing is okay. You don't look pained. It's
I know.
for you to remember.
I don't know.
Okay. Do you know who, if anyone, is responsible for maintaining easement two? And who, I don't mean you versus your husband, but is it an Anderson responsibility to maintain easement two? Is it a David responsibility, or how do you think about that? If
We have maintained it up into this point, so I guess it's our responsibility.
at least you have assumed that it's your role to do that.
Yes.
Okay. All right. Do you have any follow-up based on those questions?
I don't have a follow-up, but I have one question that I forgot.
All right, Ms. Sturm, any objection? You get to follow up if you want to, a question Mr. Edwards forgot.
To both the questions and what Mr.
No. I wanted, Mr. Edwards remembered something he meant to ask Ms. Anderson. Really, we've closed that. I don't mind reopening it. I just want to give you the chance to object, saying, no, he actually did direct and redirect, so he may not ask her another question.
I believe that's the case. We've done direct and redirect.
Okay. What's one question?
Yes, sir.
Ask you one question.
In the couple of years that those nets have been in your yard, can you give the jury an approximate number of times that you have seen any children or other people out there actually playing with the nets?
A handful.
I was allowed one question.
Ms. Sturm, you can follow up on that question if you want, or any of the questions to which Ms. Anderson provided answers in the jury.
Ms. Anderson, just to be clear, you didn't do anything on easement two, no maintenance, nothing between the time you purchased the property in September of 2018 and the time the Davids moved in 2020.
I don't remember when we had it cleaned up. I don't know if they were living there or not, to be honest.
Isn't it true you don't actually know when anything occurred on easement two, or when people have been on easement two, or when equipment has been on easement two?
No, I do. Some things I know, but I don't know exact dates. I mean, I don't remember. I don't remember when we had it cleaned up. We just thought it was a nice idea to make it look better. And no idea that that would offend anyone.
But you didn't ask anyone about it.
No.
Okay, thank you.
The cleanup work that happened, I know you're not pinning a specific
Okay.
date on it, that's okay. But can you place cleanup time pre-Davids, post-Davids?
I guess it was after they had moved in, just because of all the issues that have come up.
Okay, thank you. I appreciate your testimony.
Okay.
You are free to step down.
Okay.
Mr. Edwards, call your next witness, please.
We're gonna call Daniel Venable. He is out in the lobby. He was subpoenaed.
Okay,
Want me to go to him?
you should, someone on your team should get him.
Okay.
Just to manage Mr. Venable's expectations, we're gonna go for about 8 minutes with the witness, then we have to break for lunch, because I gotta get to my office and turn on a Zoom to do my lunch meeting. So
Certainly.
he may get interrupted, and we'll do part one, pre-food for some people, and part two after we reconvene.
Sounds good. Thank you so much.
Sure. That may open things up for you. We'll see how it goes.
Can you state and spell your name for the record?
I'm sorry, is that for me?
Yes, sir.
Okay, my name is Daniel Venable.
Are you employed?
Yes,
All right. Who are you employed with? Spell, oh, I'm sorry. I thought he was asked to state his name. I apologize. I'm sorry.
sure, it's Daniel Venable, spelled Daniel. Last name is Venable.
Are you employed?
Yes,
Who are you employed with?
On Point Surveying and Mapping,
Okay.
and surveying and mapping.
And can you describe what your job is?
I'm a licensed land surveyor. We map out properties and commercial, residential, and do, plats and maps of those properties.
Okay, and are you, did you say you're registered?
I am.
Okay. Will you describe your job duties?
I work in both the field and the office. The field, I'm more of a, I guess like a project manager. I oversee the field crews. And then the office, I prepare proposals and review the plats and maps that our CAD technicians provide.
Okay. And how long have you worked there?
Since 2016, so 8 years. Yep.
Have you ever been out to 3350 West Andrews Drive in Atlanta, Georgia?
I have.
All right. Do you know who lives there?
I believe it's the Anderson residence.
Okay. And do you remember when you first went out to that property?
I do.
When was that?
I want to say, well, I guess I do. It's April 2020, I think was the date. I can look, it's on my plat, the field date, but
Okay. And
it's been a while. Yeah.
the plat on this screen?
Don't
Or
put
the
anything on
survey
screen until it's
says.
Been admitted.
Oh, okay. Yes. Well, let me, before it is that. Did you bring a copy of your survey
I
with
sure
you?
did.
Okay. And I believe it's a rather large survey, isn't it?
Yes.
Okay, we have a smaller copy. I'll show to the other side. Okay.
Your Honor, just a logistics, I'm assuming that it shouldn't be published yet to the jury until it's.
I said,
I apologize.
okay, nothing should go up on a screen until it's in evidence. I don't think there's anything that's gonna be admitted that can't also be published, so no one needs to ask about publishing. There are no autopsy photos or anything, so, once it's admitted, feel free to publish. If it's already been admitted, publish whenever you want, republish, but until it's admitted, jury shouldn't be looking at it.
All right. We'll take a look at that.
Sure.
Do you see the document I've handed you?
Yes,
Do you recognize what that is?
I do.
And what was the document I handed you?
It was the drawing or the plat that we provided the client after we performed the survey.
And is that what you brought? Is that a smaller copy of what you brought with you today?
That's correct. The size, the copy that I brought is a scaled copy, so it's the exact scale of the drawing, not reduced or anything. So
All right, and I would move to tender that as plaintiff's two.
And you're tendering the reduced size version, or we're gonna be taking from Mr. Venable, the big one?
Is that a copy that's available to stay here?
absolutely.
Okay, we'll take the large.
Okay.
When
So
is-
you make sure you label it, because that's something that'll go with the court reporter ultimately, but we'll go back with the jury, if it goes back with the jury. But, any objection to admission of plaintiffs two?
Not necessarily, but we have not had an opportunity to compare the two.
Okay, assuming what you've got in the micro version is the same as the large version, plaintiffs two is admitted.
Okay, thank you. Okay, and looking at the copy of your survey, can you just describe like what this is?
So it's basically a boundary, topographic and tree survey, which the boundary shows the property lines and the dimensions around the property. The topography shows the elevations of the property, and then the trees, we identified all of the trees that were 6 inches in diameter and larger, and showed those on the map.
Okay, and that was for the was that for the entire property?
Correct.
Okay, and it looks like that the easements are included on this, is that correct?
That's correct.
Okay, so you also have the ability, or would you have the ability by looking at this to describe how many trees are on easement two?
I would.
Okay, and so does the survey identify what date you went out there to go do it?
It does.
And what date is that?
I'll have to look if that's okay.
Sure, absolutely.
Okay, if you look at, under the survey notes, is item number 5, it says last date of field work performed on last date of field work. It says performed, go back to find it, on 04/02/2020.
Okay, thank you so much. And okay. Do you know, can you tell how many trees you identified on easement two?
Sure.
For the less educated viewing public, are the easements the two gray areas?
That's correct, yes.
And easement two is the smaller or the larger of the gray areas?
Looks like it's the larger of the two to the far right of the page.
Okay.
Uh-huh. So it looks like there were 1, 2, 3, 4, 5 trees that were all the way on the property, and then there was one that looks like it's right on the property line. That would be tree number 12, it looks like.
Okay, and so if my math is right, that's about 6.
Correct.
Okay. And can you, does the survey include the dimensions of the trees?
It does. Well, it gives the size of the diameter of them.
And what, the diameter of what?
So that's gonna be if you take what we call a tree measurement tape, and that's at your breast height, so you wrap the tape around the tree, and it gives the dimension of that tree,
Okay.
whatever you read on the tape. So,
Okay, thank you. And can you describe the 6 trees that are on easement 2?
sure, looks like it's gonna be tree 14, 15, 16, 19, and 20. 14 is a 9, so it's a double tree. It's got 2, I guess, trunks coming up. It's a 9 and a 24-inch hardwood. Tree 15 is a 26-inch pine. Tree 16 is a 13 and 32-inch hardwood. Tree 19 is a 27-inch hardwood. And tree 20 is an evergreen, 6-inch evergreen screening. And then the one that was on the property line looks like tree 12, that was a 24-inch pine.
Okay. And do you remember when you were first contacted to do this survey?
Vaguely, it's been a while.
What's your recollection?
Basically, we either through phone calls or emails, most of the time we'll prepare a proposal for the client, they'll sign it, send it back, and that's basically our notice to proceed for the work.
Okay, and do you remember when you were first approached to do the survey?
I don't.
Okay.
I don't know why you're showing me.
Okay. Can you take a look at this for a minute?
Sure.
And let me know when you're done.
Okay.
Thank you so much. Did you have an opportunity to review that?
I did not.
This?
Oh, just now, yes,
Yes.
yes. I thought you meant before I got here. Gotcha.
No, I'm sorry. That's my
No.
fault. That was confusing.
No.
Okay. And did that refresh your memory on when y'all were first contacted about the survey?
Yes.
And when was that?
Well, I'll have to take another. Oh, I didn't take a date. I was just reading the thing. I'm sorry.
Didn't ask you to memorize.
So looks like on March 3rd, 2020.
Thank you so much.
Sorry about that.
Okay, you are all good. Did you ever go back to the Anderson property at 5530 West Andrews?
We did.
Okay,
Right. Yes.
when'd you go back?
It was a couple of years later. I was contacted by a gentleman, Robert Jenkins, I believe is his name. And he was asking me to fill out an affidavit.
Okay, and did you actually go back to the property?
I did. I met him on the site.
Okay,
I met him out there on the site. Yes, sir.
and did you have an opportunity to look at easement 2 on that date?
We did. We went around the property and reviewed each of the trees that were in question.
Okay, and do you remember the date that you went back out there?
I don't remember the exact date.
Okay. I believe you said it was a couple years later?
Correct.
Okay.
Yeah.
Do you recall when you went back out there a couple years later, were all the trees still there?
Yes.
They were?
Mhm.
Okay. Thank you so much. I have no further questions for you.
Right, this is where we're gonna break. Unfortunately, for you, Mr. Venable, you're gonna get lunch downtown.
Okay.
Eat lunch, but we need to break now. It is at multiple clocks here. I'm gonna go by the phone clock. It's 12:25. Let's try to be back by 1:30, jurors, 1:30. So don't walk more than 30 minutes in one direction because you want to be back in an hour. You're free to eat wherever. You don't have to eat at all. It's fine to eat as a group or subgroups. Just don't talk about the case. No outside research. Don't look up what a 24-inch hardwood means. If you've got questions about that, here's your man. You can ask him after lunch. So let's all try to be back by 1:30. Any logistical questions? Seeing none, we'll see you in about an hour.
All right, sir.
And counsel, I'll take up any issues you all may have when I get back from my meeting. So let's be back at 1:45. Good, thank you.
Oh, Mr. Venable,
We're supposed to come.
wait.
Oh, I'm sorry.
We don't want you to actually end up with the jury.
Okay, yeah.
Yeah,
Oh, God.
sheriff will send you back there.
I think that he can exit the courtroom now, right? Or Venable?
Yeah.
Okay, yeah. Did he say what time he wants us to be back?
Do I need to re-swear in?
You remain sworn.
Okay.
So be truthful.
I will.
Good afternoon, Mr. Venable.
Hello.
Judge, may I approach the witness?
Yes, so all the attorneys have a continuing authority to approach witnesses to hand things, not to stand right in front of them while you yell questions at them, but you can always go back and forth to drop things off.
I understand that's your.
Thank you. Thank you.
Okay,
I have a
good.
question for you, Ms. Stern. You had a chance, it sounds like, over the break to look at the big survey. Are you comfortable that the big survey can be plaintiff's exhibit 2, or you didn't look at it at that level of detail?
I actually didn't look at it at all. Counsel just brought it to my attention that was here, but I will take a look at it shortly after. Okay. Good afternoon, Mr. Venable. My name is Casey Sturm, along with my colleague Jeff Schneider. We represent the Davids. I don't believe I've had the pleasure to meet you previously.
Right.
Okay.
Nice to meet you.
Nice to meet you as well. And I understand you're a land surveyor.
Correct.
Okay, and you're not an arborist.
No.
Okay. And I understand that you went out to the Anderson property.
Correct.
Okay. And you did a boundary, topographic, and tree survey for the Anderson residence
That's correct.
on April 6th,
Yes,
2020.
correct.
Okay. And if we pull up, I believe it was Defendant's Exhibit 2. That showing up. That's a copy of your survey.
Okay.
Is that correct?
Yes.
Okay. And I believe if you need to is it showing on your
On mine,
screen?
it's not
too?
showing on mine, but, it says something about stay muted or unmute.
Oh, you should click stay muted.
Okay.
And then what's that one say?
Got it or leave meeting.
It says what?
Says got it or leave. It's talking about a third party or
Oh,
something.
just say got it.
Okay.
Don't leave the meeting.
Okay, now I can see
Excellent.
it. Perfect.
Okay, now you
All
can
right.
see it. Okay, good. Okay, and your land survey, your scope of work for this project, if I understood you correctly, it was to identify trees on the entire property,
Correct.
okay? 6 inches DBH or greater.
That's correct.
Okay, and DBH again?
It's the diameter at your breast height. Yes,
So your survey would not pick up anything under 6 inches DBH, whether it was trees, shrubs, brush, what have you.
correct.
And am I correct in understanding that the survey is based on a site visit on April 2nd, 2020?
That's correct. Yes,
Okay. And did you perform that site visit yourself?
I did.
Okay. On your survey, well, let me ask you this.
Uh-huh.
Did you walk the entire property during that survey?
I did. Mhm.
Okay. You walked to easement area 2?
Yes, because inside the easement areas, I also had to identify the trees, so I would have been all in the area as well.
Okay.
And locating the property corners and that and such. So,
Oh, okay. And you walked through the woods to do that?
yes, ma'am.
Okay. Easement 2 had not been cleared.
From my recollection, it was, it was trees and maybe some tall grass and stuff like, maybe a few briars, but, typical for wooded areas out in that area, so.
And you were able to walk through, no problem?
Yeah, I mean, I would have to, there were a couple areas I would have to, I carry a machete, so I have to chop. If there's vines or stuff in the way, then I have to clear it. But I don't recall having to do too much clearing out there.
Okay. Do you have any photographs from your site survey?
Typically are photos that we take are of the house and the driveway and stuff like improvements. I usually don't take photos of the actual, the tree areas.
So you don't take photos of any of the trees that you
Correct.
identify?
Correct.
And on your survey, if we look down in the lower left corner, there's some notes. Is that correct?
Yes.
In the very bottom note, what does that note? That say?
Yeah. Do you mind if I look at it on mine? I'm having a little trouble seeing it on the screen.
I'm fine with that. Just for your benefit, I understand I may be wrong that it blows up. Is that correct on his?
I can kind of see it. I mean, I'll have to
But you
look real
can,
close.
I don't think he can magnify. He can circle something. You would need to magnify. His screen simply shares what's on your screen, but then he can use his finger as a.
Oh, that's better. There you go. That's a lot better.
okay,
Okay.
thank you.
I'll just go ahead and read the note. Tree type label shown here on as requested by the client's design team and needs to be verified by the proper professional prior to planning or construction. On point survey and assumes no liability as to the accuracy of these labels.
You said on point.
On point surveying, yeah, yes. And so basic.
I need you to.
I'm sorry,
The
yeah.
court reporter didn't catch all that. Start with.
Yes.
on-point
Okay,
surveying.
I'm sorry. Yeah, on point surveying assumes no liability as to the accuracy of these labels.
Thank you. Let me hand you photograph. Let me ask you if you recognize the image in that photograph.
I do not recall that image, but I've probably done 300 tree surveys since then, so they all kind of run together after a while.
Okay. Do you recognize any of that as easement area 2 on the Anderson property?
I don't recall that.
Okay.
So,
Thank you very much. Now, your survey, let me see if I can get it to zoom back out. Okay. It shows 2 easement areas, is that correct?
yes,
And those easement areas are highlighted in gray.
that's correct.
Okay. And those easement areas, were they identified using the Anderson's deed and plat?
That is correct as well.
Okay. And if I look, I'm going to try to zoom in over here on easement area 4.
Okay.
Sorry.
You mean two?
I'm sorry, 2.
Yep.
Sorry.
No, it's okay.
I was thinking Blair Witch in my mind as I'm trying to enlarge this, and everybody's probably like, please stop. On easement area 4, am I on easement area 2? Sorry, Judge. Am I correct on the corners? Tell me what we see there.
So on 3 of those corners, you see, well, let's start on if you're looking at the screen, the top left, you see a little circle that has a leader to it that's identified as a 1/2-inch rebar found. So that was a found monument that we found on the site. And then if you go down the 60 feet to the right, you'll see a 1/4-inch rebar found. And then go down the 53.27 feet, you'll see a 1-inch rebar found. The other corner was not found, so it was actually, it's just a calculated point that's shown there.
Okay. And these found areas, you were able to find those in the field?
Yes, ma'am.
I don't have any further questions for you.
Does 1-inch rebar mean like that was a 1-inch diameter?
Diameter, yes, sir. Yes, sir.
Okay. Thank you, Ms. Stern. Any redirect or anything else from the Anderson side?
Very briefly, Your Honor. Mr. Venable, you were asked to read a note just a minute ago that said tree type labels.
Mhm.
Does that mean labeling what type of tree it is?
So a lot of surveyors will do it differently, the way they identify the tree. Some will actually identify, for instance, let's say it was a dogwood tree. They'll actually specify dogwood or maple or that. Because she asked me a question if we were arborists, we're not. So we put them in 2 classifications, basically hardwood or pine. I think we showed some evergreen screenings, which are like little holly bushes, but that's our way of like limiting our liability on the trees.
And that would be if there was a dispute as to what exact type
Right,
of
if
tree
it
that
was a
was.
maple or an oak or what, so, yeah.
Thank you so much. No more questions.
Anything else, Ms. Stern?
No.
Any questions from the jurors for Mr. Venable? That may open things up for you. We'll see how it goes.
Can you state and spell your name for the record?
I'm sorry, is that for me?
Yes, sir.
Okay, my name is Daniel Venable.
Are you employed?
Yes,
All right. Who are you employed with? Spell, I'm sorry. I thought he was asked to state his name. I apologize. I'm sorry.
sure, it's Daniel Venable, spelled Daniel. Last name is Venable.
Are you employed?
Yes,
Who are you employed with?
On Point Surveying and Mapping.
Okay.
And surveying and mapping.
And can you describe what your job is?
I'm a licensed land surveyor. We map out properties and commercial, residential, and do, plats and maps of those properties.
Okay. And did you say you're registered?
I am.
Okay. Will you describe your job duties?
I work in both the field and the office. The field, I'm more of I guess like a project manager. I oversee the field crews, and then the office, I prepare proposals and review the plats and maps that our CAD technicians provide.
Okay. And how long have you worked there?
Since 2016, so 8 years. Yeah.
Have you ever been out to 3350 West Andrews Drive in Atlanta, Georgia?
I have.
All right. Do you know who lives there?
I believe it's the Anderson residence.
Okay. And do you remember when you first went out to that property?
I do.
When was that?
I want to say, well, I guess I do. It's April 2020, I think was the date. I can look, it's on my plat, the field date, but
Okay. And
it's been a while. Yeah.
the plat on this one?
Don't
Or
put
the-
anything
or
on
the
your screen until
survey
it's
says-
Been admitted.
Oh, okay. Yes. Well, let me, where it is that? Did you bring a copy of your survey
I
with
sure
you?
did.
Okay. And I believe it's a rather large survey, isn't it?
Yes.
Okay, we have a smaller copy. I'll show to the other side. Okay.
Your Honor, just a logistics, I'm assuming that it shouldn't be published yet to the jury until it's.
I said,
I apologize.
okay, nothing should go up on a screen until it's in evidence. I don't think there's anything that's gonna be admitted that can't also be published, so no one needs to ask about publishing. There are no autopsy photos or anything, so, once it's admitted, feel free to publish. If it's already been admitted, publish whenever you want, republish, but until it's admitted, jury shouldn't be looking at it.
All right.
We'll take a look at that.
Sure.
Do you see the document I've handed you?
Yes,
Do you recognize what that is?
I do.
And what was the document I handed you?
It was the drawing or the plat that we provided the client after we performed the survey.
And is that what you brought? Is that a smaller copy of what you brought with you today?
That's correct. The size, the copy that I brought is a scaled copy, so it's the exact scale of the drawing, not reduced or anything, so.
All right, and I would move to tender that as plaintiffs two.
And you're tendering the reduced size version, or we're gonna be taking from Mr. Venable, the big one?
Is that a copy that's available to stay here?
Absolutely.
Okay, we'll take the large.
Okay,
When
so
is-
you make sure you label it, because that's something that'll go with the court reporter ultimately, but we'll go back with the jury, if it goes back with the jury, but, any objection to admission of plaintiffs two?
Not necessarily, but we have not had an opportunity to compare the two.
Okay, assuming what you've got in the micro version is the same as the large version, plaintiffs two is admitted.
Okay, thank you. Okay, and looking at the copy of your survey, can you just describe like what this is?
So it's basically a boundary, topographic and tree survey, which the boundary shows the property lines and the dimensions around the property. The topography shows the elevations of the property, and then the trees, we identified all of the trees that were 6 inches in diameter and larger, and showed those on the map.
Okay, and that was for the was that for the entire property?
Correct.
Okay, and it looks like that the easements are included on this, is that correct?
That's correct.
Okay, so you also have the ability, or would you have the ability by looking at this to describe how many trees are on easement two?
I would.
Okay, and so does the survey identify what date you went out there to go do it?
It does.
And what date is that?
I'll have to look if that's okay.
Sure, absolutely.
Okay, if you look at, under the survey notes, is item number 5, it says last date of field work performed on for, last date of field work. It says performed, go back to find it, on 04/02/2020.
Okay. Thank you so much. And okay. Do you know, can you tell how many trees you identified on easement 2?
Sure.
For the less educated viewing public, are the easements the 2 gray areas?
That's correct, yes.
And easement 2 is the smaller or the larger of the gray areas?
Looks like it's the larger of the 2 to the far right of the page.
Okay.
Uh-huh. So it looks like there were 1, 2, 3, 4, 5 trees that were all the way on the property, and then there was one that looks like it's right on the property line. That would be tree number 12, it looks like.
Okay. And so if my math is right, that's about 6.
Correct.
Okay. And can you, does the survey include the dimensions of the trees?
It does. Well, it gives the size of the diameter of them.
And what, the diameter of what?
So that's gonna be if you take what we call a tree measurement tape, and that's at your breast height, so you wrap the tape around the tree, and it gives the dimension of that tree,
Okay.
whatever you read on the tape. So,
Okay, thank you. And can you describe the 6 trees that are on easement 2?
sure, looks like it's gonna be tree 14, 15, 16, 19, and 20. 14 is a 9, so it's a double tree. It's got 2, I guess, trunks coming up. It's a 9 and a 24-inch hardwood. Tree 15 is a 26-inch pine. Tree 16 is a 13 and 32-inch hardwood. Tree 19 is a 27-inch hardwood. And tree 20 is an evergreen, 6-inch evergreen screening. And then the one that was on the property line looks like tree 12, that was a 24-inch pine.
Okay. And do you remember when you were first contacted to do this survey?
Vaguely, it's been a while.
What's your recollection?
Basically, we either through phone calls or emails, most of the time we'll prepare a proposal for the client, they'll sign it, send it back, and that's basically our notice to proceed for the work.
Okay, and do you remember when you were first approached to do the survey?
I don't.
Okay.
I don't know why you're showing me.
Okay. Can you take a look at this for a minute?
Sure.
And let me know when you're done.
Okay.
Thank you so much. Did you have an opportunity to review that?
I did not.
This?
Oh, just now, yes,
Yes.
yes. I thought you meant before I got here.
No, I'm sorry. That's my fault. That was confusing.
No.
Okay. And did that refresh your memory on when y'all were first contacted about the survey?
Yes.
And when was that?
Well, I'll have to take another. Oh, I didn't take a date. I was just reading the thing. I'm sorry.
Didn't ask you to memorize.
So looks like on March 3rd, 2020.
Thank you so much.
Sorry about that.
Okay, you are all good. Did you ever go back to the Anderson property at 5530 West Andrews?
We did.
Okay,
Right. Yes.
when'd you go back?
It was a couple of years later. I was contacted by a gentleman, Robert Jenkins, I believe is his name. And he was asking me to fill out an affidavit.
Okay, and did you actually go back to the property?
I did. I met him on the site.
Okay,
I met him out there on the site. Yes, sir.
and did you have an opportunity to look at easement 2 on that date?
We did. We went around the property and reviewed each of the trees that were in question.
Okay, and do you remember the date that you went back out there?
I don't remember the exact date.
Okay. I believe you said it was a couple years later?
Correct.
Okay. Do you recall when you went back out there a couple years later, were all the trees still there?
Yes.
They were?
Mhm.
Okay. Thank you so much. I have no further questions for you.
Right. This is where we're gonna break. Unfortunately, for you, Mr. Venable, you're gonna get lunch downtown.
Okay.
Eat lunch, but we need to break now. It is at multiple clocks here. I'm gonna go by the phone clock. It's 12:25. Let's try to be back by 1:30, jurors, 1:30. So don't walk more than 30 minutes in one direction because you want to be back in an hour. You're free to eat wherever. You don't have to eat at all. It's fine to eat as a group or subgroups. Just don't talk about the case. No outside research. Don't look up what a 24-inch hardwood means. If you've got questions about that, here's your man. You can ask him after lunch. So let's all try to be back by 1:30. Any logistical questions? Seeing none, we'll see you in about an hour.
All right, observe.
And counsel, I'll take up any issues you all may have when I get back from my meeting. So let's be back at 1:45. Good, thank you.
Oh, Mr. Venable,
We're supposed to come.
wait.
Oh, I'm sorry.
We don't want you to actually end
fine.
up with the jury.
Okay, yeah.
Yeah,
Oh, God.
sheriff will send you back there.
I think that he can exit the courtroom now, right? Or Venable?
Yeah.
Okay, yeah. Did he say what time he wants us to be back?
Do I need to re-swear in?
You remain sworn.
Okay.
So be truthful.
I will.
Good afternoon, Mr. Venable.
Hello.
Judge, may I approach the witness?
Yes, so all the attorneys have a continuing authority to approach witnesses to hand things, not to stand right in front of them while you yell questions at them, but you can always go back and forth to drop things off.
I understand that's your.
Thank you. Thank you.
Okay,
I have a
good.
question for you, Ms. Stern. You had a chance, it sounds like, over the break to look at the big survey. Are you comfortable that the big survey can be plaintiff's exhibit 2, or you didn't look at it at that level of detail?
I actually didn't look at it all. Counsel just brought it to my attention that was here, but I will take a look at it shortly after. Okay. Good afternoon, Mr. Venable. My name is Casey Sturm, along with my colleague Jeff Schneider. We represent the Davids. I don't believe I've had the pleasure to meet you previously.
Right.
Okay.
Nice to meet you.
Nice to meet you as well. And I understand you're a land surveyor.
Correct.
Okay. And you're not an arborist.
No.
Okay. And I understand that you went out to the Anderson property.
Correct.
Okay. And you did a
boundary, topographic, and tree survey for the Anderson residence
That's correct.
on April 6th,
Yes,
2020.
correct.
Okay. And if we pull up, I believe it was Defendant's Exhibit 2. That showing up. That's a copy of your survey.
Okay.
Is that correct?
Yes.
Okay. And I believe if you need to is it showing on your
On my,
screen?
it's not
too?
showing on mine, but, it says something about stay muted or unmute.
Oh, you should click stay muted.
Okay.
And then what's that one say?
Got it or leave meeting.
It says what?
Says got it or leave. It's talking about a third party or
Oh,
something.
just say got it.
Okay.
Don't leave the meeting.
Okay, now I can see
Excellent.
it. Perfect.
Okay, now you can see it. Okay, good. Okay, and your land survey, your scope of work for this project, if I understood you correctly, it was to identify trees on the entire property,
Correct.
okay? 6 inches DBH or greater.
That's correct.
Okay, and DBH again?
It's the diameter at your breast height. Yes,
So your survey would not pick up anything under 6 inches DBH, whether it was trees, shrubs, brush, what have you.
correct.
And am I correct in understanding that the survey is based on a site visit on April 2nd, 2020?
That's correct. Yes,
Okay. And did you perform that site visit yourself?
I did.
Okay. On your survey, well, let me ask you this.
Uh-huh.
Did you walk the entire property during that survey?
I did. Mhm.
Okay. You walked to easement area 2?
Yes, because in the side of the easement areas, I also had to identify the trees, so I would have been all in that area as well.
Okay.
And locating the property corners and that and such. So,
Oh, okay. And you walked through the woods to do that?
yes, ma'am.
Okay. Easement 2 had not been cleared.
From my recollection, it was, it was trees and maybe some tall grass and stuff like, maybe a few briars, but, typical for wooded areas out in that area, so.
And you were able to walk through no problem?
Yeah, I mean, I would have to, there were a couple areas I would have to, I carry a machete, so I have to chop. If there's vines or stuff in the way, then I have to clear it, but I don't recall having to do too much clearing out there.
Okay. Do you have any photographs from your site survey?
Typically are photos that we take are of the house and the driveway and stuff like improvements. I usually don't take photos of the actual, the tree areas.
So you don't take photos of any of the trees that you
Correct.
identify?
Correct.
And on your survey, if we look down in the lower left corner, there's some notes. Is that correct?
Yes.
In the very bottom note, what does that note say?
Yeah. Do you mind if I look at it on mine? I'm having a little trouble seeing it on the screen.
I'm fine with that. Just for your benefit, I understand I may be wrong that it blows up. Is that correct on his?
I can kind of see it. I mean, I'll have to
But you
look
can-
real close.
I don't think he can magnify, he can circle something, you would need to magnify. His screen simply shares what's on your screen, but then he can use his finger as a.
Oh, that's better. There you go. That's a lot better.
Okay,
Okay.
thank you.
I'll just go ahead and read the note. Tree type label shown here on as requested by the client's design team and needs to be verified by the proper professional prior to planning or construction. On point survey and assumes no liability as to the accuracy of these labels.
You said on point.
On point survey and yes. And so basic,
I need you to.
I'm sorry,
The
yeah.
court reporter didn't catch all that, start with.
Yes.
on-point
Okay,
surveying.
I'm sorry. Yeah, on point surveying assumes no liability as to the accuracy of these labels.
Thank you. Let me hand you a photograph. And let me ask you if you recognize the image in that photograph.
I do not recall that image. But I've probably done 300 tree surveys since then, so they all kind of run together after a while.
Okay. Do you recognize any of that as easement area 2 on the Anderson property?
I don't recall that.
Okay,
So,
thank you very
Mhm.
much. Now, your survey, let me see if I can get it to
Uh-huh.
zoom back out. Okay. It shows 2 easement areas, is that correct?
yes,
And those easement areas are highlighted in gray.
that's correct.
Okay. And those easement areas, were they identified using the Anderson's deed and plat?
That is correct as well.
Okay. And if I look, I'm going to try to zoom in over here on easement area 4.
Okay,
Sorry,
you mean two?
I'm sorry, 2.
Yep.
Sorry.
No, it's okay.
I was thinking Blair Witch in my mind as I'm trying to enlarge this, and everybody's probably like, please stop. On easement area 4, am I on easement area 2? Sorry, Judge. Am I correct on the corners? Tell me what we see there.
So on 3 of those corners, you see, well, let's start on if you're looking at the screen, the top left, you see a little circle that has a leader to it that's identified as a 1/2-inch rebar found. So that was a found monument that we found on the site. And then if you go down the 60 feet to the right, you'll see a 1/4-inch rebar found. And then go down the 53.27 feet, you'll see a 1-inch rebar found. The other corner was not found, so it was actually, it's just a calculated point that's shown there.
Okay. And these found areas, you were able to find those in the field?
Yes, ma'am.
I don't have any further questions for you.
Does 1-inch rebar mean like that was a 1-inch diameter?
Diameter, yes, sir. Yes, sir.
Okay. Thank you, Ms. Stern. Any redirect or anything else from the Anderson side?
Very briefly, Your Honor. Mr. Venable, you were asked to read a note just a minute ago that said tree type labels.
Mhm.
Does that mean labeling what type of tree it is?
So a lot of surveyors will do it differently, the way they identify the tree. Some will actually identify, for instance, let's say it was a dogwood tree. They'll actually specify dogwood or maple or that. Because she asked me a question if we were arborists, we're not. So we put them in 2 classifications, basically hardwood or pine. I think we showed some evergreen screenings, which are like little holly bushes, but that's our way of like limiting our liability on the trees.
And that would be if there was this dispute as to what exact type
Right,
of
if
tree
it
that
was a
was.
maple or an oak or what, so, yeah.
Thank you so much.
Uh-huh.
No more questions.
Anything else, Ms. Stern?
No.
Any questions from the jurors for Mr. Venable?
State and spell your name for the record.
What's that?
State and spell your name for the record.
Okay, Tracy, Tracy, Anderson, Anderson.
All right, Tracy, there's a couple of elephants in the room. I want to just jump on them right now, okay?
Okay.
Let's talk about the fat bitch incident. You admit calling Miss David a fat bitch?
I do, yes.
Tell the backstory. Well, stop before you go there. Are you proud of that?
No,
Have you apologized?
I did.
Have they said, okay, thank you?
No, she didn't. We did it with the other judge in court
Okay,
when she tried to get a temporary restraining order against me.
okay. So let's tell the backstory as to how we got to this incident where you talked to her and cussed at her.
Okay. We were laying sod on the property alongside the garage.
When you say the property, you're talking your property compared to the easement or?
My property, nothing on the easement.
Okay,
Okay? We were laying the sod across there, and I'd been in a hurry all morning. I had to get to my office, and I'd pulled my car up to the front of the house, okay? And I'd gone back down, and I was looking for some documents I needed to get to take to my office for signature
Let me stop you right
Yeah.
there. Where were you when you're looking for these documents?
in my basement office.
Which way does your basement office face?
It faces due south, right toward the easement
Okay.
in the side yard.
Was there sod, were there pallets of sod out there?
Yes,
Were they in the easement? Were they on your property? Were in the street, driveway? Where were they?
they were not. They were in our property and on the street to the best of my recollection.
Okay. What happened next?
Okay, I heard some commotion all of a sudden, and I heard this, I'm gonna call the police. I'm gonna call the police on you. And then all of a sudden, I see her car just go screeching off. So she'd gone out, and I come subsequently find out because
Hold on, let's wait a minute before you get into subsequently found out. I want to lay the foundation for that. But you were there and you heard her threatening to call the police.
I heard a police action. Yes,
Was it Miss David's voice?
it sure seemed like it. It was her blue Tahoe.
Okay. Wasn't the landscapers threatening to call the police on her?
No,
Okay.
no, sir.
All right. What did you do next?
Well, I went back in, I got in my car, I had to go. So as I'm driving down Habersham to go cut over to my office over off Windy Hill Road, I called my landscaper, Jose Lopez.
All right, now, before you say what was said during that conversation, I want to establish a few things.
Okay.
You called or he called you?
I called him first and he called me back
He called you back.
because his workers had gotten in touch with him and he was making a move to get over there to see what was going on.
Okay. And you spoke with him?
I did.
And did that calm your concerns or did that make you even more mad?
I didn't really understand the whole gravity of the situation until I got home.
Okay.
Okay. And then we were able to see that. I was able to talk to Jose and he said that Mrs. David had scared the living.
Stop for a sec.
Yes.
Okay, the objection is hearsay?
Yes.
Okay, as to what Mr. Lopez said.
This goes to affect Mr. Anderson's state of mind for how he was feeling when he went to see Mrs. David shortly thereafter.
Okay, it's not, I don't know what Mr. Anderson is gonna say Mr. Lopez said. Is it being offered for the truth of the matter of what Mr. Lopez?
It's not we're not offering it for the truth of the matter asserted. We're just offering it for the fact that the statement was made and it affected Mr. Anderson's thinking as he went to talk to Mrs. David.
Okay, Ms. Sturm, anything else?
No.
Okay, for now, I'll let it in.
All right, go ahead.
Question again, please.
What did Mr. Lopez tell you during that phone call?
He told me that Mrs. David had come out there and was screaming at his landscapers
Okay.
and telling them that they were on her property to get off. You got to quit laying sod, the whole thing.
Anything about the police?
I think, yes, she said that. I heard the police. She's going to call the police. And all it was just her screeching off.
Okay. And then obviously you saw Mrs. David sometime thereafter.
I did, yes.
How did that happen?
So
I need a question, I'm sorry.
You saw Mrs. David sometime thereafter.
yes.
How did that happen? How did you happen to see her?
Okay, I was in my dining room with my daughter Holly, who was teaching a class, and I was talking to her. She was on a break, and I saw her come pulling down her Tahoe. I said, I got to go out and talk to this woman. This is just not right.
Okay.
And so I started getting a little amped up with her. I freely admit that because she was just screaming at me, telling me I was a horrible person.
Hold on, let's take it step by step.
Yeah.
So you walked out the back door. Where was she?
She was in her car.
Okay. She was in her car, coming from your right to left, so the driver's window is on your side.
I believe the driver's window was facing me, yes.
Okay. And
And if it wasn't, it was her through the other side, but the window was down where she could talk.
who started the interaction? Did you first say something to her or did she first say something to you?
I did. I said, ma'am, you cannot come on my property, tell my workers not to lay sod and do that and scare them to death. These guys were all very scared, as my wife pointed out earlier, because she'd gone down there after I'd left and was able to talk to one of them.
Hold on one second, Ms. Sturm.
Well, I don't recall Mrs. Anderson testifying that she went down there and talked to one of them.
Okay, but That's his recollection. The evidence is what the jurors heard the evidence to be.
Okay. And I'm sharing my screen. I hope everybody can see it. You went to see her,
Yes.
and I'm going to call out this area. The shaded area, what's your understanding as to who owns this shaded area, easement area 1?
So you get into, just want to make sure we use the right words. Who owns, who can use, and you may have said that purposefully, but just be thoughtful about how you're asking about who owns, controls, can use.
Just asking about ownership.
Okay.
Who pays taxes on it?
Okay.
Who owns it?
I pay taxes. I'm the rightful owner.
Okay. Did you, all right, keep going. You went to talk to her. You said what you said about don't confront my workers. Where were you standing at this time?
I was on my pathway across from the brick turnaround.
So somewhere around here?
Yes. No. Yes.
Okay. Did you ever jump the wall? Because there's, what is this area right here? It says neighbor's wall. What is that?
It's just a 4.5, 5 foot brick wall.
And did you jump the wall?
I did not.
Where did you end up? I'm going to use my little laser again and stop me when you stopped.
Go back into the circle. Kind of corner, caddy corner.
Right there?
No, yeah, just go back, straight back now.
Straight back?
Yeah, so right in the middle.
Right around there?
No, over here a little bit.
Which way? My right?
To my left.
This way?
Yeah,
Okay.
this way to the left.
Okay.
So it's over here, Randy.
So you can mark on the screen.
Okay.
That may be more helpful if we have the witness mark it.
That certainly would be.
Yeah. So what you need to do, tap the screen once,
Yep.
and then there should be a little pencil icon in a circle that shows up on the left of the screen. You just mush your finger on the screen once, tap, and then take finger off. Is there a circle with a pencil in it in the left-hand corner?
There's a circle with a smiley face.
No, that's not it.
That's
Deputy Gordon's gonna help you with this, because I just
Yeah.
wanna.
Yeah, it's not there. The pencil's not there.
Once we empower you, then whenever you touch it, you'll be making a mark. That's not doing what it's supposed to do. All right, we'll get IT to fix it during the break.
All right.
It is a fancy touch screen when it works. Sorry, Mr. Grant.
It's all right. Can I show him by going around?
Yeah, why don't you just
Show
go to
the-
the big
show-
screen?
Yeah, come here to the jury and I'll mark it on my iPad.
So here's our house, and this is the dining room, and this is the pathway. It comes around and goes down to here, and then across all the way to the detached garage. I was standing right about there.
Around here.
Yeah, a little back, actually. I was probably a good 15, 16 feet from the gate.
So you told her, don't confront my workers. Did she apologize?
No, sir.
She didn't say anything about apologize for the misunderstanding. It's anything like that.
No, sir.
Did she say anything?
No, just when I went off after,
Well, what did she said something?
about, to me,
Yeah, to you about you. Did she say anything to you about
she
you?
said I was a horrible man that had multiple wives.
Have you had multiple wives?
I have not.
How'd that make you feel when she said that to you?
It was an absolute insult. It was an insult to my wonderful wife of 27 years. And that also was a thing that got me kind of angry that day.
Okay. What did you do in response to that? Or
Well,
what did you say? What did you say or do?
I called her a fat bitch, and I said, and you can die from being fat. And you got to put that in. When she says I'm going to die, that's not it. There was context there. There was context to what I was trying to say.
Okay. What happened after that?
Walked off.
What's the context of you saying you could die for being so fat? But maybe
Well,
I'm missing the.
well, the context is I was very angry. Okay.
The context you gave as to here's why I may have said something indicating I was angry.
Yes, it was purely out of anger at the moment, and I normally don't do that. I'm a former CEO of a biotech company. I had 265 employees in Miami of every type of person known to man. Okay. And I think if you talk to any of my employees, they would tell you that number one, I was a really good guy to work for, and they had a lot of fun working with me, and we did things the right way. I'm not a racist. I mean, for them to say that and to call me that, it just.
Okay, we're not.
All right, let me ask,
I
let me just
was
ask a question.
asking about context.
All right, let me ask the question about the, is there anything else about this incident? Did you jump the wall? Did you threaten her? Did you attack her? Did you
No.
do-
I was never closer than 15 to 20 feet from her.
Did you set foot on her property?
I did not.
Did you set foot on the shaded area that you own and pay taxes on, but they have easement rights?
I did not.
Okay. There's another elephant in the room. Let's talk about that. You heard Ms. Sturm in her opening statement say that well, let me stop right there. How many times in your life, from the date of birth until today, have you had interactions with Stacy David?
Once.
Okay. We had a hearing on the TPO with Judge
Well, then,
Manning.
if you consider that, it'd be twice, but that was on a Zoom call. It wasn't like where I saw her in person.
Okay.
I've seen her once in person until yesterday.
Okay. So yesterday, Ms. Sturm, in her opening, said that you'd yelled at Ms. David. I can't remember if she said either this is not the first time or the last time, but any other interactions where you yelled anything at Ms. David?
No.
And Ms. Sturm used a very, very offensive term. Algerian, I'm not even going to say it. Did you ever use that term to anyone in the David family?
I absolutely did not. I find it so reprehensible that that's being said, that this is being brought up. This is a land dispute and they're trying to make it into a racial thing. And it galls me to even think about that. I'm born in Atlanta, Georgia. I'm from here. I grew up here my whole life. I went to school here at the University of Georgia. I've tried to do everything, give back to our community. I've tried to be a good citizen. I've never had anybody call the police on me until Mrs. David called police on me. And they came over and they were like, sir, I think the police officer, he said, sir. Okay.
Objection.
Just keep it focused.
Just for the timing and not all.
Okay.
Do you recall the first time you heard any claim by Ms. Sturm's office that you had used that slur in any way in this case?
Yeah, I think it was like about 10 days ago.
No, let me hand you.
Was
this
it late,
email.
a couple months?
And the date of this email, I'm not going to offer, I'm just using this to refresh your recollection. What's the date of this email from Ms. Sturm to me
November 9th.
of last year?
Yes.
And she references this slur
Yes.
in here, right?
Yes.
This slur, this racial slur. Is this the first time that you were ever advised or accused of using this slur in the history of this case?
The only time.
Well, until yesterday.
Yes, until yesterday.
Was there anything significant that happened in this case around this time that you think precipitated this false accusation?
So no speculation. You're
Okay.
welcome to.
Is there anything you can point to of significance in the history of this case around this time?
They were denied cert from the Georgia Supreme Court just days before that letter came out.
Okay.
Well, that was an interesting little twist. Fulton County's system's down, so I can't really look at the docket for the case, but I did find where the Supreme Court did deny the writ. And I also found the Court of Appeals opinion, which is from June of 2023. I will post the entire thing on Patreon, but just to give you an idea, it says this is a property dispute between neighbors. Plaintiffs Anderson appeal from the trial court order denying their motion for partial summary judgment and granting defendants David's motion for partial summary judgment. The Andersons assert the trial court erred in construing easements burdening their property to convey sole and exclusive rights to use and possess the easements areas to the Davids, thus stripping the Andersons' rights as fee simple owners to use or possess those areas. For those reasons that follow, we reverse the trial court's decision. So apparently, the Davids won a partial summary judgment. The Andersons appealed. The appeals court reversed, and then the Supreme Court affirmed the appeals court decision. So the Davids basically lost, and the Andersons won. So they're saying that that's what prompted Ms. David to throw out the allegations that that slur was used. Interesting.
Thank you. Let's well, we also heard something about a gun with Hopkins. You remember Ms. Sturm talking about that in the opening? And I believe, at least in the email correspondence, they had referred to that as brandishing a gun. Do you know what brandishing a gun means?
I do.
1 second. Yes, ma'am.
But, counsel is testifying as to things in emails, but that's not coming from the actual witness.
Okay.
So
Rephrase his question.
let me rephrase the question. Have I forwarded you an email from either Ms. Sturm or Mr. Schneider where they used the words brandishing a gun at Hopkins David?
Yes, you did.
Okay. Did you understand what brandishing meant at that time?
My definition of that would be waving something or holding it up and pointing or doing something with a weapon that I would never do.
Okay. And do you recall an incident where do you recall videotaping Hopkins on this occasion when you were allegedly brandishing a gun?
I don't recall that I was videoing at that time.
You videotaped Hopkins at some other time?
When he's out on the property, the lawyers asked me, just show if they're out there and let us know.
Okay. Let me, Plaintiff's Exhibit 45 is a capture, Plaintiff's Exhibit 60 is a capture of Hopkins David video that Mr. Anderson took. You remember you took at least 2 videos, right?
Probably 2, yeah.
Okay. All right, Your Honor, we're going to offer Plaintiff's Exhibit 60.
Okay. So 60, you're saying Mr. Anderson would identify because he made the video.
He made the video.
This is something we've talked about outside the presence of the jury.
Yes.
I don't have any authenticity issues, assuming 60 is what he's saying. We'll find out in a minute when it plays, assuming it is what Mr. Edwards is saying. Any objection to the admission and publication of plaintiff's 60?
No.
Okay.
All right, I'm going to play this and hopefully we can see from my iPad how it goes, and I don't know if we're going to be able to hear it. All right, come on, start playing. This is, let me go output. There you go. That's not working. All right. Judge, we're having technical difficulties. I was not expecting this.
You're having technical difficulties. You can have a colleague try to get it to work while you continue your examination of Mr. Anderson.
Well, do you recall when you were recording Mr. David, young Mr. David, that he picked up his camera and started taking pictures of you?
He did.
Have you seen any pictures that young Mr. David took, pictures or videos of you brandishing a gun?
No.
Okay.
Because I wasn't.
Did you have a gun that day?
I did. I've been at Stoddard's at the range, and I had it in a casing, and I got it out of my trunk, and I didn't realize the young man was over there on the easement. And I pulled the gun out. It's in a case. You can't even tell it's a gun unless you were asked. Okay. I walked down to my mailbox, got the mail, and turned around and took the gun safely to the house where it was put in the gun safe.
Okay.
But to say I was brandishing a weapon around a young boy, that's just completely false.
Knowing the Davids the way you do you think, speculation, we'll save that for closing argument. Okay, let's kind of back up a little bit. That's not working either. All right, I apologize. All right, let's kind of back up to the beginning. Mr. Anderson, your wife talked about y'all looked at this property before y'all got married. Tell us about that.
So before we got married, we were looking at houses and we were trying to decide whether we wanted to try to rush and buy a home quickly or lease a home and have time to take some time. So we didn't end up buying the house that time. We went and leased a home for a year and then we bought another home. And subsequent to that, this house came up for sale back in 2018 and we acquired the house and moved in.
Okay. And in the intervening years, would you drive by the house from time to time?
Time to time. Just a lot of times that, West Andrews and Chatham are cut-through streets between Habersham and West Paces Ferry Road. So there's a lot of drive-through there.
And when you drove past it on these cut-through occasions, did you kind of glance at it and think, hey, whatever?
Yeah, sure.
This nice house. During that time, did you notice what the frontage looked like on West Andrews over these intervening years?
Yeah, just south of the driveway, it was just all overgrown. Just all overgrown.
Okay. Plaintiff's Exhibit 22, Your Honor, is Google Earth screenshots, street view images. Oh, let me go back. Don't show that yet. Street view images. Mr. Anderson can authenticate those if I have to do that first and agree, or however they want to handle it. But
Which exhibit?
Plaintiff's Exhibit 22, Google Earth screenshot images, 5 pages over several years. And I'm afraid if I go up there and show him, well, actually, you have the notebook in front of you.
Dude, if you'll open
Flip
that,
over to tab 22. Thank you, Judge. I almost forgot that.
I'm there? No, 21, sorry.
That's 21. Thank you. It's 22.
Yeah.
All right. You're looking at those Google Earth Street View images. The first one is, can you read the date on that, of the actual picture?
I don't see the date.
Should be the top left-hand corner.
No, it's not there.
Okay. Does that look like, do you recognize that as a street view image of what is now your property?
That's correct.
And same for the next 4 pages, is those street view images of what is now your property?
So where I can. Yes.
Okay. All right, Your Honor, we offer plaintiff's exhibit 22.
Any objection to plaintiff's 22?
No objection.
Admitted.
All right. Mr. Anderson, I'm showing the jury the first page of plaintiff's exhibit 22, and let me use my little handy dandy call out feature. Street view August of 2012.
Okay.
Can you kind of generally describe for us, and I'll do this the easy way or the hard way. Roughly where is easement 2?
Easement 2. Can you see the fence on there? Picture? I can't see.
No, this is before y'all bought it. This is 2012.
Okay. Easement 2 is down past here, kind of about halfway through the picture it starts.
Okay. Somewhere around here to this way?
Right, a little south.
Around here?
Yeah, a little south of there even.
Okay. Next page. This is from August of 2014, a couple of years later. Does it look like anyone is using this for ingress or egress or any?
No.
Objection. I mean, it calls for speculation.
So don't ask him his opinion on that. You can show the pictures.
Okay. Third page is an image taken from October of 2018. Did y'all own the property at this time?
We did.
Okay. Had you started any clearing of easement 2 at this time?
I'd started probably that time, I'd started going in there, it's like you heard earlier, Marty Paget, who was Ann Nikirk's yard man, he was with them for 20 plus years. And he had taken the easement area, he'd made a path that goes back through there, and he would just take grass dumpings, bottles, railroad ties, anything.
Okay, let's not talk about what Mr. Paget may have told you. I want to talk about what you personally observed with your eyes. When you bought the property,
Yes.
did you see any evidence of anyone from next door using it for ingress or egress?
Never.
Describe for the jury the condition of easement 2 when y'all bought it in September of 2018.
Well, it was just so overgrown with brush and vines and weeds and just all kinds of little nuisance trees, those little skinny little type trees that are about that big around that would go up, and we just started clearing it out. And there was huge stumps back there on the property that were in there. We had to get that removed and pulled out. I mean, it was a big pine tree that had probably fallen over years ago. And we just cleared the place up as best we could and tried to make it look better. Just like my wife said.
Okay. Railroad cross ties.
Yes, they were back
Tell us
there.
about that.
But they're just, the house initially had a bunch of railroad ties around it. And they were starting to rot out, and I found a couple of copperheads up by the house where I was able to kill them and pull them out. But back when we were cleaning out easement area 2, I killed 12 copperheads.
Where were they at?
They were in easement area 2 and on my side of the yard as well.
Okay. And the railroad cross ties, well, had there been railroad cross ties thrown or trashed into easement 2?
Yes.
Okay. What about plastic and bottles and other types of trash? Was that in easement 2? Tons. How would you characterize easement 2 in this fall of 2018, spring of 2019? Was it an area of peace and beauty or natural beauty, or was it something else?
I mean, I thought it looked really horrible. That's why we wanted to try to fix it and make it look better.
The fourth page of this exhibit, November of 2019. This is after y'all have been there for over a year, is that right?
Correct.
And let me just call out all of this. Have y'all done any clearing or cleaning of easement 2 by this time?
Maybe a little bit.
Okay. And the grass, if we look at the grass in the yard from 2019 versus 18, has the grass been extended?
Grass has been extended, yes.
And has any ivy been removed from easement 2 between 2018 and 2019?
Yes, oh yes, definitely. That's where all the snakes are.
Okay. And the fifth page of this exhibit is dated also November 19. Where in relation to the property is this on the fifth page compared to the fourth page?
This more southern end of the property.
Okay. So is that the street frontage of easement 2?
Yes.
West Andrews?
Easement 2 is on that street frontage there, yes.
Now, Ms. Stern said in her opening, I believe, that the workers used easement 2 for ingress and egress, not your fee simple property. Did you ever see any workers hiking through this brush, or did they just walk around your house?
They walked up my driveway. They would come, if they were down the street or up the street, either way, they would walk down to my driveway, and I'd built a stone path up around the side into the back of the garage. And their workers would just come up and go right across my driveway, right across my property into their property. So it was just happening over and over and over, and we didn't know who was coming around the house or who wasn't. So then a bunch of ladies were like parking their cars down there and going over to see Mrs. David. And they would come up there and one lady, I asked her, I
Well,
said, "Ma'am,
don't get into what you talked to these ladies about. I'm just asking about what you personally observed. Did you ever observe any workers or visitors to the David property go through all of this brush on easement 2 to access their property?
never, ever."
But did you personally observe them using your fee simple property?
Yes,
Did you complain to either of the Davids about this?
I have not.
Okay. We heard a lot of talk about the trash. And tell me what you know about that based on your personal observations, not what you've heard from third parties.
My personal observation is my now son-in-law took some items over there and threw them in the dumpster because we had no room in our trash cans because they'd been blocked off.
And did you have a discussion with Mr. David about this at any time?
I did.
Tell us about that.
Mr. David came over one evening while I was grilling for our kids and knocks on the door. I went to the door and he said, "Why are you throwing stuff in my trash can? Why are you throwing stuff in my trash can?" And I said, "Sir, my son-in-law put this trash in there because you all with your workers have blocked off this whole area, okay, where we can't even get trash pickup." So that was the case.
Okay. Did he apologize?
I think he might have apologized that time. I think he might have said, "Oh, sorry," and he said something to the line of, "It smells really good back there." So,
Talking about your
Yes.
hot dogs? Did he say, hey, we need to get together for dinner sometime or anything like that?
no, sir.
Didn't invite you over for a drink or ask for one or anything like that?
No,
Didn't ask for a hot dog?
no.
Would you have given him one?
Would you have given him one?
I probably have to, right?
Yeah, I mean, seriously, would you have given him a hot dog if he'd asked for one?
Sure,
Only on the easement.
sure.
After not the garage incident, after this incident that you personally had with Mr. David, did you have any other incidents other than the one with Mrs. David?
No,
Okay. Have you ever, other than that one occasion and being in court the last 2 days, have you ever physically been in the same room with Mr. David?
I don't believe so.
Other than that one incident, have you ever said anything to Mr. David?
No,
Did you see him out at your property a week ago?
I did.
When was that?
It was on a Sunday.
Sunday?
Yes.
Where was he?
He was walking across the easement area too with some other gentleman.
Okay. Now, after this incident with Mrs. David, what was the next contact or communication you had with either the Davids or anybody representing the Davids?
The next contact I had was with us going to court for the TRO to get it knocked out.
Do you recall getting a letter from Ms. Sturm?
Oh, yes.
Shortly after that?
Yes.
Plaintiff's Exhibit 3 is a redacted version of the letter that Ms. Sturm wrote on February 26th. We offer that, Your Honor.
Ms. Sturm, any objection to plaintiffs 3 as redacted?
No objection to plaintiffs 3 as redacted. I have given some broad birth here, but I think we've had a lot of leading questions and I would just ask that counsel address that.
Okay, so let's keep the questions open-ended for your witness. They
I
can
will-
be precision sharp when you're cross-examining, but we're hearing from Mr. Anderson and not from you.
I understand, and I will try to do better. All right, Plaintiff's Exhibit 3, let me share that with the jury. Is this the letter? Let me flip through it. It's 3 pages. Part of it's redacted. Do you recognize this as the February 26th letter that Ms. Sturm sent to you?
I do.
And the letter is going to be into evidence, so I don't need to go over this in detail. What was your reaction upon receiving this letter?
Well, I was pretty much kind of shocked
Why?
just because I just was like, what are they doing? What are they thinking?
She says in here, Let me do a little highlighting. That you've trespassed onto David's property, unlawful clearing.
Stop for 1 second. Did you have this is just an excerpt from a letter that's in evidence.
Yes,
And you can highlight as he sees fit.
yes, I don't disagree with that. Is he asking a question about it?
Okay.
If I was.
You don't need to read it. You're the last one really who should read it.
Okay.
It's in evidence. The witness
All
can
right.
read it. It's on the screen.
I'll just highlight it and then I'll ask the question. Do you see here where she's accusing you of cutting down trees and unlawful clearing without an arborist permit and other vegetation?
Yes,
Is that in any way, shape, or form true?
it's 100% false.
Do you see where there's lots, this full entire paragraph is about surveillance cameras. Did you have any surveillance cameras pointing at the David property?
No,
Did you have any surveillance cameras directed at easement 2?
no,
Did you have any surveillance cameras directed at easement 1?
no.
And finally, did you view this as a message that you're about to be sued by Ms. Sturm?
Well, when somebody threatens to put a lien on your property, you have to expect that's the case. So yes,
Did you get a lawyer to respond to this letter?
I did.
Who was that lawyer?
Mark Ruschi from Alston and Bird.
Plaintiff's Exhibit 4 is a letter from Mark Ruschi to Kimberly Sturm. We offer that, Your Honor.
Any objection to plaintiff's 4?
No, Your Honor.
Okay. 4 is admitted.
All right, 4 is admitted. I'm not going to go over this in much detail. The jury will see this. Did Mr. Ruschi, who's Mr. Ruschi?
He's a real estate lawyer here in town.
Okay.
You know, retired now from Alston Bird.
Friend of yours?
Good friend, yes.
How long have you known him?
I've known Mark, I guess, about 5 years.
Okay. And did he basically respond to her allegations?
He did.
After this letter, did anyone from the Davids or Miss Sturm follow up and say, "We're sorry for the misunderstanding," anything like that?
No.
Did you think this matter had been kind of put to bed by the time you sent, Mr. Ruschi sent this letter?
I thought so, yes.
Obviously not. What happened next?
Well, I mean, we filed suit against them.
Was there something in between Mr. Ruschi's letter and us filing the lawsuit, the TPO?
Oh, yeah. So yeah, I mean, they,
Objection, Your Honor. The counsel continues to lead the witness.
Well, yes and no. He does offer commentary, like obviously not, and then ask the question. But that's not your objection. I don't have a problem with lawyers on either side providing some context to get a witness oriented to where, not the answer they're trying to get, but where chronologically they're trying to get. And Mr. Anderson, it sounds like he's out ahead of Mr. Edwards. And so for Mr. Edwards to say, well, let me give you some framework here. I don't think there's an issue with that. So I'm gonna let you frame it to get Mr. Anderson chronologically where you are. And then I trust you will stay focused on asking open-ended questions when it's your witness.
I will certainly try.
Okay.
Do you recall being served with some papers from a Fulton County sheriff a few weeks after Mr. Ruschi's letter?
yes.
What was that?
She tried to get a temporary restraining order on me, and we had to go to court to beat it down.
And who represented you in that court hearing?
You did?
Okay. And who represented Miss David in that court hearing?
Ms. Sturm?
Okay. Actually, Brandon
No,
Arnold.
no, that's right, that's right. Brandon, what's his name?
Yeah,
Yeah,
Brandon Arnold from her office.
yes,
Arnold.
yeah.
And Miss David testified, is that right?
She did,
And you testified.
correct.
And during your testimony, did you say basically the same thing you said today?
Yes,
And the result of that TPO hearing was?
it was beat down.
And we filed suit. I'm not sure if it was before or after the actual TPO hearing, but we filed suit, right?
Yeah, I think it was after, I believe.
Was there any doubt in your mind that there was going to be a lawsuit one way or the other?
There was zero doubt in my mind, unfortunately.
Okay. Before the TPO was sought and obtained, did anybody from the Davids come over and say, hey, we need to stand things down a little bit? Can you agree? Can you apologize to my wife or anything
No.
like that? Okay. We've heard a lot of talk about your intentions to do a lot of clearing and landscaping and all of that stuff on easement 2. And when did you begin planning to do more work on easement 2 than you had already done?
I think we started talking to Alec sometime in late 2019, maybe. And we were talking about what we could do down on that area and what we could do also on the north end of the property.
Okay. And Alec's last name is what?
Michaelitis, I think, something along that line.
Okay. And Land Plus Associates, is that his
Yes,
firm?
that's correct.
Okay. Plaintiff's Exhibit 5 is pages 1 through 7 of the documents produced by LPA to Ms. Sturm's office in response to RFP that they served on him. I offer that.
Ms. Sturm, any objection to the admission of plaintiffs 5? While you're thinking about that, ladies and gentlemen of the jury, an RFP is just request for production. Lawyers, while they're engaged in discovery, can send a subpoena to a non-party like Land Plus Associates saying, we'd like you to produce for our consideration documents X, Y, or Z. And what Mr. Edwards is saying is that whatever documents are in Exhibit 5 were things that actually the David's lawyers asked for from this landscape. That's all RFP means. Ms. Sturm, any objection to plaintiff's 5?
I'm going to object to the extent he's trying to get information within those documents into evidence.
Because it's hearsay.
It's hearsay.
Okay, so Mr. Edwards, I think I'll admit these. I don't know that they'll go back with the jury. And you'll need to be thoughtful about how you use them other than to provide Mr. Anderson maybe with a frame of reference for what all was involved. But these are, I find that they're statements of Mr. M, the landscaper, and not statements of your client.
Well, there's back and forth, but I'm just offering them for the purpose of establishing the timeline for when these plans began.
Great.
Okay?
So they're in, whether they go back to the jury or not, we'll decide later. And Mr. Anderson can certainly refer to them in response to your non-leading questions about when things happen.
All right. The first page of this exhibit, Mr. Anderson, is an email from whom to whom? That's not leading, is it, Judge?
It's from me to Alec,
Dated?
3/11/20.
Okay. So without really necessarily reading the document, tell us generally what's going on here.
So we'd talked to Alec about maybe doing a complete full landscaping of the entire property. And that's what we were doing. He made a landscape plan that he presented to us.
And the next page, the next couple of pages are a detailed proposal. And again, we're not going to get into the details of that, but the date of this proposal is what?
February 11th, 2020.
And then did you proceed to do anything in response to this landscape plan?
We didn't hire Alec for the plan. We didn't hire him.
Okay, did you hire anybody?
No, we just brought in some workers and everything to help clean out that horrible area that was back there.
Okay, in the sod?
Yes,
And
that was later though.
did you, when you were doing this clearing of easement 2, did you plan to do any installation of any type of vegetation?
Well, we were thinking about doing grass to get started with, and then we were going to probably hire a landscape company and try to figure out a plan.
Okay. And we've heard questions of your wife and some statements in opening statement about your intentions. You intended to do landscaping. You intended to do that. Did you in fact intend to do landscaping in easement 2?
Yes.
Have you since the sod incident?
Since the sod incident and the lawsuits, we haven't done anything
Why not?
because we wanted to see this through and do it the right way.
Okay. Have the Davids reciprocated and said, we're not going to do anything either until this case is over?
No.
What have the Davids done on easement 2?
Well, they put up a lacrosse goals, some nets, some different, rotted out, these things they put out there. It's like a rotted piece of lacrosse equipment.
Let me just stop you right there. I've got a number of pictures I want to introduce into evidence. P Exhibit 6 is a photograph that Mr. Anderson took of some netting on easement 2.
So what would be great is if you want to get them in all at once, rather than we do one at a
Perfect.
time. So 6 through what would you like Mr. Anderson to look at?
6 through 11.
All right, so Mr. Anderson, if you just take a quick look at those 6 through 11, let me know if you're familiar with those photographs.
6, I'm familiar with that.
Okay, 7. Just take a minute, and when you're through, look up, and I'll ask you just one question instead of a bunch.
Mhm. Okay,
Did you take all those pictures?
I did.
Why did you take them?
To get them to you.
Okay, we offer 6 through 11, Judge.
Any objection to plaintiffs 6 through 11?
No, Judge.
They're admitted.
All right. Plaintiff's Exhibit 6. What is this?
It's some like raggedy chair that was placed on the easement area.
Okay. Did you remove that?
I did.
And do you still have it?
I don't know if I have it or not.
Okay. Plaintiff's Exhibit 7, what is this?
Some type of lacrosse goal.
The ground in front of that lacrosse goal, is it nice, good, firm footing, or describe the footing for me?
Soggy and wet.
I'm curious about the easement. You've described it as impassable, impenetrable. Is what we see in plaintiff 7, is all of it the easement, or the net is on the easement, but all of this, I'm gonna call it leaves and whatnot, is that on the David's property?
No, that's in the easement. Where that goal is down at the very southern end of the easement.
So a whole bunch of the easement is actually wide open.
Wide open because I cleared it out, cleared it.
I'm confused because you said you had never cleared it, and
No.
it was 100% false that the David said you were clearing the easement. I don't see, I may be missing it, but I don't see trees and snakes and bushes and whatnot between wherever the camera was and this lacrosse goal.
That's because they had all been pulled out.
Okay,
Let me,
and who pulled it out?
I did.
Okay, and when did that happen? Ballpark, I don't mean the specific. date.
Sometime in the 20s, 2020, 21, somewhere in there.
So parts of the easement then aren't, we saw some pictures where it looks like you would need the machete like Mr. Venable had.
Yeah, if you look at that picture and you go to the left, that's to the road to West Andrews. It's just all vegetation overgrowth.
Got it.
And then if you go to the very back along the David's property line, that's where you see their property.
Okay, but this area where it looks like leaves and whatnot.
Yes.
It is open, it's open because you made it open, but that is part of the easement. That's not, I think Mr. Edwards would call it, your fee simple, is not David property. This is easement. Everything we see on the screen.
That's correct.
Okay, thank you. That helps.
From the net forward, is that easement area?
That's easement area 2.
From the net backwards, all that trees and everything else, is that also easement 2?
No, the easement 2 ends at Dr. Elliott's property next door.
But have you cleared all the way to the edge of your property, or is there some portion of easement 2 that you've never done anything to?
Yeah.
All right, can you give us a ballpark for what the approximate cleared area is?
Maybe 60%, maybe
Okay.
40, 50%.
If you put up 8, you were probably gonna get there anyway, but Mr. Anderson can help there. Is that all, everything we see in there, easement 2?
Yes.
Okay. That's one of those split trees we heard Mr. Venable
Yes.
talk about, where he said one of them is 13 and the other is 32.
Yes.
Okay.
9? What is this?
It's some lacrosse thing, and it's like, if you go back there and would look at it now, it's kind of like rotted out.
Okay. And we have the pine straw to the front of it and some weeds and stuff behind it. The portion to the front, is that easement 2?
To the left,
But to the front of us, between us and the,
that's easement 2.
okay, and behind it, is that easement 2, or is that the David's, or is that Mr. What's his name's property?
That, I can't tell from that particular picture if that's the David's or if it's to Dr. Elliott's.
Okay, that's fine. Exhibit 2 is another angle. We have 2 nets. What's going,
Yeah, that's south to Dr. Elliott's property.
because there's a pink ribbon back there. Is that the property line?
Yes.
Okay. And 11 is the last one. What's going on here? What is this a picture of?
Well, right after we started the lawsuit, within maybe a week or two, all of a sudden, they'd never been out there. All of a sudden, I see Mr. David out there with 2 construction workers, and he's like making a path and cleaning it and just then leaves all the junk out on the street.
Okay.
Just so I can be oriented, this path that's cut through there, would it lead to where then we'd see all that lacrosse gear?
Yes,
So this would be part of easement 2 that remained overgrown after you did some clearing work?
yes,
And they did a little bit of clearing work, the Davids, which created that little path we see.
yes. And I don't know what trees or anything were taken out there, if there were or not. I just don't know.
Did you ever do any clearing of the street frontage portion of easement 2 so that people could walk from West Andrews to easement 2 and vice versa?
Never.
Why not?
I just didn't want to do that. Didn't want to have that
Okay.
for myself.
Plaintiff's Exhibit 13 is a video of the street frontage of West Andrews. You familiar with that video?
Yes.
We offer Plaintiff's Exhibit 13. Hopefully it'll play on my iPad.
What year was this?
We're on plaintiff's 13,
Yes. Now,
or the photo, I don't know who just asked that question, I couldn't see.
juror number 1, let me,
Don't ask questions out loud, jurors, you gotta write them on card.
Mr. Anderson, those nets that we just looked at, all of those pictures, approximately when did those first go in to easement 2?
I mean, right after we filed.
So after the lawsuit?
Yes.
Did the Davids reach out to you and say, hey, we want to put our kids' sports nets on the easement? Do you have any objection?
No.
Did we complain about it?
We did a little bit.
Did they say, oh, we're sorry?
No,
Are they still there?
they're still there.
They were there this morning?
They're there this morning.
Approximately how many times have you, so shortly after filing the lawsuit to now, roughly 3 years?
Mhm.
In the 3 years that those nets have been out there, approximately how many times have you seen anybody using them?
No more than 5 or 6 times.
Okay.
Your wife testified that you travel a fair amount, at least you used to.
I do.
How often are you around on weekday afternoons?
Well, I stopped really traveling a ton, Judge, back in 2020 when I stepped down from my role as CEO of IVEX.
Okay, so you've been some of them homebound.
I've been more homebound than previously, yes.
All right, so we haven't even talked about what you do for a living. You mentioned Vivex. What is Vivex?
IVEX is a biologics company and biomedical manufacturing company.
And you mentioned Windy Hill. Is that the headquarters?
We know that our main headquarters are in Miami, where we have 265 employees there. And then I keep an office in Atlanta with essentially our sales group and our accounting, because, flying out of Miami is a difficult footprint. So we use Atlanta for that. But to answer the judge's question, I was in Miami a lot up until 2019.
Okay. 2019, the Darby's still on the property. Did you ever see any signs of life from the then Darby's, now David property?
I have not.
Did you see any lights on at night or cars coming and going?
I never did.
I was going to show plaintiff's exhibit 13, a video taken August 12th, 2021. You familiar with this video?
It's not coming up.
I know, I'm going to wait. Are you familiar with it? And then I'll offer it. Well, I'll offer it now.
I believe I am, yes.
Okay, we offer plaintiff's exhibit 13.
Any objection to plaintiff's 13? Do you know which video this is, Ms. Stern?
It's street frontage one, August 12th. 30.
No objections.
All right, 13 is admitted. Good luck, Mr. Stern.
I know it works on my trial pad normally. I think the Zoom is to conflict.
So when you do share screen, there is a little box you're supposed to check in the lower left-hand corner, two little boxes about optimized video and audio. Make sure you.
Optimize for video, it says optimize for video off, so I need to click on. Boom. Thank you, Judge. Now, let me pull that back up. Everybody say hi to my wife and daughter. All right, let's try this again. Well, I know I can advance it second by second. Well, let's see, is it playing? All right. Well, I tried to optimize it, it's not working. All right, here we go. I'll just advance it 10 seconds at a time. And hope we'll get a computer for the jury tomorrow. That will be better. All right. August 12, 2021. Was there anything going on in the case around this early to mid-August timeframe? And let's not get into real details, but just tell me generally, was there anything going on as far as, well, tell me what you know.
I mean, I can't go back to that date and just think that I know. I don't know.
Okay. Shortly after plaintiff's exhibit 14, we'll offer this clearing video.
No objections, Your Honor.
Okay, 14 is admitted.
And hopefully it'll play, but I'm not optimistic. All right. So I'll just have to scroll through this. These big pink and yellow ribbons, did you ever complain about these pink and yellow ribbons to the Davids?
No, I mean, I'd just say that just obnoxious looking. Claire and I both felt like they put those up just to say, don't come across this.
Okay.
It's ours.
We see some people down here. What are they doing?
I think they were making that path.
Okay. All right, plaintiff's exhibit 15 is another copy of the clearing video. We offer that.
Looks like the next few are videos. Are they all similar? So you could offer them all up at once? So Ms. Sturm could say, I have no objection, or I do to the remaining videos? Not
Yeah,
that you're gonna be able to play them, but you're gonna give me evidence.
yeah, I'm gonna get them into evidence, plaintiff's exhibit 14, 15, and 16.
No objection. I just want to make sure that, there's audio with some of these and we need to make sure that's in clear.
Okay, well, the whole file is admitted, and so, should the jury want to review it during deliberations, I think if we play it through a different platform, it'll work. I don't control which platforms the lawyers select, but all the videos are admitted.
Thank you. And also 44 is a August 15th video. Plaintiff's exhibit 44, August 15 video. So I was at 15 is admitted. This is another video of the clearing, the workers. I'll just scroll through that.
Mr. Anderson, are you making these videos? Are you the producer of the videos?
Yes. Plaintiff's exhibit 16. Tell us what's going on and I'll scroll through this in 10-second intervals.
So I'm out there and Mr. David just comes walking on there and just starts setting up all this equipment on the property.
Okay. And I'll just scroll through in 10-second intervals. Do you recall Mr. David picking up his phone and placing a phone call?
Once I started filming him, that's the first thing he did.
Okay. Did y'all have any interactions yelling at each other back and forth? You didn't yell at him and call him
I didn't say
racial
anything.
slur?
No,
Did he threaten to call the police or ask if he should call the police?
no, he didn't.
Okay. Okay. And then plaintiff's exhibit 44, the August 15 video, I offered that, was that objected?
We hadn't gotten to it. Any objection to plaintiff's 44?
No judge.
Admitted.
Okay. Did you take plaintiff's exhibit 44?
Yes,
Why did you take that?
just to be able to show that there was a path being cut through so I could get it to the legal team.
Okay. Let's see if that works. No, it doesn't. All right. Go back to my document side. Plaintiff's exhibit 58, a before and after comparison of West Andrews. We offer that.
Which number?
58.
Sturm, any objection to 58?
I object only that I don't have foundation. I don't know where the comparison is coming from. I don't know if this is for demonstrative or
Let me
took them.
do Mr. Anderson can authenticate the photographs if you want to ask him a question. Mr. Anderson, you see plaintiff's exhibit 58, that side-by-side comparison?
I did, yes.
Can you tell the jury what that is?
So that was before and after Mr. David cut his path that's already kind of grown back over.
Okay. And the dates on that, that are superimposed on that, are those accurate?
Yes.
Okay.
Sturm, anything else? I think he's laid the foundation.
No objection.
All right, I'll admit 58.
So what's the purpose of this?
What was the purpose of this?
Yeah.
But you can ask him what it shows.
What does this show?
It shows that a path has been cut through from the top of the easement area down to West Andrews.
Okay. All right, 1 second, Judge. Okay. Tracy, I just want to make sure we're all clear on the timeline. Stop my share. On the timeline of what happened. When did y'all buy the property?
We bought it in, I believe it's September of 2018.
Okay. And the Davids, what's your understanding is when they bought it?
I think probably a year and a half or later.
Spring of 20?
Yeah, probably.
Between the fall of 18 and the spring of 20, did you do clearing, some clearing of easement 2?
Yes.
Did you continue doing clearing after the Davids bought their property?
Yes.
Did you continue to do anything on easement 2 after you got the letter from Ms. Sturm in late February of 21?
No, I mean, I've taken some equipment and removed it and put it back over in their yard or put it down over in the yard. But other than that, nothing.
Okay. You have you planted any bushes or trees or anything like that on easement 2 ever?
No.
Have you, why not?
I haven't now because we've been in this lawsuit and I want to get this adjudicated the proper way.
And the condition of easement 2, when you bought it, before the Davids ever looked at it, I'm talking the late 2018, first half of 2019, describe for the jury whether it was a natural beauty, nature preserve or something other than that.
Okay. It was not a natural nature preserve. It was a dumping ground. Okay. And it was a dumping ground for the guys, the local guys, yardmen in the area. They would come back and do this, especially the one that worked for Ann and then worked for our neighbors across the street. So they would take them back, they would drive it across my driveway and take it back into there and dump. And that's what I had to clean
Stop
up.
for a second. Yes, ma'am.
It's hearsay, speculation.
Well, if you want to ask him how he knows these things,
Okay.
it sounds like he could eyeball some of this stuff, as in he would see it, but if it's hey, my neighbor told me he was gonna dump some railroad ties there, let's
Yeah.
not get into that.
I don't want to know about what people told you. I want to know what you personally observed in the last quarter of 18 through 19, through all of 19.
Well,
What was the condition of easement 2 when y'all moved in?
it was just a dumping ground.
Did it appear that anybody, based on your personal eyes?
Yes.
Did it appear that anyone had made any use of easement 2 from the adjoining property in any way, shape, or form?
Absolutely zero.
Okay. And why did you want to clear it? Did you try to track down the Darbys and say, hey, I'd like to clean this up? Do you object?
I've never met the Darbys.
Well, did you try to track them down?
No.
Why not?
Just, I didn't feel there was a need to.
Okay. So you did some cleaning. The Davids moved in. Did you continue clearing out easement 2 after the Davids bought their property, finished their construction, and actually moved in their house?
Yes.
And approximately how long was that? Or do you know?
I don't know.
Eventually you built a fence.
I did.
Why did you build the fence?
I built the fence because when they tell you that workers were coming up the actual real easement area, they weren't ever. They would come up my driveway, cross our property. So what we had to do to stop that was we put the fence up, okay, and that stopped that problem immediately.
And did you reach out to the Davids and say, hey, we're building this fence. Do you have any questions or concerns or comments?
No,
Why not?
I didn't think it was necessary at the time.
Okay. Why did you stop landscaping or doing any work on easement 2?
Because of the lawsuit.
Who pays taxes, the property taxes on easement 2?
I pay the property taxes.
Have the Davids ever offered to share in the payment of the property taxes on easement 2?
No, sir.
Thank you, sir. Past witness.
Sir?
Get my water.
Good afternoon, Mr. Anderson.
Good afternoon.
We've met before. I believe we met when I took your deposition. Is that correct?
That's correct.
Okay.
And it's your testimony here today that you used easement 2 prior to the Davids moving in.
Yes,
And you're certain of that?
we've been on it, yes. Cleaning some stuff up.
Okay. And you recall I took your deposition?
I do, yeah,
Okay. And I asked you questions under oath,
right,
and you had an attorney there representing you to object.
right.
Okay. Do you recall me asking you this question in your deposition? Do you recall me asking you this same question in your deposition?
Repeat the question, please.
Did you make any use of easement 2 after you purchased the property and prior to the Davids? purchased the property?
Other than doing some cleanup, not really.
So it's your testimony that you did do clearing.
We did some clearing, yes.
I'm going to ask you to look at your deposition,
Okay,
page 52.
I don't have a copy of it.
I'm going to.
It's coming.
Very shortly. And it's lines 22 to 25. Can you read the question I asked you and your answer?
20, what were the numbers again?
52, 22 to 25.
I'm having difficulty. I don't see a 52. Okay. Page 52, right,
And then they do the lines on this.
21 through, okay,
22.
22, okay. Did you make,
Can you read that out to the jury, please?
okay, did you make any use of easement area 2 after you purchased the property and prior to the Davids purchasing the neighboring property? And I said no, but we did do some clearing. So that's just, that, if that's okay, that's just a mistake on my part.
Okay, so when I took your deposition back in January of 2022, you didn't tell me truthfully what had happened.
No, I told you truthfully.
Well, today you're saying you did make use, you cleared it, and in your deposition, you said you made no use.
Well, for when you say the clearing, we weren't actually on the EA2 except to bring stuff. We were clearing my property because that's where the bulk of it was, and it extended into the easement.
Let's talk about your property. You purchased your property, 3350 West Andrews Drive, September 27, 2018.
Correct.
Okay. And you purchased your property from Ann and Jeffrey Nikirk.
Correct.
Okay. Did you know Miss Nikirk previously?
I did not. My wife did.
You understand, and you closed on the property at the firm of Campbell and Brannon.
Yes.
Is that correct?
Mhm.
Okay. And during closing, you were given a copy of the easement agreement, correct?
I don't recall.
You don't recall?
No.
Okay. And at closing, you were given a copy of the plat to your property.
We were.
Okay. And do you recall the deed transferring title, conveying the property to you? Do you recall the deed for your property?
I don't.
You don't. Okay. Sometime after you purchased your property and moved in, do you recall the attorneys at Campbell and Brannon reaching out to you?
I do not. But they could have.
Okay. And I apologize, Judge, I just realized, Jeff, if you can give Judge McBurney the binder for the defendant. When you purchased your property, you were aware that there were 2 easements on the property, correct?
We were.
Okay. Easement 1 and easement 2.
Yes.
Okay. And my question to you just a moment ago is whether you recall, after purchasing the property, the attorneys from Campbell and Brannon reaching out to you about the property, your deeds, the easement agreement, and the surveys.
Is that a question?
Yes.
I don't.
Do you recall
don't
that?
recall that.
Okay. Let me have you take a look at this document. This is, I'm not. Mr. Anderson, do you recognize this document?
Judge, I object. She didn't share a copy with me, but now she is. Thank you.
You know, I don't, obviously it was sent to me, but I don't remember this.
Okay, but it's an email from John Hocutt, attorney at Campbell and Brannon, to you,
Mhm.
your wife, your former attorney, Mark Rushi, and Alec, we have all been butchering his name
Nicolaitis.
today. Nicolaitis. And you see that? Is that correct?
Mhm.
Okay. And in this email to you, Mr. Hocutt references
Mhm.
that he is providing a courtesy copy of both the easement agreement and the survey, correct? And you can flip through it.
We'll get that for you, I promise. I'll write it down and get it for you.
Is that correct? You were provided, on June 23rd, 2020, you were provided another copy of the easement agreement and the survey you received at closing.
I believe so, yeah, it says here.
Okay, you responded to this.
Yeah, I did.
Okay.
Hmm?
And isn't it true, you responded to Mr. Hocutt saying, we understand fully the easement?
Judge, I object because I think we're trying to get to some admission that the easement has some magic legal language. The easement is what it is, and you're gonna tell the jury what it means, and I don't want her to get into some form of admission, oh, it means X, Y, Z.
Okay, I understand your concern. We're not there yet, and so Ms. Sturm's gonna need to not go that far. I think right now she's simply establishing the awareness of the easement.
Mr. Anderson, isn't
Yes.
that correct? That you responded back to closing counsel, telling him, I fully understand the easement?
Yes.
Okay. And this is a communication between, I think I identified all the parties. We would move to admit defendants exhibit 29.
Any objection to the admission of defendants 29?
Yes, Judge, it contains out-of-court statements from an attorney, which may or may not constitute legal opinions. And if they do, they're inadmissible because you are the sole source of the law for the jury. And I think we all know why this is being offered, and I object to the document. If Mr. Hocutt, if they're gonna call Mr. Hocutt, I'd certainly look forward to cross-examining him, but absent Mr. Hocutt taking the stand, his opinion is clearly not admissible and probably not even then. So I object to this going back. It's irrelevant and misleading and hearsay.
Okay, well, that was a lot of things. The hearsay piece, though, how do you get past that?
Well, we could, yes. This goes to show his state of mind. So they're talking at, yes, Mr. Anderson's state of mind and knowledge and awareness of these documents that govern the property.
Okay. So I'm gonna do two things. I will admit defense 29 for purposes of the record, so it's in the record. We'll sort out later if it's something that will go back with the jury for the very concerns that Mr. Edwards has raised. And I just want to reemphasize, I don't see an issue with you establishing that either Ms. Anderson or Mr. Anderson were aware of the easement. Where it gets tricky and you'll need to steer away from is then saying, so you knew the easement meant X. Because it's not Mr. Anderson's interpretation of what the easement is that is going to be what guides the jurors.
Understood. Thank you, Judge. So just to be clear, Mr. Anderson, when you purchased the property, you were aware of the easement agreement and the easements on the property.
Yes, we knew there were easement agreements.
Okay. And then in June of 2020, closing counsel sent you another copy of the easement agreements and survey.
Can't remember that.
That's what we just talked about.
Yeah,
That's
but
this email.
if that's it, they sent to me, but that's 4 years ago.
Now, you also had your own survey done after you closed on the property, correct?
You did? Yeah.
Okay. And your survey of the property showed 2 easements, correct?
Yes.
Let's talk about when you purchased the property. Did you walk the entire property?
Yes.
You walked easement 2.
I walked easement too. Yes.
Okay. And you were able to walk easement 2,
No, it's pretty tough.
but you did it.
Yeah, but you needed boots and you needed to keep stuff off of everything. It was horrible.
You've talked a lot about the plastic bottles and the copper heads and the piles of debris that were back there.
Mhm.
Do you have photographs of those?
No, I don't have any photographs that we took. There's some photos of when we cleaned out took the stump out, I believe. There was some from that, but
Did you produce those?
I don't know where they are.
At the time you purchased the property, easement 2 was wooded.
With tiny
Yes,
little
no.
vegetation. No, not really.
It wasn't wooded.
It had those nuisance trees, but it wasn't with hardwoods.
Were you aware that the neighbors, the Darbys, enjoyed easement 2 in its
Yeah.
natural state?
Objection, assumes facts not in evidence.
I can re-ask.
Okay, ask that a different way, without testifying for the Darbys.
Did you reach out to the Darbys at any point in time to ask them how they used easement 2?
No,
You didn't,
we talked with Ann Nikirk though, and she told me nobody used it.
Don't talk about what Ms. Nikirk said. If she's gonna talk, she'll
Okay.
do it tomorrow.
you didn't knock on the Darby's door?
The Darbys didn't live there. Nobody
Didn't
lived
knock
there.
on the Darby's door, did you?
No, no,
Okay. You didn't send them a certified letter?
no,
You didn't call them on the phone?
no.
Did you renovate the interior of your home after you moved in?
We did renovation, yes.
Do you recall ever making an offer to buy the adjacent property, the David property?
No,
Okay. You were aware that it was for sale?
I was aware that it was for sale.
Did you make any offer to purchase easement 2 from the Darbys?
I did not.
You didn't did you contact the Darbys to see if they would modify the easement agreement?
I've never spoken with the Darbys.
So you didn't reach out to them to see if they would modify the agreement?
No.
No more questions about, he's never spoken to the Darbys about anything, even offering him a hot dog when he was making hot dogs. So you don't need to ask any more about his contact with the Darbys.
The Davids purchased their property in March of 2020, a year and a half after you purchased.
Mhm.
So, Mr. Anderson, just like with your wife, when you're answering, make sure it's a yes or a no or a maybe, or I don't know, but the or court reporter, he can't guess or simulate those.
Totally understand, Judge.
Thank you.
It's hard. We all do it. After the Davids purchased their property, did you contact either Mr. or Mrs. David to discuss use of easement two?
I did not.
After the Davids purchased their property, did you contact either Mr. or Mrs. David to discuss clearing of easement two?
I did not.
After the Davids purchased, did you reach out to either Mr. or Mrs. David to notify them that you were going to clear easement two?
I did not.
And you admit you cleared a portion of easement two?
I have.
And we don't have any actual photographs of the clearing taking place, is that correct?
There are probably some out there somewhere. I just don't know where they are.
You do recall that you were sent requests to produce, in this case, asking you to produce documentation related to these claims. That would include any
Right.
photographs that you have. Did
All right.
you,
Well, Mr. Edwards does have any and all photographs that I have.
did you have photographs of the actual clearing occurring?
I don't believe so.
You don't-
I think there was one photograph I've seen somewhere that had the stump guy back there. And that was it.
Okay, and you provided that to Mr. Edwards?
No, I don't believe I did.
I thought you just said that any photographs.
I did, but I thought I saw one yesterday that had that. I thought I was looking at a photograph yesterday that had that machine and equipment back there.
A photo you took?
I don't know if I took it or someone else.
I'm asking you about photos you took. Did you take any photos of the clearing of easement two?
Not that I'm aware of.
You don't know,
I don't know.
but you were asked to turn them all over.
Ma'am, we would turn over everything we were asked to do. So,
You put lighting in a tree on easement two, is that correct?
yes,
Did you contact the Davids to inquire or to ask about placing lighting on easement two?
no, is the fee simple owner of that property? I could put that in the tree.
I'm gonna object.
So, he's free to answer and you can explore why he thinks that if you want. I mean, he is opening a door to exploring legal advice he's received. So, you should move forward as you see appropriate.
Do you still have defendants exhibit 29 in front of you?
Yes,
Okay, and this is the email from John Hocutt to you and some other folks. And Mr. Hocutt's your closing attorney, correct?
29 is a picture. You said 29.
I
So
did,
you're in
I'm
the
sorry.
wrong binder. That's your exhibit binder, and I don't think you've got the defense one. So the only defense exhibit you've got is the paper she's handing.
Okay, thank you.
These complaints. Okay, so we talked about this document earlier. This is Mr. Hocutt forwarding you another copy of the easement agreement
Mhm.
and the survey to the property. And reaching out to you to make sure you understand, correct? And if you need to read through the whole thing, please do so.
No, I mean, it's fine.
Is that correct? He's reaching out
Yeah,
to
he-
you to make sure you understand.
I don't know that he was trying to make me understand. I think he was reaching out.
Okay, well, can you please take a look through the document?
Yep.
Do you know Erica Eaton?
I do not.
I'll represent to you that she was a real estate agent for the Davids.
Mhm. I don't know her.
Did you have a chance to look through?
Yeah.
Okay. You may recall when we did your deposition, there's some Bates numbers at the bottom. That may be the easiest way to get to the page, or I can help you. But at the very bottom, there's an LPA 000282.
Mm-hmm.
Okay. And in this email from Mr. Hokut to you, he provides, well, you tell me what he's telling you.
Objection, are you asking him to read what the attorney says to him?
Well, he tells you, right, that he's reaching out. Is that correct?
Yes.
And he's reaching.
Okay.
Hokut.
Yes.
Reaching out.
Before you go a lot further, Mr. Hearsay, still hearsay.
Sure.
So he can certainly review it and tell you what he thinks is going on, but I couldn't tell from your question. I think Mr. Edwards had the same concern. Were you asking Mr. Anderson to just read straight from it? But he can read it and then give you his synthesis of that.
Did you have an opportunity to read it?
I did.
Okay. Would you agree with me that Mr. Hokut is reaching out to ensure you have an understanding of the easement agreement and surveys and how they apply to your property?
I agree that he was asked by Erica to do that, yes.
And would you agree with me that you responded to Mr. Hokut and
Yep.
told him you had a full understanding?
We do have a full understanding.
And with regard to that, in this communication, there's reference to easement 2, correct?
Mhm.
And there's reference to whether folks are using easement 2 or not, correct?
Appears that way, yes.
And this is regard to, you're indicating that you're not talking about easement 2, is that correct? That you have a full understanding of the use easement 2, and that's not what you're talking about.
I said, John, we fully understand the easement and want you to know it's at the south end of the property.
Okay. And with regard to that easement agreement, did you read the easement agreement again
I've
When-
read it.
when you obtained it from Mr. Hokut?
No, Judge, I object to this. We went through this in his deposition. His understanding of a contract or a deed that is an issue of law for the court is irrelevant. We spent a lot of time in his deposition asking his understanding.
Okay.
He understood they existed, and what the boundaries were as far as legal understanding is irrelevant. And I would ask Ms. Sturm to move on to something that is relevant and admissible.
Well, I do want her to move on, but Mr. Anderson answered a question. As a fee simple owner, I don't remember exactly, I can go ahead and put that light up there, because I'm the fee simple owner. That injects into our case, Mr. Anderson's perspective on what he's allowed to do or not allowed to do in the easement. And I guess really what you need to do to make the finest of points and not belabor defense 29 is have Mr. Anderson share with you what he thinks he's allowed to do under the easement. That's relevant. That doesn't control. That's not necessarily what the easement means, but his understanding of what it allows him to do and maybe what he thinks the Davids can or can't do. You can certainly ask, because that would explain perhaps some of the steps he took or decided not to take.
Thank you, Judge. Mr. Anderson, what was your understanding of easement 2?
My understanding of easement 2 was that it had been abandoned.
And yet you accepted a deed and a conveyance of property that was subject to an easement agreement.
And I'm the fee simple owner of the property.
Okay, but you took conveyance of that property. You purchased it subject to an easement agreement. We just discussed that, correct?
Yeah,
And you were provided a
Yes.
copy of the easement agreement.
yes.
Has been suggesting responses to the witness. Several of us have seen this, and we don't know that it's in her intent. We all sometimes try to, wish upon our witness that, but we'd ask some direction that there not be any of that.
Excuse me, I didn't hear the first part of that, but I think I know the gist of it.
Yeah,
Sure. Mr. Schneider is suggesting that somehow someone, I'm assuming associated with your team, is helping,
No, not you. This young woman over here.
is assisting Mr. Anderson with his answers. And he just wants me to provide guidance. I'm happy to provide guidance. There are very few questions that have been asked that someone could, absent like a microphone in Mr. Anderson's ear, could provide guidance because they are, tell me what happened. Well, no one asks that open question, but he's providing multi-word answers. I did notice that when Ms. Anderson was asked a question that was about recall, hey, when did something happen? She tended to make eye contact with her husband to see if maybe he remembered. It wasn't a big deal, and I didn't comment on that. But that was to me innocent enough of like, hey, do you think it was last year or the year before? It's important that witnesses provide their own independent recollection of the events about which they are asked. So let's make sure that's how it plays out. Did you have anything else, Mr. Schneider?
That's it, Your Honor.
Okay. Mr. Edwards, do you have anything before we bring the jurors?
No, I fully and 100% agree that nobody should be giving signs, and I certainly wish that Mr. Schneider would have mentioned it to me before mentioning it to you.
Okay, well, he wisely didn't mention it in front of the jurors, so here we are. It's all good. Let's see if the jurors are ready. Thank you, Deputy Gordon. Everyone else can be seated. Great job, Juror 1, coming in at the end to get your special seat.
Yeah. I waited, yes.
All right, we are still in the midst of the cross-examination of Mr. Anderson, who remains under oath. Ms. Stern, when you are ready.
Thank you, Judge. Before we broke, Mr. Anderson, I believe I handed you a document.
You did.
Recognize that document?
You did?
Okay, and that's the easement agreement?
Yes, it appears to be.
Excuse me?
It appears to be, yes.
Okay. And this is the easement agreement you received at closing and from Mr. Hokut following.
Okay.
Your Honor, we would move to admit
We've identified it as Exhibit 1, Defendant's Exhibit 1.
So this is in your binder. Really small print. You're able to read that?
Barely.
Okay.
It took glasses, Judge.
Okay. Any objection to Defense Exhibit 1
Well-
being admitted to the record?
Being admitted into the record, no objection whatsoever.
It's admitted.
Showing it to the jury, yes, we have an objection because that gets into legal conclusion and argument of legal arguments and all of that. That's an issue of law for the court. We don't want the jury to get confused by trying to figure out what these meets and bounds mean and what the language of the easement means. I think that's improper. She can ask whatever questions she needs to ask, potentially that might be proper, but I don't think she should show the jury the document and start asking, did you see this? Do you understand this word? Do you understand this phrase? That's
So
completely
I agree
improper.
with a little bit of what you said. 1, D1 is admitted, so it's in the record. 2, I think you can publish any part of D1. 3, it probably will go back with the jury. Don't have to decide that right now. Or you can ask Mr. Anderson questions about different parts of the document, especially if you can make it legible. But 5, you may not ask him to share his sense of what the legal significance of any of that language is.
But Judge, beyond that, under 13-2-1, this little novel legal theory called parole evidence rule is inadmissible to add to, take from, or vary a written contract. That's the whole purpose of this. She wants him to say, do you see this? Do you see? Of course he sees it. But asking him his understanding is directly prohibited under 13-2-1.
Okay, so fair point. I guess it depends how she's gonna ask the questions. I just want to make clear, I don't think that any of this shouldn't be published if Ms. Sturm wants to publish it, but you're right. She's gonna need to be careful about what she asks about that document. All right, E1 is in.
Am I able to share or on this system through the Zoom?
Are you on? You're Jeffrey Schneider, you can share. Why don't you start asking some questions while Mr. Schneider tries to figure this out? We got a witness just sitting there looking at himself on the screen.
Rather, I have.
You got it? All right, Mr. Anderson,
Yes,
what we've labeled as E1, this is the easement agreement
yes,
for your property, correct?
yes.
Okay, and were you able to share it, Jeff? And you were provided this agreement at closing and following,
I believe so, yes.
okay? And if you read down on the first page, it says we have 2 easement grants. On the first page, we talk about easement 1, is that correct?
It's hard to read, but it looks that way.
Okay, let me, it
I
appears.
I can't read this.
Okay, it appears Mr. Schneider's having a problem. There it goes. No,
Yep.
Yeah, there it is.
there you go.
Done for the day.
And I,
Drops the mic. Walks out of the room.
well done. And I believe, Mr. Schneider, if you can, you're able to zoom from your, yes. Is that showing up on your screen as well, Mr. Anderson?
Yes, ma'am, it is.
Okay, very good. And can you tell us what easement 2 says?
Which paragraph?
You're gonna need to guide a little.
Yeah, I mean, this is going up and down like a yo-yo.
There you go. We're on the second page of the document. You see number 2?
Yes,
Okay. Can you tell us what easement 2 says?
grantor hereby grants, bargains, sells, and conveys to grantee, his successors, and assigns for the benefit of all pertinence to the guarantee property a perpetual exclusive easement over, across, and under easement area 2. Grantee may use easement area 2 for any legal purpose whatsoever, which uses may include, but shall not be limited to the construction,
Don't
installation,
read too fast, because the court reporter needs to take all this down.
but shall not be limited to the construction, installation, and use of a driveway connecting the grantor property to West Andrews Drive, provided that such construction, installation, or use is not in violation of then current building and zoning requirements. Grantee shall have the right to maintain or cause to be maintained all improvements and structures it elects to construct within easement area 2. Grantor acknowledges and agrees that grantor shall have no right to interfere with grantee's use of easement area 2.
And if you scroll down, Mr. Schneider. If you've gone too far afield, go back up. Thank you. Nope, right there. That is number 4 as part of this easement agreement. Can you tell us what that says?
Grantor shall be obligated to pay ad valorem taxes on the grantor property. Shall be obligated to pay ad valorem taxes on the grantor property, including but not limited to those taxes applicable to the easement areas.
Okay. And this agreement was provided to you before and after you closed on the property.
Yes.
Is it your position, Mr. Anderson, that it's okay for you to clear easement 2, but it's not okay for the Dobbies to be on easement 2?
No,
I haven't said that. We have the exact access to both the easements that the Davids do. And that's what the appellate court told us.
So let's not get into what an appellate court may have said or may not have said.
I would move to strike that portion of the answer.
All right, so you all, members of the jury, should strike, not recall, not rely on Mr. Anderson's non-lawyer opinion as to what an appellate court may have said in this case.
Mr. Anderson, is it okay for the Davids to sit on easement 2?
Right now, today it is, yes.
And it's okay for the Davids to walk through easement 2?
Today,
And it's okay for the Davids to have sports equipment on easement 2?
I mean, I look at easements differently than you do. I view an easement as a way to pass across an area, not go and put sports equipment and all this stuff on it. And so, no, I don't agree with that.
And you read the easement 2 on the easement agreement.
I did, but that's why we're in court.
You've taken a lot of pictures of the Davids on easement 2, right?
Not a lot,
No?
a few.
You photographed their son on easement 2, correct?
I have, yes.
Okay, and he was out there practicing lacrosse?
No, he was just running around doing stuff. He wasn't even throwing the ball around then. Last time I saw him.
You've not ever seen him out there playing lacrosse?
I told you earlier, maybe 5 or 6 times in this whole time. Okay.
We're gonna pull up a video, Defense Exhibit 12.
It's already been
It's
admitted.
been produced, it was taken by Mr. Anderson, it's
Okay.
been
It
produced
wasn't
to
one
us.
of, okay,
It's not one of the ones that
they admitted.
they admitted.
Okay.
Objection.
I'm sorry, it's D16, Randy.
I think that's already in. So if you're able to make it play. Oh, D16.
D16.
Oh, you're switching to you now.
Yeah.
Okay.
But we'll see,
Your Honor, may we approach for a minute?
Because,
Well, if, before anything's published to the jury, perhaps she needs to move the view of her laptop.
okay, let's just do that. What would be great is if the David team could figure out, you got 2 lawyers here, if someone could pull something up and you keep asking Mr. Anderson questions. We have a lot of pauses.
Jeff, are you able to pull that up? Okay, Mr. Anderson, do you recall filming the David's son when he was out on easement 2 with his lacrosse equipment?
Yes.
Okay, do you recall him telling you he did not like that?
No, I didn't recall him.
You don't recall that?
I don't recall.
Okay, and do you recall him telling you his age and how he didn't like you filming him?
I don't recall, but the reason we filmed is because the lawyers wanted me to get, anytime people were over there and we saw it, to get it on tape. And that's what we did. It's nothing against that little boy or anything else. It's just anybody that was over there, if I had a video, I was going to get a video of it.
Okay, did you film any of your workers out on easement 2?
I haven't had any workers out on easement 2 since we started this lawsuit.
Did you film any of them out there on easement 2?
I don't believe so.
Did you film any times you've been out on easement 2?
Just other than showing like where the path was that Mr. David cut and the other stuff, other than that, not really.
We will work on getting the video up to play. In the meantime, I will continue on. Jeff, if you'll let me know when you get it, we will take a moment to listen to it. Um. Oh. And if you can turn up the volume. Judge, I think it. We will have to work out the kinks, and so you can hear the audio from here.
That was progress, that video actually.
Video played. Mr. Anderson, you took that video?
I believe so, yes.
Now you testified earlier, that in this video, we do see Hopkins, the David's son, picking up his phone.
Yes. He started videoing me.
You don't know that he was videoing you,
Boy, he was holding the camera up like somebody's videoing it.
but you don't know whether he actually videoed you.
I don't know, but it sure appeared that.
Okay, and you don't know if he actually took any photographs of you at that time.
I don't know that.
See, I've got it.
Oh, we're gonna try again. Let me move to a different area for a moment and we'll come back and address, yeah, you're gonna have to mute on your end.
Go ahead.
Mr. Anderson, you installed a fence along the border between your property and the David property, correct?
Correct.
And when you purchased the property, there was no fence there.
No,
And it was your intent, was it not, to extend that fence all the way down?
we were going to extend with a chain link fence from the wooden fence down and put a gate in the middle of it.
So you built a fence between your property line and the David line, property out of wood.
That's correct.
Okay, how tall is that fence?
6 feet.
Okay, and then it was your intent to fence, chain link, install a chain link fence from where the easement 2 starts along the property line between your property and the David's property, all the way down.
That was the intent.
Okay, and then it was your intent also to put a fence on the opposite side along West Andrews, correct?
We discussed putting a fence along there.
The we is you and your wife.
My wife and I, yes.
I mean, that was part of your landscape plan, is that not correct?
Well, I mean, you say part of the landscape plan, that was a presented plan to us. We never approved that final plan. And we haven't acted on it.
But you asked for the landscape company to put it together, correct?
Yes, I did.
Okay. Is it also your intent to put sod on easement 2?
We were discussing that, but nothing was finalized.
It was part of the landscape plan though, was it not?
It could have been, yes. I'd have to go back and look at it.
Okay.
I know they wanted to take a lot of stuff down. They wanted to clear out all that frontage on the street of all the junk and potentially put a wall in there.
Let's take a look at your landscape plan. Mr. Anderson, tell me again, who were you working with on landscaping? Is that Alec?
Alec Michelatis.
Okay, and I'm gonna bring you up a copy.
Just give me the number.
Okay, D33.
33.
33. D33. Mr. Anderson, you familiar with that document?
I believe so.
Okay.
I think I've seen it before, yeah.
And you know the folks from Land Plus, that's Alex's company, is that correct?
Correct.
Okay. And this is a landscape plan for a portion of your property, correct?
That's correct.
Okay. And it shows from the house or most of your house all the way back to the end of easement 2. Is that correct?
Mm-hmm.
Okay.
Yes.
Yep. And just by way of reminder for the court reporter, yes or no, but, and you had a landscape plan for the front portion as well at the same time, is that correct?
No,
No?
no.
Okay.
We were looking at the north and southern ends of the property.
Did you have a
Middle.
plan at one point in time to put a pool on the front end?
No, not yet. We've discussed it, but we haven't planned it.
Okay. D33, this is the landscape plan for about your house going back to easement 2.
Mm-hmm.
Yes.
And
Yes. Sorry, Judge.
I'm about to, Your Honor, we would move to admit D33.
Edwards, any objection to defense 33?
Other than relevance, but no.
Okay, I'll admit it.
Excuse me. We're only seeing half of it, Jeff. There you go. Okay. Now, can you show us the wooden fence portion and what you were talking about, the chain link fence?
Yeah, so it goes down from, here's the garage. You see the garage? The fence behind there goes all the way down the property line, right to easement area 2.
I think you have a tool on there that may allow you to mark.
Not working right
Oh,
now.
it's not working.
No, we've made a request to IT and I don't know where IT is.
Okay. So I will come up here and can you tell me if I am correct? This area down to here is the wood fence.
That's correct.
Okay. And then here to the end of the property is the chain link fence.
That's what we were looking to do. We
Okay.
never did it.
And this break here, this marks the start of easement 2, correct?
I believe so.
Okay, and if we take that and compare it roughly with the easement and go down that area, once we draw that line perpendicular across, the area to the left of there would be easement 2, correct?
That's correct.
And that shows a landscape plan you had designed for the use of easement 2, correct?
That's correct.
And if we look down along West Andrews on this landscape plan, there's an indication of stone columns and a wood rail fence. Is that correct?
That's something we were discussing.
Okay, and that extends all the way from near the end of your garage down to the end of easement 2, correct?
I don't recall the plan, but that looks like that's what it is. Yeah.
Okay, I mean, you can look on the plan.
Yeah, no, I see it right here.
Okay, so it
Yeah.
shows up on the plan now.
Yeah.
And Mr. David was in town when workers were out there installing the fence. Is
Mr. David was in town?
that correct?
I believe he was, yes.
Did you have an interaction with Mr. David that day?
I don't believe I did.
You don't? Okay. Do you recall any of your workers contacting you about the fence?
No, I can't recall.
Did you ask the workers to stop?
Yes, I did.
You did.
I did.
Okay. And when did you do that?
Well, I called Mark Rushi, okay, and he told me, he says, go easy on the,
Hold on.
Don't talk about attorney-client privilege.
okay.
Once that cat's out the bag, it's out.
Do you know what date you contacted the fence workers and told them to stop?
I do not.
Okay. Were you on site when this was happening?
I was in and out that day.
Do you know whether Mr. David asked the workers to please not put the fence along the easement area?
I believe he might have done that, yes.
Okay.
You didn't have any discussions with the Davids about installing the fence,
I did not.
and you didn't have any discussions with them about putting it down easement two.
I did not.
Were you upset that Mr. David asked them to please not fence the easement area?
I wouldn't go like really upset, but I wasn't happy about it, no.
He hands you, it's a D34. Do you recognize that document?
Yes,
And this is an email from you. Who's Mr. Mullins?
he's at Land Plus,
The company that did this, the
Andrew Mullins. Yeah,
same company that did the landscape plan.
he works for Landscape Plus.
Okay. And did you make a comment to Mr. Mullins? It's also Mr. Golitis?
Now, I wrote to Mullins for sure and Alec. And what I told them was I'd spoken with counsel and they said, hold off on the fence for now. Just hold off on the fence for now and we'll we're going to probably have to litigate it out.
That's what you told Mr. Mullins and Mr. Mikolitis.
Yes.
Okay, what's the date of this email?
10/5/2020.
And you tell them, stop the fence, I'm gonna begin my legal fight.
I said we're going to have to probably have a legal fight. I will begin the legal fight, yeah.
I will begin the fight with my legal team shortly after, but the polls must be removed for now. Is that correct?
That's correct.
We would move to admit D34.
The objection to D34?
No, sir.
Okay. Admitted. Let's admit before we get into contents next time, sort of, I don't know what
Sorry.
Mr. Edwards would object to by now. Contents already.
Mr. Anderson, you had some communications with, well, before I ask you that, you did in fact bring a lawsuit. You brought this lawsuit.
Yes, I did. And it's because you threatened me with putting a lien on my land.
We didn't file a lawsuit, did we? The Davids didn't file.
You threatened me with a lien. You used a very threatening letter to come at me where I felt I had no choice. You did that.
Okay, Mr. Anderson, you filed this lawsuit, correct?
Yes,
The Davids did not proceed with a lawsuit against you.
they didn't because I went first. And I did that strictly to protect my property and my home.
You didn't contact or reach out to the Davids and say, let's talk about easement 2 and maybe even my landscape plan.
No,
Okay. You just filed a lawsuit.
no, we filed a lawsuit, yes.
Let me ask you about these communications with Mrs. David. You've only seen her once?
Well, I've seen her from the house driving in, but after that one time, that one incident, I haven't seen her at all. I haven't yelled, talked to her, haven't done anything.
After calling her a fat bitch, you haven't seen her again.
I've told you, you're putting words in my mouth. I told you that I've seen her driving in, or driving around the neighborhood, and maybe a time or two saw her get out of her car from the house. But other than that, nothing.
Okay. I'm just wondering, because when Mr. Edwards was asking you questions, you stated that you'd seen her one time in person.
That's true. But I mean, if you call in person is in person, being there. It's not through the window of a house.
Okay. So if she was getting into her car and you yelled out, that wouldn't be in person.
Number one, I never did that. I flatly deny that. I resent that. I resent that so badly you have no idea. I really do. I resent that. And the jury needs to know that's false.
And you didn't see her or her son getting into their car?
I've never seen her and her son getting into the car.
Okay.
You can't see people getting in the car because it's 10, 12 feet below. I can't see anything that goes on. When I walk from the house to our garage, you can't see anything that they're doing up there. I would have to go all the way up to be able to see that and to see them. So no, I haven't seen them.
Okay. And so it's your position, it didn't happen and it didn't happen in front of her son?
My position is I've never said that.
And the gun, we heard you with Mr. Edwards. Is it possible that, I mean, you don't deny you have a shotgun?
No,
Okay. And you don't deny that you took it out of the car and brought it to the garage?
no, I took it out of my car. It was encased. If any of you have shotguns or know, you know, you put them in a nice case. Okay, that case is sealed. Okay. I went from my garage. I didn't even notice the boy was over there until I went down to the mailbox and I looked over and he was there. So all I did was simply walk back up with my firearm and put it in safe storage in the house. We have gun safety.
Is it possible that Miss Hopkins David would have, are you?
We'll finish it off.
Okay. Is it possible that Hopkins David may have interpreted that in a different way?
Objection calls for speculation.
Correct, sustained. Don't answer the question. The objection's been sustained.
Let me hand you Defendant's Exhibit 26. Is this a survey of your property?
Appears to be, yeah.
Okay, and you have several surveillance cameras on your property, is that correct?
Yes.
Okay, you have 9.
7 active.
7 what?
7 active.
7 now active?
7 now active and 2 have been out. I took them out for probably about a year. The one on the front of the garage, it just picked up too much road traffic on West Andrews.
Number 3?
I'm sorry.
Oh, you may not know. I'm just looking at this exhibit. So that would be number 3 on the exhibit.
Number 3 would be the driveway. Yes, sir.
Okay.
Did you identify the location of the surveillance cameras on here?
Yes.
And when is it that number 3 was removed?
It got knocked off probably a year ago. It's in my garage.
And Mr. Anderson, have you produced any video from camera 3 or any of the other surveillance cameras that show you taking this gun from the car to the garage house area?
No.
No. Okay. Now you do have surveillance cameras that capture the entry of all your entry points.
Yeah,
Is that
but
correct?
we erase those daily. Those get erased daily unless there's something you think you need to keep.
So if you didn't want somebody to see the gun, then you would erase it.
Number one, you couldn't see a gun because there was no way of telling it was a gun because it was in a case. So Mr. Young David did not have any idea if that was a gun. He could only speculate.
Did you produce any pictures of the workers going across your property, not easement 2,
No,
from the surveillance cameras?
no.
And you talked about Mr. David and a gentleman that was out on the property recently,
Yes,
week from Sunday or so
yes,
ago.
yes.
Do you recall talking to them while they were out there?
I said, yes, hey, see you next week.
Did you say, see you in court, big boy?
No, I said, I'll see you next week.
Okay.
That's pretty much what I thought I said.
And I believe you indicated that you have readjusted some of those surveillance cameras. Is that correct?
Yes,
So during the time that the Davids have lived next door, during the pendency of this suit, you have adjusted the angle of some of those cameras?
yes.
Mr. Anderson, that is all I have for you this afternoon.
Thank you, ma'am.
Yes.
Any redirect?
Yes, sir.
What? Mr. Anderson? Share my screen. Just pick up where we were a minute. Oops. Pick up where we were. You mentioned, in Ms. Sturm's questions that you have seen a picture recently of some work being done on easement area 2. Do you
Yeah, I
recall
thought I
that?
saw a picture of that, yes.
Okay. Defendant's Exhibit 8, I assume there's no objection to Defendant's Exhibit 8?
Sure.
I assume there's no objection to Defendant's Exhibit 8?
Is that what's on the screen?
Not yet.
No.
Okay. Defendant's Exhibit 8
All right, it's admitted.
is admitted. Is this the picture you're referring to that you've seen recently?
I'm not sure I'm following the question.
You told Ms. Sturm that she's asking you about pictures that
Yes.
you may have taken in this, that, and the
Yeah,
other.
yeah, that's the one that has the, now I see. That's the one that had the stump remover.
Is that the picture you're referring to?
Yes,
And
the picture I was referring to.
when we produce documents in a case, we put these little Bates numbers at the bottom.
Right.
Is this a document that they produced or we produced?
Well, it looks like they produced it.
Okay. Let's stop that. Defendant's Exhibit 29, I'm not going to show it to the jury, but do you have that in front of you? Do you have that with you?
I have it, yes.
Okay. And talking about the conversation, did you take a moment and look at your email to Mr. Hokut on June 23rd at 7:36 p.m.? Take a moment and look at that, then I'm going to ask you some questions.
Understand it?
Okay. Did you express any concerns about the workers using your property for ingress and egress outside of the easement area?
I did.
Did anybody apologize to you for that? Say, we'll
No
stop
one.
it. Did you indicate one way or the other was whether you wanted to be good neighbors or bad neighbors with the Davids?
I didn't indicate, there was no indication either way.
Well, look at the third line. We want,
We want to be good neighbors. Yeah, I mean, I agree with that statement. But when you get yellow ribbons put up on you and goals and other stuff, it's just kind of untenable.
you asked about times you've seen young Hopkins playing lacrosse out there. We've seen a couple of videos. Have you ever actually seen him practicing lacrosse, slinging the ball and that stuff?
Not really. I mean, it's just so wet back there. It's kind of hard to do. So
Okay. The alleged gun incident, we saw the video. They got it to play better than I did. Defendants Exhibit 12, no objection?
Objection.
Do you remember in that video that Hopkins appeared to pick his phone up and either start taking pictures or videos?
Yes, it appeared that way, yes.
Defendants Exhibit 12, it's my understanding from defense counsel, this is the photograph that he took that day and that there are absolutely no other photographs or videos that he took. Do you see a gun anywhere?
No.
Given the history with the Davids, let me withdraw that. I was going to ask you to speculate. Did the police show up at your house shortly after this incident of the alleged gun waving?
No.
Waving. Or the alleged gun incident, did the police show up?
No.
All right, plaintiff's exhibit 38 is a picture of the fence from the easement taken by Mr. Elrod as part of the inspection. No objection to that?
No.
Plaintiff's exhibit 38, this is a picture of the fence from, well, tell us what this is.
This is the fence I constructed from easement area 1 down to just before the beginning of easement area 2. And that was done to keep construction workers and other people from coming up my driveway and going, if you look along where the side of the garage is, there's a path there, you can see it. And when I built that path and there wasn't any fence, people would just walk up across there and across into the David's yard.
Okay. And did you intend to extend that fence across easement 2?
Yes, I wanted to, again, we were going to put the chain link fence in at the very southern end.
And did you in fact extend the fence?
Did not.
And same with the landscaping. Did you intend to do a lot of landscaping in easement area 2?
We wanted to, yes. We intended to.
I haven't seen those pictures. Has that
No.
landscaping been done?
Nothing,
Why not?
because we are in the middle of litigation right now, and I don't want to do anything that could upset that.
So what you intended or hoped to do, you didn't actually do. Is that correct?
That's correct.
Pretty leading.
I apologize. I knew you were going there halfway down the sentence. Let me rephrase the question. Well, the jury knows the point. Let me go back to defense exhibits. Defense exhibit 33 was the landscape plan, just so we're on the same page. Do you know the date of this landscape plan?
It was like within the first 12 months of us living at 3350, I believe.
Okay. And again, why was this never implemented?
Well, the cost was astronomical, so we were looking at that, and I think Claire made the decision she wanted to get the inside of the house taken care of before a lot of the outside.
So your wife made the decision and you saluted smartly.
I did indeed.
Okay. Talking about, obviously, we filed this lawsuit. The record will reflect when it was actually filed. What was the precipitating event immediately before filing the lawsuit? Or was there one?
The letter,
The letter?
Ms. Stern's letter,
What about the
threatening,
stalking order?
yeah, I mean,
Objection, Your Honor.
they were trying to say I was stalking and all this other stuff. I've never seen this woman more than one time.
Okay.
One time.
So you can ask him if there's anything else, but let's not feed him the answers.
Nothing further.
Okay. All right, Ms. Medwick, did you have anything?
No, Your Honor.
Ladies and gentlemen, if you got any questions,
Can I do one cleanup on, it was
if it's 2 questions or less, you can do
Oh,
2
no,
questions.
D26, can we just get it moved to admit it? I don't,
Yeah, it's not in? We didn't close the loop on that?
I don't think we closed the
Okay.
loop.
Defense 26 is admitted.
Thank you.
All right. So ladies and gentlemen, I'm going to ask you to write your questions if you have any. We're not going to go through them today because we're out of time. But if you've got questions, take all the time you need to write them down. And what we'll start with tomorrow will be your questions for Mr. Anderson.
No more questions?
Well, we can actually get through these. They're not so many. I thought there were going to be more. So let's knock that out. Why don't you quickly look at, I plan on asking all three of these. Next to that. Oh, thank you. The issue is getting the touchscreen to work.
I tried earlier, it didn't work. Sorry. It's okay.
Yeah.
Great. Yeah. If it's not an easy fix, you'll actually have all tomorrow morning to fix it, because we don't start till after lunch. Is it not playing nice?
Yeah, no. It might be better to give it another question.
Okay. Can I get that on your list for tomorrow morning?
Yes.
Thank you. Appreciate it. All right, Mr. Anderson, you don't need to read that yet. That'll come into context in just a moment. Couple questions. Did you, in one of your answers to one of the many questions you fielded this afternoon, mention that you adjusted the angles of some of the security cameras?
I did.
Okay, why'd you do that?
We adjusted them because they were saying that we were pointing them at their house and we weren't. I was just putting it, it's on particular points of the property where you can show going into doors, entrances and other things. There's not a single thing that points to their property at all.
But what
Nothing.
did you adjust if nothing was pointing at their property?
Well, I think one of the cameras in the back, on the side of the house, might have been a little angled up more than it should have been, so I brought it down.
Okay. There was a situation where you yelled what you yelled to Ms. David.
Yes.
After she had been allegedly talking to the folks working on your yard.
Yes.
You know, the one we're talking about. Do you know how much time passed from that exchange and the restraining order, TPO, whatever we're gonna call it, being taken out? That's just the document. That was to give you a
So,
framework.
so it was, I believe it was a couple weeks later, if I'm correct, but she called the police that day and they came to the house.
Okay, and then a few weeks later-ish.
All of a sudden, the sheriff's deputy show up. I was in shock. I mean, I've never had anything like this ever happen to me in my life.
But the answer to the question is, it was probably a few weeks later.
It was a few weeks later.
Okay. Last question, explain to the jurors, if you will, if you can, why, as a CEO, guy who runs a big company, et cetera, you didn't simply tell your neighbors, hey, we can't get to our garbage cans. You need to move your stuff, or have people park in a different way, because we need to be able to get to our garbage and get it out.
Right. That's a fair question. We really, I don't recall doing that and probably should have. But Mr. David, after it was happening, he came over to the house and he saw clearly, that our garbage cans were being blocked by pickup trucks and other construction workers.
that were along the way. So that was,
Do you have any follow-up based on those questions, Mr. Edwards?
Yes, Tracy, briefly, the document that I handed you a moment ago, the TPO order. What is, at the top of it, it's got a filed date from the courthouse. What's the date that was filed?
3/19/21.
And if you flip back a few pages, we've got the petition. And then there's a page where Miss David signed it, got a little notary thing on it. Says sworn to and subscribed before me.
Yes,
What's the date of that?
8th of March, 21.
Nothing further.
Any follow-up, Ms. Sturm?
No, Judge.
Okay. Ladies and gentlemen, we are about done for the day. Tomorrow, we start at what time?
1:30.
1:30, so be here. The shuttle doesn't run as frequently in the middle of the day. So if you're relying on the shuttle and think, hey, if I get here at 1:28, I'll get on the 1:29 shuttle. There's not a 1:29 shuttle. So get here in time enough if you're parking in one of those lots to catch a shuttle. So you're here by 1:30. Feel free to bring a lunch, but don't expect to get a lunch break. Are we able to go a little past 5 tomorrow? Did you all talk? Okay, we'll see. We may have a natural break point at 5:10 and we'll just stop at 5:10. But if we've got some good momentum, you're into what's happening, I'd like to use as much of your time as we can get. After you leave, I'm going to talk to these lawyers about where we are in their time estimate, because they represent it to me and then I represent it to you. All right, let's get on the record. We've got everyone and we are ready to go in the Andersons versus the Davids. We are still in the midst of the presentation of plaintiff's case on Wednesday afternoon. All our jurors are here. Mr. Edwards, anything we need to discuss before we bring our jurors back in?
No, sir.
Ms. Sturm, anything from the defense side?
No, Your Honor.
All right, let's get the jurors, please.
All right, jurors. Jurors, in the count of 4.
Thank you, Deputy Gordon. Everyone else can be seated. Good afternoon, ladies and gentlemen. Hey, great to see you, Judge. Welcome back to 9J. It's always interesting to see jurors on day 2, to see different outfits. Every once in a while, I get a juror who doesn't change clothes throughout a trial. He or she usually ends up being left way over in the corner. But thank you all for being here pretty much on time. We had to tackle a couple things before we could bring you out here. Just a refresher, we are in the midst of the plaintiffs, the Andersons' presentation of their case. They called witnesses yesterday. They have a few more witnesses to call today. One may be appearing via Zoom, in which case you'll see that witness on that big screen right there. If that happens, Mr. Williams, our court reporter, is actually going to move around and will be facing the screen so he can see the person who's testifying. His back will be to you. Otherwise, things will be as they were before. One thing we worked through before you came out here is that the touchscreen now should be working. If anyone needs to mark something on there, we don't have to get them up out of their seat and in front of that monitor. So we'll see how things go. And we will have a break kind of mid this session. And then we'll go a little past 5. It'll really, when we stop, will depend more on where we are with the flow. That doesn't mean we'll go till 8. I don't mean that at all. But if there's a natural break point at 5:20, we may not push all the way till 6. For example, if one side rests, there are a whole bunch of things the lawyers and I need to talk about when that happens that you don't need to be here for. So we'll see how it goes. All right. Mr. Edwards, if you would call your next witness, please.
So Jean-Noel David for cross-examination.
All right. Mr. David, if you would come on up, please.
Raise your right hand. You swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, self you got. Go ahead and have a seat. Can you state and spell your name for the record?
Yes, I'm Jean-Noel David. Jean-Noel-David.
Mr. David, good afternoon.
Good afternoon.
Make sure when you're answering questions that you speak slowly. I've only heard a few words, but they came out quickly. And I make sure the court reporter is able to take all that down. Okay,
Absolutely.
great.
Good. Thank you, Mr. David. And also, I understand English is not your first language, but it is one of several languages in which you are fluent. Is that right?
Yes.
So if by chance I ask you a question and you are not sure of the word or what I mean, please ask me to rephrase it or explain it so we're on the same page, okay?
Yeah.
All right. And I'm just preparing for what I'm going to be doing in a little bit. So let me just pull up an exhibit that the jury has seen so I don't have to worry about sharing too much at this point. There, the preliminary plat. Now, Mr. David, you just were sworn in by the deputy to tell the truth, right?
Yes.
And you have been sworn in to give testimony in this case a couple of times, right?
Yes.
The first time is in your verified answer and counterclaim, right?
Yes.
Okay. And I'm going to show you a copy and hand a copy to the judge. Stacy cares.
Thank you, sir. I care.
I'm going to share a copy of it with you. I'm not going to introduce it in evidence, but I just want you to have it when I refresh, so we can refresh your recollection, okay? So these answers to the counterclaim, if you flick over to the last page, and I didn't attach the exhibits, but the last page is a verification where it says personally appeared before the undersigned officer, a notary public.
Which page?
The very last page. Yes. Very last page. That's your signature on May 24th, 2021, correct?
Yes.
And you say, having been sworn, deposes and states that the facts contained in the foregoing counterclaim are true and correct to the best of her knowledge. That's a typo. It should have been his knowledge. But everything in the counterclaim, the factual averments in the counterclaim, were true and correct to the best of your personal knowledge, correct? Okay. So what I'd like you to do is turn to page 9 of the counterclaim. Or excuse me, page 10 of the counterclaim. And there's an allegation in paragraph 9 about conversations that Diane Darby supposedly had with the Andersons regarding her uses of the easements. Do you see that?
Yes.
And you state in the counterclaim that Miss Darby notified the Andersons of the ongoing use of the easements and directed the Andersons not to interfere with the sole and exclusive use of said easements by the David property during their ownership of the same, right?
That's what's in it, yes.
And you swore that that was true and correct and based upon your personal knowledge, correct?
Yes.
Please tell us the source of that personal knowledge supporting that allegation in the counterclaim?
The source,
How do you know that to be true?
we've talked to the Darbys over time.
And Ms. Darby confirmed to you that she had spoken to the Andersons and explained to them the exclusive rights of the easement to the Andersons.
It was conversation between my wife and I, and I remember the Darbys were around. Yes.
Okay. That's fine. Paragraph 29 of the counterclaim, which is a few pages back, about top of page 14. You say, defendants installed a spike fence.
I'm sorry, defendant stall, go ahead.
Defendants installed, meaning the Andersons, counterclaim defendants. This is for your counterclaim. The defendants, or the Andersons, installed a spiked fence along the border with the David property, which appears to be constructed to close the property line and potentially encroaching on the David property. Now I want to focus on spike fence. Explain to the jury what you meant in May of 21 when you used the term spike fence.
Offensive?
Offensive? Now, you remember I took your deposition in this case, right?
Correct.
And you explained to me in your deposition that spike fence is not a term that you use, correct? You remember that?
I remember that.
So in the counterclaim, was that your term, or was that a term that the lawyers put in there and you signed off on it?
My wife explained that term to me.
So it wasn't based on your personal knowledge, it was based upon your wife's personal knowledge.
But wouldn't
I
it
don't
be his
understand.
personal knowledge if she explained it to him?
Well, if my wife explains to me that she went to Kroger, do I have personal knowledge she went to Kroger?
Your wife,
All right.
to you.
So that's not a term that you use, that's a term that your wife used.
That's a term that I've heard in the past, yes.
Okay. Now, let's talk a little bit about the history of some of these confrontations that you have personally had with Mr. Anderson. Regarding the trash, you had a person, you can put that down. Actually, I'll take it away if you don't, because we're not going to use it anymore. I'll put it right here in case it's You had a discussion with Mr. Anderson about the trash in the dumpster, correct?
Correct.
And you went over and rang the doorbell and walked around and he was cooking hot dogs on the grill, is that right?
I don't know, it was hot dog.
He's cooking something on the grill.
Yes,
And you spoke to him about the trash, right?
correct.
And he explained to you why he did that or why it was done, right?
Well, no,
He did not.
he did not.
What did he say?
He says my son-in-law did it.
Didn't give any explanation about the trucks.
It'd be easier if your workers don't park in front of my trash can.
And what was your response?
I'm sorry.
Okay. And did it happen again after that?
What happened after that?
Did trash continue to be put in the dumpster by the Andersons or their relatives after you had that discussion with Mr. Anderson?
I don't know.
Okay. So as far as you know, you can't deny that that issue was resolved with that brief, short interaction between you and Mr. Anderson, right?
I'm sorry, I don't understand the question.
I'll move on. The fence, the spike fence, you objected to the spike fence going across the easement area, correct?
Correct.
Did you object to Mr. Anderson directly or to someone else?
No, it's the worker that was on the, that was doing the work.
Okay. And that was resolved, was it not?
Well, they stopped. Yes,
Okay.
yeah.
So it was resolved.
Define resolve?
Is there, this morning when you got up, was there a fence of any type
On easement two?
on the easement too?
No,
So at least as of today, that issue has been resolved. True?
right.
Okay. And the sod issue, that was an issue that your wife raised, right?
Yes,
You did not raise that issue with anyone, did you?
there is side on the easement too.
Well, and have you measured that so that you can tell us, Mr. Edwards, 24 square feet of sod or 10 square feet of sod or whatever is on easement 2?
I have not measured.
Okay. Can you give us a ballpark? Is it 1 linear foot into easement 2, or is it 20 feet, or what?
I don't know, closer to 1 to 2.
Okay. In all this time that we've been litigating this case, and all the money y'all have spent on experts and other things, have you hired an engineer or surveyor to go out there and say, I have measured the easement and the sod encroaches by X feet?
I have not.
Okay. So that's your opinion that it encroaches onto easement 2 by some undetermined amount?
No,
It's not?
no,
That's not your opinion.
it's not.
Whose opinion is it? Where's that coming?
It's the survey of the easement.
Who did the survey?
McClung? McClung. McClung. Sounds about right?
So Mr. McClung has in fact surveyed easement 2 and reported that X number of feet of sod encroach upon easement 2.
No,
All right, we're not connecting here.
currently.
Other than yourself and perhaps your wife, are you aware of any other person who's going to come in here and tells this jury that X feet of sod encroaches on easement 2?
If they have the survey in front of them, yes.
Who has done the survey?
McClung.
Well, the question is specific, not a general survey. Did he do a survey to determine how much sod encroached on easement 2?
He did a survey on the easement.
I understand that, and that's not my question. Did he perform a survey of the easement that says X number of feet or inches of sod encroaches on the easement, yes or no?
No,
Now, I understand that you used to before any of this clearing and grading and all of that stuff allegedly happened, you would personally use easement 2 for ingress and egress for things like your morning runs, right?
yes.
And let me go to what was introduced yesterday as Exhibit 13.
Can't see anything here.
It takes a second to sync up.
One second.
Maybe
What is the,
it says, do I need to unmute or anything?
don't do unmute. So if there's a stay mute, what are the two choices?
Stay mute.
Stay
and-
mute, hit that one. And then
Got
what's
it.
the,
Got it.
got it, you got it. And now, excellent. Thank you for flagging.
Thank you.
All right, so I'm sharing my screen, and during this morning, we figured out how to at least move the video. I can move it with my finger. And you recognize this as a video of the frontage of easement 2 taken on August 12th, 2021, of where easement 2 fronts on West Andrews, right?
It's a portion of it, yes.
Okay. So we see, do you see just kind of to the upper right from where the start arrow is, a blue ribbon?
I don't.
See right here, a blue ribbon?
Looks yellow to me.
That's a yellow
Oh, yeah.
power line,
Yes,
and to
yes.
the right is a blue ribbon. That is the south edge of easement 2, correct?
Yes.
Okay. So what I'm gonna do, and I believe you have a little highlighter there that you can use on the screen and touch and highlight something. So what I'm gonna do is I'm gonna move this along slowly, and you tell me when to stop when you see the path that you used on or before this day to access West Andrews for your morning runs. And if I skip it, tell me to back up. Keep going. We're getting close to the end. Did we see the,
You skipped it.
I skipped it. All right, we'll start over.
Pick something.
Tell me when to stop.
I go up anywhere here or on there. I
All
go
right.
back up anywhere or on there.
All right, show us, use your little red touchy thingy.
Move it back a little bit when you said,
Right there.
Yeah,
Okay.
I can.
Now, the way this, it's a little blurry now, but the way it works, if you tap the screen once, there should be a little pencil in a circle over on the left, lower left corner.
I see, lower.
Deputy Gordon's gonna show you how to do it. It works now, so we'll get this to work. Good. Well, just don't press anything now. It may give you a strong electric shock. Okay, now, is it working? Oh, this guy was just here.
That's not working.
You know what I bet is it's this funky app that's
It probably is.
not going, but it's still going through Zoom.
Well,
Come to the big
I mean, I can
screen.
show them.
come to the big
Yeah.
screen.
And I'm gonna get tech to show up now while we're doing it. Thank you, sorry.
Cause it was a pencil, now the pencil gone.
Yeah.
I go up anywhere here.
Okay, so through all this, you walk through here to get on and off West Andrews.
That's correct.
Okay.
Could go anywhere here.
And you remember I asked you, I did this same thing in your deposition. Do you remember that?
Can I go back sit? Or
Please.
go back sit?
Please, use whatever you're more comfortable with. We're not gonna be doing this again for a little while. You remember I asked you about that in your deposition and we did the same thing and you couldn't tell me where you were able to access West Andrews in your deposition. Do you recall that?
I don't remember that.
Okay.
Stop for a sec. Yes, ma'am.
I think he's backwards in his use of deposition transcript to
Right.
talk with the witness about it. I'm sorry, he's testifying from the deposition as opposed to asking the witness.
Right, so I want this to work smoothly. You may be calling Ms. David as well, and you may want to use deposition transcript, but you need to ask a witness a question, and if his answer is somehow inconsistent in your mind with the deposition, then we can go there, as opposed to, I'm gonna already get you with a deposition answer, unless what he just said, I don't know that it was, is inconsistent with a deposition, but you still show him that deposition information first before you wield it.
All right. Let me go to plaintiff's exhibit 22, which was admitted yesterday. These are the Google Street View images that Mr. Anderson identified. And if we go to the fifth page of exhibit 2, let me make this a little bigger and I'm going to call out the date. This is from November of 2019. So this is 5 months before y'all bought the house, right?
Yeah, it's 4.
4 or 5 months before you bought the house. Okay. And did the frontage of West Andrews at the time y'all bought it, did it look like this or did it look more like the video we just looked at?
It looks like that.
Okay, it looked like this. So let's try that little red thingy again. Can you tell me, let me just call out all of what appears to be the frontage. Does this basically encompass all of easement 2 and then maybe some additional on the frontage?
This is part of easement 2.
I'm just talking about the frontage. I'm not talking about the back portion.
Oh, it looks like it.
Okay.
Yeah.
Can you use your little red arrow thingy and kind of,
Arrow thingy's not working right now.
well, it wasn't working on the video. It might work.
Okay, well, try.
Let's try it. Try it again. And if not, you can come
But
around.
I have summoned IT, because I would like it to work, so you don't have to keep doing what you're doing.
I appreciate that.
Yeah.
It's not working. All right, well, come here and show us where on this Google Street View image you would come through here to do all of the.
Don't come up on me.
Okay, so you come through any of this brush, and would you have to kind of
No,
part ways, you just walk straight through?
yes, sir.
Okay, thank you.
Now, you have that big notebook in front of you. Can you flip to tab 23?
Yep.
Do you remember we went over this in your deposition? It was actually marked, I'll represent to you as marked as Exhibit 2 in your deposition. And if you need to look at the Exhibit 2, I've got a copy in black and white. Want that?
The black and white version of what we use in your deposition. If you want to kind of compare this page by page with Plaintiff's Exhibit 23, we can do that, or I will offer it right now and see if this firm has an objection.
Which, you
I'm
mentioned
offering-
a bunch of numbers. Which one are you now offering?
I'm offering Plaintiff's Exhibit 23, which is a color version of what I just handed the witness.
Got it. So plaintiff's 23 is not yet in evidence.
Correct.
Okay. Any objection to plaintiff's 23?
I'm unclear if this is duplicative of what we're already admitting with our videos and pictures.
You're not testifying, you're explaining. What is the origin or provenance of 23? Is it screenshots from videos?
Screenshots from the videos, and then there's also some pictures of their house taken from the real estate listing and some Google Earth images. So some of it's, well, I wouldn't say a screenshot is duplicative of the video.
No, and some of them aren't screenshots because I see, I don't know if it's Mr. Anderson's hand, there's a lens of a camera.
That's Mr. Elrod's hand.
Mr. Elrod's hand, okay. Regardless of whether they're duplicative, any objection to plaintiff's 23? I don't think there's an issue having a still version of what's in a video, but there may be stills in there with which you're not comfortable. And if there's an evidentiary reason, let me know.
No, Judge, I will say I'm a little bit worried we're headed down the same path with the deposition testimony.
Okay, we're not there yet. So
Okay.
no objection to 23, it's in.
All right. I'm now sharing my screen with you and the jury of Exhibit 23. Whoops. Make it a little bigger. Come on, cancel that. Go here. There we go. To the right, we see the fence kind of down the lower left-hand corner, right?
Yes,
And that's the spike fence, right?
yes,
Okay. And to the upper right of that is your fee simple property, right?
yes,
And we got some nice landscaping around here, right?
yes.
And cancel that.
You're showing off how you draw on screens.
And I
We can't do it.
did that with my right hand, and I'm left-handed, so. And also we have some nice lawn to the right, correct?
Yes,
And we have a sports net of some sort at the end of this lawn area, correct?
yes.
What's the purpose of that sports net?
It's a soccer rebounder.
Okay. And the next page is an image of Easement 2 taken from the drone, correct?
Yes,
Okay. And that also has a sports net. What's the purpose of that sports net?
it's a net you put in the back of either lacrosse or soccer, to catch the ball.
Now, kind of circling back to where I was a minute ago, when you would leave your house to go onto West Andrews for your morning runs, let's go back to the first page, would you, let me use my laser pen so I don't have to, would you go this way through the grass, or would you come this way down this little walkway and then through the wildlife and then turn left at the easement?
Anyway,
Both of them.
I rarely come to the left. I usually go to my grass.
Okay. So then you'd get to the grass and you would take a left and go through Easement 2. And this path wasn't here until mid-August, correct? This path has been cut through.
Yes,
Okay, so you would,
but that's not necessarily the way I go, that you pointed at.
okay,
Okay,
so before the path was there, you would basically go anywhere, right?
right.
Okay. And then, you would start your run?
Yeah, I'll either start or walk up Habersham or walk down towards West Paces, however I feel that day.
Okay. And, for a while, you used to use Strava to track your runs, correct?
Correct.
And one of the features of Strava, it's like the Garmin app I use for my bike rides, it will map your run, correct?
Yes,
Yeah.
ma'am. Hold on one second. Yes.
Yes.
Again, he's testifying about certain characteristics of things. I think he needs to ask the question to.
It has the witness on cross-exam, and if Mr. David didn't use Strava, if I'm saying it correctly, he could say, I never use Strava. So I don't, come on in, please. This is I will make the screen work, gentlemen. So overruled for now. If I hear testimony, you think you're hearing him testify, let me know, but I think these are appropriate cross-examination questions. Can you please help us get the notation to work on that screen? That screen right there. It was working before your colleague was here and it worked.
Before we get back on the Strava stuff, I want to kind of go back to where we were a minute ago, talking about the sod supposedly in the easement. These are stakes and ribbons that you placed in easement 2, correct?
Yes,
And you placed them on the edge of easement 2, not a couple of feet inside easement 2, correct?
actually, I put them on easement too.
Okay.
When you say on, meaning you knew where the border was?
Yes,
So you purport that where these are would actually mark the border. If you're on one side, it is
still the
Anderson
easement.
property.
No.
No.
If you go on outside, if you go on the other side of the border, I mean, the ribbons, you're still actually on easement too.
Okay, so this would be a reason why you might say, I'm not saying it's correct,
It is
why you might
correct.
say there is sod in easement 2.
That is correct.
Because you're claiming that this ribbon isn't right at the edge.
That's correct.
There's easement 2 space beyond.
That's correct.
Okay, that helps.
Yes,
me.
Judge.
Thank you.
So I have my little laser pointer here. You're saying that the actual border is on this side, somewhere in this sod area.
Somewhere, yes.
And that's your personal opinion based upon your review of the survey, correct?
Based on the survey in my hand, looking at the survey, looking at the ribbons and the peaks, the perks that it puts on the ground, and yes,
And we didn't go through your educational background. You're not a land surveyor, correct?
I am not.
You're not a licensed engineer in the state of Georgia, is that correct?
I'm not.
Okay. So circling back to where we were, if you can flip over to tab 47 and 48 in that notebook.
Yep.
Do you recognize 47 and 48 as screenshots of your Strava profile that we talked about in your deposition?
Yes.
Okay, Your Honor, we offer 47 and 48.
Ms. Sturm, any objection to 47 and 48?
Your Honor, my objection to 47 and 48 is if we can stipulate that this is, we're using an app. And so just like we would calibrate something else, the calibration, we have no idea what the calibration of these are. We have.
So you're free to examine Mr. David on this. The question is, it's got whatever evidentiary weight it has. There may be reasons why this is just an estimate and maybe reasons why this is precise to the millimeter. And you're welcome to explore that with the witness. Do you have any objections as to foundation or it's hearsay or anything like that?
Well, my objection would be to foundation, and that kind of gets to the issue.
Would you like to voir dire this witness on this exhibit before I decide whether to admit it? Well, don't put it on a screen
No,
yet.
I'm having to show
Okay.
you.
I think while she's looking at, this is the same thing, just rotated. These aren't two, I don't believe, they're two different events.
One of them's, it's the same run, One of them
As
is,
long as
a-
you agree with me, it's the same run. I don't have an issue with
it's the
it.
same run. The second one is a more close-up image,
Okay.
Randy, can you tell me those numbers?
47 and 48. And let me just lay a little more foundation.
Why don't you get started on that?
Now, we talked about these in your deposition. Do you recall that, Mr. David?
Yes,
And in fact, we went through every run that had been recorded on Strava under the Jean-Noel David profile in Buckhead, Georgia. Do you recall that?
yes,
And this 47 and 48 is just one run. 47 is a bigger image and 48 is a close-up. Is that right?
I guess, yes.
Okay. And that trail, you recognize that route as a route you take very often, correct?
Not necessarily.
Well, it's a route that you used to take very often at the time I took your deposition. You may have changed since then, but that's the route that you took very often.
I did.
Okay. And that accurately reflects your route, correct? At that time?
Yes.
Okay. Your Honor, I think I've laid a foundation. I think we can move on.
Any objection based on those questions?
No objection.
All right, 47 and 48 are admitted.
47, this is the one we're just talking about, and this shows your run starting on Habersham, going down the road, turning onto West Paces, and circling around. It's a little under 3.2 miles, correct?
Yes.
And your average pace is 8:47, and you told me in your deposition it's now down to 8:10 a mile, correct?
Yes.
And I tip my hat to you for doing so well. Do you recall that? And the next exhibit is more of a close-up image, and it shows elevation or something like that. This is 48 I'm looking at. Let me do a call out here on 48. What we're looking at is where you start and end your run, correct?
Yes.
And I understand that, of course, the app doesn't start until you press start, correct?
Right.
And then the app stops when you press stop, correct?
That's my understanding.
And I believe that you said that you would use West Andrews for either ingress or egress about every other time, correct?
Pretty often, yes.
Okay. And this start and stop point is directly across from the end of your driveway, correct?
On Habersham.
Yes.
Yes.
Okay. So whether you use easement 2 for ingress or egress, basically what you would do is you would walk out the house, you'd come down here, cross over, go up West Andrews, cross Habersham, come back down here, and hit start, and then start your run, correct?
I will hit the button start right there at the green light. Yes.
Okay. Or if it was, you used West Andrews after your run, you would basically go out your driveway and then just reverse it. You would hit stop and then go back up the road, down West Andrews, across the easement, through your backyard, up to the house, correct?
Sounds about right.
And in our review of all of your Strava runs, we never found one single run that covered any portion of West Andrews. Is that right?
I guess you did not.
Now, at some point, you decided to put a chair on easement 2, correct?
Yes.
And that has already been admitted as plaintiff's exhibit 6. Let me share that with the jury. Hold on a second. There it is. Plaintiff's exhibit 6. That's the chair that you put on easement 2 for your post-run recovery, correct?
Yes.
Okay. So, kind of circling back to where we were, what you would do is you would finish your run, go back up Habersham, down West Andrews, come across down West Andrews, across easement 2, but you wouldn't stop at the chair. You would actually continue into your yard, back up to your house, get coffee, come back down your yard, cross into easement 2, and then sit there in this chair and enjoy your coffee and check your emails and whatever's on the news on your cell phone, right?
What's the question? I don't understand the question.
Okay, well, you would sit here after your run, correct?
I have sat there after my run, yes.
Okay, and you would sit there with coffee, correct?
Sometimes, yes.
And you didn't have a coffee pot out here, you had to actually go into the house to get the coffee, right?
Yes,
Okay, so you would have to go into the house to get the coffee, and then you'd have to repeat this whole process. You'd have to walk through your backyard into easement 2, sit there and drink coffee, correct?
yes.
Okay. And if we go back to 23, hold on a second. Let me. So here's, on page 30 of Exhibit 23 is a view of your backyard, correct?
Yes,
Facing the house.
yes,
And you've got a nice brick stairwell, and off to the left here, we have a nice brick patio, correct?
yes.
But instead of sitting there and drinking your coffee, you would go all the way through the yard, through the woods to easement 2 and sit there and drink your coffee, correct?
Sometimes, yes.
Sometimes. Now, it wasn't your idea.
Unmagnify the picture for a second. I have a question from Mr. Duggan.
Yes, Judge.
I need the picture. There's a structure over on the right. Is that your garage or is that some part of the Anderson household?
Anderson House.
What part of their house? I don't mean for you to tell me what room. Is that part of the main building or is that a garage?
That's the garage.
Okay. I'm just trying to see how close together things are. Thank you.
Absolutely.
Now, just to clarify, this red brick structure, is that your structure or the Andersons' structure?
That's ours.
Okay. And the Andersons' garage is the wooden structure to the right, correct?
Yes.
Okay. I just
What is
want,
that brick structure? A little temple?
It's a shed.
A shed? It's a nice looking shed. All right.
and here's let me show you, page 28.
It's right here to the left.
This is the shed, correct?
Yes.
And actually, easement 2 kind of, well, let me go to another page. Whoop, clear. Clear that, come on. All right, I have boogered it up. Now we've got technical difficulties here. All right, pen, highlight, I'm frozen. Basically, easement 2 covers a good portion of the lower left of this picture, correct?
Sorry.
There we go. All right, Judge, it seems like technical difficulties are an infectious disease in this building, so.
Going backwards from that screen to you.
All right. Let me stop my share, start over, see if this helps. There we go. All right. There we go. So what I was trying to do was show, and now it's frozen again. Turn that off.
So if you have those exhibits as PDFs, you can certainly share them in the good old fashioned way, just through Adobe Screen Share, and then
All right, let me,
you'll be able to mark them up. I don't know what format you've got.
all right, Mr. Logan, can you share your content, and we're on Exhibit 23. We'll do it the good old-fashioned PDF way. Free. All right, we have to rotate those. I wanted a picture of their driveway and the shed from the front. So that's going to be down around 28 or 30. Here we go. Now down here in the lower right, Eric, you have rotate, that rotate option. Go ahead and rotate. Go up to page 27. Yeah, and then rotate the document. Down lower right-hand corner. No, lower right, that's it.
Yeah, okay. Yeah, they changed it.
Okay. So, page 27, what we're looking
Try
at,
something before you ask your question. Now try tapping the screen somewhere and see in the lower left-hand corner is a little circle with a pencil.
Yes,
Now pick a color. Is there a little palette?
yep.
All right, now try circling your shed. Did it create on your screen a circle? All right, Deputy Gordon, can you?
But I can,
Oh, it did.
that's me.
Okay, look,
There you go.
It is green, it worked.
Hey.
All right, so that's how it works.
All right. So,
Hold on, one last thing. You can erase it by hitting that, there's a arrow that looks like it's going in reverse. If you tap that, that should make what you did go away. So there, sit it once. Good.
okay.
I'm sorry, back to you, Mr. Edwards.
So now this is a picture basically taken from easement 1 facing the back of your driveway and shed and backyard, correct?
Yes,
Okay. And we see that kind of gate there between the two brick columns. That's basically the line for easement 1, and it's going to come kind of diagonally from left to right to the bottom of the screen. Is that right?
wait,
All right, well, you draw it for me. Show us where the boundary line for easement 1 on the left and your property on the right.
easement 1 is right here. Okay. Easement 1 right here.
Okay.
Okay.
Okay. And one of your planned or contemplated uses for easement 2 is to extend your driveway all the way down to West Andrews, correct? Through your,
We've talked about a lot of things. We're not even in the house. We're talking about a lot of options, you know, so we talked about driveway, we talked about a lot of things.
but that's specifically one of the things that you guys have contemplated is to extend your driveway and use easement 1 for access to West Andrews, right?
We've talked at a really, really high level.
Okay.
Yes.
So to do that, you'd have to tear down that shed and cut down all those trees and,
There's professional that tell you how to do that.
okay. But y'all haven't actually gone that step to talk to a professional as to whether we're going to do that.
We have not. It was, you know, one conversation with Cheese.
Okay. Eric, if you can pull up, do you have defense exhibits on there? Okay. All right. Do you have this, no, you don't have that. Well, that's not it. The fence along the border, the common border, the wooden fence, that's about 120 some odd feet long. Is that right?
It's less,
How much less?
it's about 90 to 96 and 100.
Okay, so it's still 30 yards.
I guess so.
Okay. And the chair, did I ask you, oh, I asked you this, I don't remember. Your wife is the one who recommended that you put that chair on easement 2 for your post-run coffee. Is that right?
We just talked about it one day that I like to sit there for my coffee and says, why don't you just take a chair? So that's a great idea.
Okay. So your wife is the one who recommended that you take that red chair out there?
No, she did not recommend. She just offered the option. Plus, I don't understand the word.
Well, I gotta do this old school way since my iPad's not working. Remember I took your deposition on January 27th of 2022, right?
Yes, sir.
And
What did I say? 78.
page 78, I asked who suggested you take the chair out there?
Oh, yeah, yeah. You remember my English is my third language. So I'm sorry. Yes, we talked about it. She offered the option. If you call it the recommendation, yes. Yes.
Well,
I just remember English is my third language.
I understand that.
Okay.
You didn't raise that issue in the deposition in response to this question though, did you?
I don't remember.
You said on page 78, line 4, someone
So
told me.
let him read it and see if that refreshes his recollection,
Okay.
and then you can ask him to explain the discrepancy if there's a discrepancy.
Yes, I'm ready.
So you told me under oath in your deposition that someone recommended that you put the chair there, and then when I asked you who, you said my wife. Right?
Yes.
Now, we started, when the lawsuit was filed, those ribbons and stakes were not along the easement line, were they? When approximately did you put those stakes and ribbons up to mark the easement area?
I don't remember exactly.
It was definitely after the lawsuit was filed, right?
That's correct.
And why did you do that?
Well, one of Mr. Anderson's complaint was for people to walk up his property. So putting the ribbon will delineate the separation between his property and the easement. And I have kids that actually play out there. I want to make sure they don't cross over Mr. Anderson property. So they see it.
And you mentioned people would use the easement for ingress and egress. The workers on your house would use easement 2 for ingress and egress, right?
I did not say, the easement, yes.
Would use the easement.
Yes, easement.
What type of stakes or ribbons or marks did you put up to show the workers the boundaries for easement 2 so they wouldn't go around the rest of the property?
At that time, we did not.
And we saw the area, you showed us the area where you would enter easement 2 from Rest Andrews on your runs. Do you know exactly where these workers carrying the tool belts and other equipment would enter easement 2?
I don't.
And at some point you put the nets up, right?
Yes, sir.
And you had some friends do some clearing.
Yes,
And those friends, do you know their names?
I do not.
And
Do you remember
another time when you
answered stuff under oath? In this case, were interrogatory responses. And you understand, an interrogatory is a written question that we send to your lawyers, and y'all have to answer it under oath. You understand that? Okay. One of the
issues we've tried to figure out from the start of this case was exactly what uses y'all wanted to do on easement 2. Do you recall that?
I recall the question, yes.
Okay. And actually, if you look at interrogatory number 14, which is at the bottom of page 8, and the answer is at the top of page 9. So we asked you, interrogatory 14, describe with particularity your current plans for the use and or improvement of easement 2 in the future. And the answer was what? I'll skip through the objections. Your answer was, the Davids respond by stating that in the future, they intend to make.
Objection.
Stop for a second. Yes, ma'am?
We've got a procedural issue again on how Mr. Edwards is presenting.
Judge,
He's testifying as opposed to the witness.
Judge, I'm going to ask the witness if I read that correctly, if that was their answer.
Okay. I assume that's how you were gonna end. You may preclude some of these objections if you say, was it not your answer? And then you read these things because there you've indicated the question in advance, but overruled.
Okay. Was it not your answer?
I like that.
The Davids respond by stating that in the future, they intend to make use of easement 2 in compliance with their legal rights to do so. Was that your answer?
Yes,
So you didn't give me any specific uses. We intend to do X, Y, or Z, did you?
No.
And if you look at the last page of this, this was mailed, were served on us. These answers were served on us on July 6th, 2021, correct?
yes.
And were you aware of any back and forth between my office and Ms. Stern's office about, hey, we need a more specific answer as to what, if any, specific uses you currently plan? Are you aware of that?
I knew there were conversation, don't know the details.
Okay. So y'all gave us a supplemental response. And if you look at the back page, this was served on us on August 9th. Is that right?
But he says yes.
Okay.
Of what year?
Of 2021. Just less than a month later, approximately a month later. And if you look on page 10, the same interrogatory, there is a supplemental answer, correct?
Yes.
And if you look down at the bottom of the page and continue on to the top, the supplemental answer, I forget how I phrased the last one. Is it correct that your answer on August 9th was future uses of easement area 2 would have and may include maintaining it for privacy purposes, for enjoyment and peace of mind, for natural and aesthetic purposes, including as wood, for access to West Andrews Drive, and for any other purpose authorized by law, correct?
Yes.
And that was a full and complete and truthful answer on August 9th, 2021, correct?
Yes.
So if you had intended at that time to put these sports nets up on easement area 2, that would have been included in this answer. Is that fair?
No,
Well,
I mean,
You can,
go ahead.
you can explain your answer.
Yeah.
I mean, if I want to go and put a soccer goal out there, do I have to send you a letter?
That's not,
You don't get to ask him questions, but maybe that was a.
No, but that was,
question.
I mean, I didn't understand the back and forth.
so
So,
here's, the question was, describe with particularity your current plans for the use and or improvement, wasn't ask us permission. We wanted to know specifically your current plans. Is that fair? I'll withdraw that. You can't say what we wanted. But that's the question we asked, for you to tell us specifically what your current plans are. And you gave us an answer. And this answer was also verified under oath,
yes,
subject to penalty of perjury, correct?
yes,
I'm not asking you whether you had to ask our permission. I'm asking you whether on August 9th, you actually had a current plan to put these nets up. Yes or no?
no,
So something changed between August 9th and August 12th. Let me back up. as of August 9th, did you have any current plans to have these friends come out and clear a path for access to the street?
No,
Okay. And you agree with Mr. Anderson that those events occurred on August 12th, 2021, is that right?
if that's it says, yes.
Okay. What changed between August 9th of 2021 and August 12th of 2021?
I exercise my easement rights.
What made the light bulb go off in your head to say, hey, I've got an idea. I'm going to go out here tomorrow and put these nets up? What was the light bulb moment?
My kids,
Your kids. Were you aware of any discussions that Ms. Sturm and I were having or trying to have during that 3-day window about this case?
no,
Are you now aware, as we sit here today, of any discussions that Ms. Sturm and I may have had during that 3-day window between the interrogatory response, when you didn't tell us anything about the nets, and the nets popping up 3 days later?
So you can answer that question, but we're going to proceed with caution after that. You understand the question? Have you learned now that maybe back then your lawyer and Anderson's lawyer?
I mean,
was
I
on-
know they were talking at times. Now, I don't have access to those conversations all the time. I don't want it, and so there was conversation, yes.
But specifically that 3-day window, are you now aware of any of those conversations?
Like, I mean, you mean, can you clarify, aware as if you were talking or aware of the content?
Are you,
Specific of the content?
are you now aware of any emails that were exchanged between Ms. Sturm and I between August 9th of 2021 and August 12th of 2021 regarding your uses of easement area 2?
I'm aware there was conversation, yes.
Okay. But my question was, at that time, back when the nets are going up and the workers are coming out, were you aware of any email exchanges between Ms. Sturm and I? Are you now, as you sit here today, aware of any email exchanges between Ms. Sturm and I during that 3-day window about this case?
Yes, I am now, yeah.
Okay, you are now. And I'm not asking for advice. Don't want to know what, if anything, Ms. Sturm told you, but is it fair to say that if she gave you any type of advice as to what, if anything, to do, you would have followed it? Okay. And
You've skirted it so far. I'm listening closely. Don't worry, and I am confident Mr. Edwards is being thoughtful. In fact, he has said, I don't want you to tell me what your lawyer said, so we're okay here.
And
Let me let the lawyers know, there's nothing untoward happening here. Just what lawyers say to their clients and vice versa is in confidence, it's privileged. And so it is appropriate for lawyers to say, hey, did you talk to your lawyer about something? But not to get into the contents of that communication unless someone waives the privilege. Mr. David could say, I'm going to tell you all about it, but he'd have to say, I want to do that. He can't be compelled to do that by a question that he has to answer under oath. So we're in a safe space here, and Mr. Edwards understands the contours. That's just why Ms. Sturm has been levitating. Okay, Mr. Edwards, let's move on.
And it's your position that it's not just a 100% coincidence that those friends of yours were out there clearing the path on August 12th with these ongoing discussions. It's a 200% coincidence.
Absolutely,
Absolutely pure,
coincidence,
total coincidence.
yes, sir.
Now, at some point, we inspected the easement area, we inspected the property, took a bunch of pictures, took these drone videos. You're aware of that, right? And you're aware that we had to coordinate that inspection with your lawyers, right?
Yes,
And you're aware that one of the things we were concerned about was making sure that there wasn't any altering of your property to create a path to easement area 2 that wasn't there before. Are you aware of that? Okay.
Yes, I'm sorry.
Okay. Your Honor, plaintiffs exhibits 24 through 39 are photos taken from the inspection. I would offer those.
What inspection are we talking about?
The inspection that occurred in the summer of 2021 that we just discussed with Mr. David that we had to negotiate with Ms. Sturm.
24 through 29?
39.
39, okay. Mr. David, if you could flip through 24 through 39 and let me know if you recognize those photos.
I'll try.
Yes, Judge.
You recognize those photos? Okay. Any objection, Ms. Sturm, to the admission of 24 through 39?
No, Judge.
They're all in.
Let me. I closed out my app and restarted it, and it appears to be sharing. So plaintiff's exhibit 24, this is a picture taken by Mr. Elrod during that inspection, correct?
Yes.
And we see, do you agree that there is a path? Let me use my laser. There's a path right here from your property, and it kind of turns. Maybe it goes on easement 2, maybe it doesn't, but it kind of turns to the south. Is that right?
Yes.
Okay. What's the purpose of that path?
The path.
It's a path. And plaintiff's exhibit 25 is more of a close-up of that path, the end of that path, correct?
Yes.
Okay. And would you agree with me that that path appears to be rather fresh the last day or two?
It fresh, I don't understand fresh.
Does it appear to you that this path has been freshly created either by a weed whacker or some sort of a cutting tool or something?
Yeah, maybe, yeah, it looks like there's a more naked area than others. Yes.
Okay. And do you recall explaining to me in your deposition that the source of this path was your son riding his motorbike or bicycle out there?
It's a mountain bike with his friend, yes.
Mountain bike. Oh, here we go. And plaintiff's exhibit 26 is another image of that. Let me just keep scrolling through. Plaintiff's exhibit 27, this, do you recognize this as kind of a close-up of what we're just looking at 26? And do you see these fresh ivy leaves on the ground?
Yes.
Does it appear that they have been cut freshly because they're still green?
Still green?
Yes.
Yes,
Okay.
yeah. They're still green, yes.
And you know that leaves, when they get cut off of the source, they die and turn brown and shrivel up. Correct?
Is that a question?
Yes.
Oh,
Do you agree with that?
and I'm not a specialist.
Okay.
in this room.
So this is the path that your son uses his mountain bike on. And he just goes to a point and stops, correct?
You'll be surprised.
Okay. But this is not an example of somebody, one of your friends, for example, going out there and cutting a path and then being told, wait, that doesn't go the right direction.
No. Not at all.
Plaintiff's Exhibit 29 is another close-up. Do you agree that the leaves here have been freshly cut within the last 24, 48 hours?
They're cut. Yes,
Plaintiff's Exhibit 30, another example of a relatively freshly cut path into the
How
ivy.
many examples of freshly cut path with green leaves do we have there?
Just a few. Well, I think that's probably the last one. Well, let me just,
Let's move past the. path.
okay. 32, this is your property showing dead limbs and stuff like that, right?
yes.
Is that what easement 2 looked like when you bought the property?
No, it was wooded area.
Wooded. And Plaintiff's Exhibit 33 is another angle of your backyard showing some sort of debris, correct?
Yes,
Plaintiff's Exhibit 34, this is the view of the fence from your side of the property, correct?
yes.
And what is Plaintiff's Exhibit 35? What do we see here in your backyard?
It's a ceramic pot. Is that what it is?
You tell me. Here's a picture, Plaintiff's Exhibit 36. This is your brick walkway parallel to the fence, correct?
Yes,
And Plaintiff's Exhibit 37 is the same walkway, but from the opposite direction. There's a little stone sitting pad there, right? Correct?
yes,
Now, before the fence was there, if you would go this direction to access easement 2, you would continue walking all the way down to what is now the end of the fence before you would turn left. You wouldn't turn left here at this path, would you?
no, yes,
Because if you turned left here at this path, you wouldn't be using the Andersons, you wouldn't be using the easement, you'd be using the Andersons' property,
that's
correct?
correct.
And 38 is an image taken from easement 2 showing the Andersons' property, the fence, and the stakes and ribbons that you had installed, correct?
Yes, so the fence ends at the property line. That's where actually the easement starts. So that's where the grass is on easement 2.
So that extra, now how do you know the fence goes all the way to the edge of the easement instead of stopping a foot or two short?
Because I measured,
Did you measure it with a tape measure?
I measured with one of those contractor measure that you use, that you buy at Lowe's.
Took a survey tripod and put it out there and it's got a laser light and you measure the time? So what,
No, not a tripod.
is that a stake just to the right of the stake that you have installed?
I have not,
No?
no.
Why didn't you put your stake up against the fence if that's the true edge of the easement?
In case my kids were playing, I want to give them an extra yard just in case, so they don't step on Mr. Anderson property.
And finally, Plaintiff's Exhibit 39, this is an image taken that day of the Anderson, from the Andersons' property, of the Andersons' property, going down the Andersons' property with easement 2 being outside the picture, correct?
It looks like it, yes, sir.
So if people were to have walked this way to get to or from your property or the Darby property, they would not be using easement 2, is that correct?
That's correct.
All right, we've also got a couple of drones, Plaintiff's Exhibit 41 and 43. Any objection?
Is it gonna be something new and different? 'Cause
It's going to be drone views of this. We can take a break.
I don't need a break. I'm wondering if it's something different.
It's a different angle and perhaps it,
Objection to 41 and 42.
Randy, are these the ones that were on the separate drive?
Yes.
I don't believe so. Judge, I think that was a set of the ones we agreed to yesterday.
Okay.
Yeah.
They're admitted.
They're admitted, and I'm gonna try to just kind of scroll through this real quick. We're looking at the edge of, well, we see the fence and we see your stake. Do you not agree that is a survey stake between your stake and the fence?
Can't tell.
You can't tell? Okay, I'm just gonna scroll through this real quick. This shows some of the paths. That's the path that your son uses on his mountain bike.
Anywhere over there.
Okay, anywhere over there. And here's the net and the path that your friends cut in. All right, that's the end of that. I'm gonna go now offer plaintiff's exhibit 43. Whoops, I'm not sure that. Oh, that was admitted, correct? Got it.
41 and 42, I thought?
43.
43.
Okay.
Okay.
This, let me kind of scroll here. This is a more overhead view. You recognize this as West Andrews Street and the Anderson house on the right?
Yes,
And we see the fence kind of splitting your property and their property.
yes.
Okay, the drone flies down, pivots up. We see the net. We see, is that ground all wet and mushy? No?
I mean, when the sprinkler's on,
Okay. Then we kind of fly up along the fence, get a little better view of your property, and we see your net over here on your property, and then we swivel back to the net on the Anderson property. And do you have a preference for whether your son practices his sports on your property or the Anderson's property?
When you're saying Anderson's property, you're referring to easement 2?
Yes, sir. I should have clarified.
whatever works to make him better.
Okay, fair. Now that this is back up and running, I can go through your deposition. And let me look at the portions I was going to ask you questions about.
You take it down from a share screen.
Why?
Why are you putting the deposition on the screen?
So the jury can see it.
Why don't you frame a question for me before you put the deposition up so I can see if I agree? One, it's not in evidence, but two, so I don't know how it would be on the screen. You didn't put the complaint on the screen. It's not in evidence. You put the interrogatories on the screen. They're not in evidence. This isn't in evidence. So I don't know how it would go on the screen. I'd ask a question. First, take it down, please.
There, Chair. I have to show something. I can't go
Chair's
blank.
great. Why don't you ask a question that you want to ask about the deposition, and then I'll let you know if the jurors need to see anything as opposed to hear things.
Well, I will, Judge, but I'd like to respond to the objection. The rules of civil procedure say that the deposition of a party may be used for any purpose. It does not need to be offered into evidence. I can share it on the screen and go through it with the witness and highlight his questions and answers in real time.
Got it. You ask your first question, and I'll let you know if you can put the deposition up on the screen as opposed to have a copy for Mr. David to look at.
All right, let's do this. Let me stop my share so that, because I've got it annotated. Okay, that's not showing. Now, whole new line of questioning. Glad you did that, Judge. Because now I've got to go to the affidavit of Mr. Will, because I had some deposition answers in response to that.
All right.
All right, Mr. David, I'm handing you a copy of a notice of filing corrected affidavit, and it has an affidavit that you signed and verified under oath on September 13th, 2021. Is that correct?
Yes.
And again, you swear to tell the truth and that the facts contained in this affidavit are based upon your personal knowledge, correct? Okay. Flip down to paragraph 7 of your affidavit or declaration. You claim that Mr. Anderson has yelled profanities, made lewd comments, and verbally abused my wife, including in front of our children, correct?
Yes,
Did you personally observe that?
I did not.
How do you, so your wife told you, I take it, that he verbally abused her in front of your children, correct?
Yes,
Okay. And you say in here, he has likewise yelled profanities at me. Is that correct?
yes,
And do you consider yelling profanities to be verbally attacking someone?
yes,
Okay. Do you remember me asking you about whether Mr. Anderson had ever verbally attacked you in your deposition?
yeah,
And do you recall your answer?
yes,
You do recall, well, if it's true, if the declaration is truthful, your answer would have been consistent, right?
yes.
Okay. Your Honor, can I show the jury and Mr. David his answer to the question?
You can show Mr. David and see what he has to say about what the deposition says his answer was.
Okay. Let me hand you a page of your deposition and look at the question on page 75, beginning on line 16, going through 21.
From where to where?
Line 16, the question was, has he ever attacked you verbally or otherwise, correct? That's the question.
Yes,
And read your answer to the jury.
no. Attacked, no,
Okay. And then next question, has he ever attacked your children verbally or otherwise? Your answer was?
I mean, he's attacked, no,
Okay.
I'm sorry, Judge. Mr. DeVito.
no.
Pull your mic though to you.
Yeah, I'm sorry. I'm so sorry. It's the accent.
It's also soft voice. We're understanding you. It's just,
Yeah.
you're distant from the microphone. So if you roll a little closer.
I'm so sorry.
And talking about the video where Mr. Anderson recorded you putting the net up. We saw that yesterday. I'm not going to go through that process again. Were you scared during that interaction?
Yes,
And you volunteered, do you recall telling me in your deposition that you thought he might have a gun?
yes, he could have anything. He is shown his behavior that unpredictable.
Okay. On page 75, line 5 and 6.
Which page 75?
75, right here.
Yes. Do you want me to read it?
Sure.
He's a big guy, and I know in this country we can carry guns pretty easily.
So there wasn't anything specific about Tracy Anderson, it's just this country, people have guns, right?
Is that the question?
That's what you told me in your deposition on January 27th, 2022, correct?
That's what I said, yes.
One of your criticisms of the Andersons is they did not consult with you before building that spike fence, correct?
That's one, yes.
You believe that they should have consulted you, right? Should have said, hey, we're building a fence, something along those lines, right?
I believe in good neighbors, it's, if I want to do something that's going to be interacting with my neighbor, I will knock on the door and have a conversation about it.
Okay.
Yes,
But as far as putting these nets up and these ribbons and all that, it's not a two-way street. You can do that on a moment's notice with no consultation of Mr. Anderson, right?
I was exercising my easement agreement.
Okay, so the answer is, yes, Mr. Edwards, I can do whatever I want, and I don't have to consult with the Andersons about anything on easement 2,
So
correct?
that wasn't his answer. You can ask him questions,
All right,
but
let
you
me-
can't then comment on the answer he gave.
Let me rephrase the question. Is it your position that you do not need to consult with the Andersons about any of your intended or actual uses on easement 2, no matter if or how it may annoy them?
It depends.
All right, give me an example of the situation where you feel today that you need to consult with the Andersons before you do something.
Probably putting a fence. Define consult.
Talk to them.
Anything that will stay permanent.
Those nets, while they're technically not permanent, they've been there for over 2.5 years, right? Coming up on 3.
I'm not sure they're there today.
You're not sure they're there today?
I don't think I didn't check. But,
You heard-
but they're not permanent.
You heard Mr. Anderson say yesterday that they were there yesterday morning. Do you dispute that?
I just said I don't know.
Have you removed them since you got home from court yesterday?
I have not been on easement 2.
Okay, so if they were there yesterday morning, they're still there right now.
That'd be my guess.
Thank you, Judge. Nothing further at this time. I reserve my right for further cross if and to the extent.
Maintain or cause to be maintained all improvements and structures it elects to construct within easement area 2. Grantor acknowledges and agrees that grantor shall have no rights to interfere with grantee use of easement area 2. Want to read the rest?
Thank you, Mr. David. To your knowledge, are sports nets unlawful?
No,
To your knowledge, I'll call it a soccer chair, so to say, is that unlawful?
no,
To your knowledge, is walking across easement 2 unlawful?
no.
There were some communications or discussions with Mr. Edwards about an affidavit and some deposition testimony. Did your understanding of communications between those times change?
No,
Okay, did you have subsequent interactions with Mr. Anderson that changed?
no. Can you ask the question again?
Sure.
Oh, sure.
Did you have any interactions with Mr. Anderson subsequent to your deposition?
Yeah, yes. Yes,
And those included verbal communications
Yes.
from Mr. Anderson? Okay,
yes.
thank you. With regard, we don't want to get into your running history again. But we saw some drone footage, correct?
Yes.
Do you recall that site visit?
Yes.
Okay. Do you recall how long we were out there?
Oh, yes.
Was it more than an hour?
Oh, yes.
Was it more than 2 hours?
Oh, yes.
Is it more than 3 hours?
Yes.
Mr. Edwards asked you about a spike fence. Do you know the location of that fence as far as where it sits between your property and the Anderson property?
If I know if I look at the survey from McClung that is, and the spikes that the pickets that they have, it spots on the border of both properties, more towards on his property than ours property.
Okay. Is it 6 feet off the property line?
No.
Is it a foot off the property
No.
line? Okay, so does that change your opinion as to, or does that get to your opinion as to why a property owner might consult their neighbor about installing a fence?
I think they should, yes.
The location of it?
Yes.
Okay, thank you. I don't have any other questions for you right now.
Do you have any questions for Mr. David at this time?
Only just a couple at this time.
Okay.
Good afternoon.
Good afternoon.
Can you hear me okay?
Absolutely. correct.
Okay, thank you so much.
Sure.
So, and Ms. Stern was actually just asking you about the Anderson's fence, correct?
Yes.
Okay, and you said when you were looking at where the fence was, you eyeballed it, correct? From
I,
the survey, you
I don't
looked at
recall
it?
using the words
I thought I heard you say that. Did you not say that?
eyeball.
Yeah,
I looked at the survey
okay,
from a clone and then at the spikes that are on the ground that they put when they come and survey.
okay,
And the spikes that they put on the property lines with the different colors of the ribbons. And that's how I know where the property line is.
okay. And I believe you said that the fence is on the Anderson's property, correct?
It's in, yes, if, yes,
Yes,
yes.
okay.
I assume that, yeah.
And a little earlier, you were talking about where the fence ends
Yes,
in relation to where easement area 2 is, correct?
yes.
Okay. Now, you wouldn't have any personal knowledge on if the Andersons actually decided to stop the fence short of where easement area 2 was, meaning not extending the fence all the way to the border of easement area 2, correct?
I don't understand the question.
So if the Andersons chose to stop the end of the fence on their property before it reaches the border of easement area 2, you would not have personal knowledge of that, correct?
No, I know that
How would you know that?
because I asked the worker to stop at that point.
And he did stop, right?
Yes, he did.
Okay, and I appreciate you saying that. However, that's not what my question was. Did you understand my question?
Actually, I don't understand your question. So
Okay.
you may have to use a different way.
Okay. You were looking at a picture, right, of the fence and it came to an end. There was a little space and then there was your ribbons, right? And the ribbons are about where easement area 2 starts.
Okay,
Should
yeah.
we put the picture up so we're not having to?
Yes, I understand now what she's talking about.
It's the 38, right?
But the one with the, whoops, move.
Yeah.
Yeah. Yes, okay. Remember this picture?
Yes,
Alrighty. So you see how the fence stops? It's got a little end pole right there.
yes,
All right. And then you keep on moving a little bit to the left and then there's your ribbons.
yes.
Okay. So what my question is if the Andersons chose to stop that fence short, meaning it stops still on their property and not up on the border of easement 2, you wouldn't have any personal knowledge about that.
No.
You would not.
I mean, no,
Okay.
you never told me.
Fair enough.
Okay.
Right. Okay, thank you. And you said a moment ago, well, hold on, let me go back a minute. Would you agree with me that a fence could be knocked down?
Yes,
Okay. And when you put your chair on easement 2, you were able to put it there, right?
yes.
Okay, and were you able to sit on it?
Once, yeah.
Okay, did you take it back with you every time, or did you leave it there for a little bit?
I left it there.
Okay, you put the nets up, you were able to do that?
I'm sorry, repeat your question.
You put the nets up? You put the nets up, you were able to do that, right?
I'm able to do that. What is the that?
Put the nets up on
Yes.
easement area 2,
Yes, I did.
and you've left them there?
Yes, I did.
Okay. And I believe you said that if something's gonna be there permanently, but maybe even just for an extended period of time, that you should consult with your neighbor, that's being good neighbors, right?
I would assume so, yes.
Okay, but you didn't consult with the Andersons about leaving stuff up on easement area 2, right?
But if I choose to move the chair now, I can. If I go and choose to move the fence, I can today.
Sure, I mean, they could knock it down if they wanted to today, right? Right?
Yes, I guess, maybe. Yeah.
Okay. I mean, it's possible,
Everything's possible, yes.
right? But you didn't talk to them about putting everything on easement area 2, right?
I was exercising my easement agreement.
Okay, so
Right.
were you trying not to be a good neighbor?
No, I've been a very good neighbor.
Okay. No more questioning.
All right. Mr. Edwards, anything else?
No, sir.
Okay, for now, Mr. Debbie, you're gonna step down, and you may get called back when, your lawyers are presenting their case. Thank you for your time. Mr. Edwards, your next witness.
And Nikirk, hopefully by Zoom.
All right, let
Let me text her.
pardon me? Yes, you should move on over. Thank you. See if she is in, I can see her, she's gonna unmute.
Perfect.
Sure. Ready? Okay, first thing is Nikirk Deputy Gordon is gonna swear you in. I don't know if you can see him on any one of these screens, but you'll be able to hear him.
Can you raise your right hand?
Yes.
Do you swear or affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Below your hand, state and spell your name for the record.
Ann Nikirk.
Can you spell your name for the record, please?
Yes, it's ANNE, and my last name is NEIKIRK.
Mr. Edwards?
All right. Thank you, Ms. Nykerk. Can you see me and hear me?
Yes, I can.
I see that my head's kind of shiny up here because my hair is going back further than it used to. We're here during the trial. I'm just going to ask you a few questions about your experiences with 3350 Habersham Road and the next door neighbors, 3350 West Andrews and the next door neighbors. Where do you currently live? And I don't need the address, just city and state.
I currently live in Charlotte, North Carolina.
Before that, where did you live?
I lived at the subject property, which is, I think we said 3350 West Andrews. We knew it as 3381 Habersham.
And how did that change?
We changed it before we sold the property because the driveway faced West Andrews, and we just felt it like it was a more logical address for the property, and just would function better that way. And it just took a little bit of time to get it all done, and so we ended up with selling it shortly thereafter.
Was the mailbox always on West Andrews, or did it used to also be up on Habersham?
It used to be on Habersham.
Okay. And how long did you live there?
We lived there almost 15 years.
From when to when?
We bought it in June of 2004 and sold, I think, in the fall of 2018.
Okay. And I saw you look off to the right and down. Do you have some notes with you?
I do. I have a copy of the affidavit that I submitted, and then I wrote at the top what I thought were the dates that we purchased and sold, but I'm not even positive those are right. But I think
Okay.
that's
Sorry, but I'm not.
Yeah, slow down.
But I'm not, repeat after that, please.
What did you say, Ms. Nikirk, at the end of your last answer, if you remember?
I was saying that I believe that we bought the house in June of 2004 and sold it in the early fall of 2018. And that I was looking at notes on my desk beside me, and I held up those notes. And it's a copy of the affidavit that I submitted sometime back.
So I'm gonna ask you to turn the affidavit upside down so you cannot see its contents. If
Okay.
Mr. Edwards asks you a question, the answer to which you don't recall, that's fine. Just say, I don't remember. I know it was in about 2015 or whatever you think the answer is. And if he wants to direct you to something to refresh your recollection, he's free to do that.
Okay.
But one reason why we were reluctant to have you or anyone else testify remotely is we can't see what you're looking at, and you need to not be looking at anything other than what's inside your head, okay?
Okay. Fair enough. It's turned over.
All right. And do you recall who you purchased the property from?
We did. We purchased it from the Parkers.
Okay. And who were your next door neighbors on the Habersham Road address?
The Darbys.
Okay. Were they your neighbors for the entire time?
They were.
Okay. So from roughly June of '04 to fall of 18, it was the Darby's?
It was.
Okay. And describe your relationship with the Darby's.
When we saw them, it was cordial. I think they spent as much time away from Atlanta as they did in Atlanta, so we didn't see them that often. We did not have very much interaction with them. We didn't have any, only challenge we ever had was when they cut down some trees along their driveway, which were technically on our property. And then when we asked them about that, they replanted trees to our satisfaction, and that was the most we ever interacted with them.
Okay. Now, obviously, you understand why we're here talking about the easements. Is that right?
Yes, I do.
And easement 1, what's your understanding of what that is or was?
I believe that was the easement regarding the parking pad closest to the homes.
Okay. And easement 2, what is your understanding of its location?
It's in the lower part of what I'm calling the lower part of the property, closer to West Paces Ferry.
Is that north or south, or do you recall?
That would be south.
Okay. I didn't ask you this. What do you do for a living?
I have been a real estate agent since about that time we bought the property, since about 2005, and I'm still active.
Still active? Are you still licensed in Georgia?
I'm licensed in Georgia and I'm licensed in North Carolina.
And how much of your work is in Georgia, if any?
Not very much. It's definitely slowing down.
Okay. I want to talk about what you personally saw and observed with respect to easement 2, the 14 or so years that you owned it. When y'all bought the property, did you see any evidence of use by the Darby's when y'all bought it?
No.
Were there any paths cut, any grills, any type of structures on easement 2?
Did you say any paths? P-A-T-H?
Yeah, let's start with a path, any walking paths that had been cut in there?
I can't remember when we bought the property if there was a path, but the gentleman that helped us with the yard definitely created a path in order to dump grass cuttings and debris from the yard in that area.
From whose yard? From your yard or from the Darby's yard?
My yard. So the only cuttings I ever saw were from us, and the only path I was aware of was one that just was made on a weekly basis by our yard people. Find a place just to dump the yard refuge.
Did you or your family or your workers make any active use of easement 2?
Other than using it as a dumping ground, no.
All right. You said as a dumping ground. Explain that for the jury. What do you mean by using easement 2 as a dumping ground?
Again, it was just yard clippings and sticks and debris from the yard that was put in that area. No personal garbage, just yard debris.
At one point, did y'all have like a walkway that was comprised of railroad cross ties around the garage?
Yes, it was like a little retaining wall. Yes.
Like little retaining steps. You'd have a 6-inch rise and a flat and a 6-inch rise and a flat.
Yes.
Okay. And do you know if those cross ties rotted over time?
They did. They had deteriorated by the time we sold.
And do you know what, if anything, became of those cross ties?
I do not.
You don't know if they were discarded into easement 2?
I do not.
Did you ever venture into easement 2 and just kind of walk around and enjoy the peace and tranquility and beauty and nature and all of that stuff?
I did on occasion. I don't know if it was for the purpose of enjoying nature so much. It's just kind of curious what was going on. We lost a couple of trees that one fell over West Andrews and blocked the road. And so there were a couple of moments like that where it made sense to walk in there and kind of see what was going on. And I think my husband did the same thing on occasion, but we did not use that area. It was just a buffer from the neighbors to the south of us.
Okay. And did it appear that the Darbys have made any active use of easement 2 for any purpose during the 14 or so years you owned it?
I never observed any active use.
The Darbys, you said that they were gone half the year or more. Is that for the entire time, or did it kind of go up and down?
I couldn't put a percentage on it, but they were gone. I believe they had property in Florida. And they were gone a good portion of the time. And then when they were home, we didn't interact socially with them. So we didn't see them when they were home, but the majority of the time.
Okay. Do you recall the frontage of easement 2 on West Andrews? Was that something that someone could easily walk through on their morning walks? Or was it overgrown?
The width of the easement, is that what you're asking me?
Yeah, the width of the easement on West Andrews, was it clear cut or was it densely forested?
I would call it more dense. It was not clear cut. And so we knew it was like an imaginary drive that was in there as far as in our heads. So we knew there was an easement that went in there. We'd been told it was about the width of a small drive, but it was overgrown. And so to my recollection, there was nothing marking the width of that easement. It was just, we just knew it existed.
And did the Darby's ever complain to y'all about the dumping that your yard guy did?
Let's not get into what the Darby said. Right.
Did you ever, let me just ask this. Did you ever have any discussions with the Darbys? And don't tell us what those discussions were, but did you ever have any discussions with the Darbys about the fact that your yard guy was dumping stuff in easement 2?
No.
Okay. Now, at some point, did you ever have any discussions, don't tell me what those discussions were, with the Darbys about possibly buying easement 2?
There might have been a casual reference to that, but there was never a serious discussion about it.
And do you recall when that may have been?
No.
Okay. But subsequent to that, did you ever see the Darbys actually going out and using easement 2 for any purpose?
No.
Did they move back to Georgia after y'all had that discussion and start living there full time?
The pattern when they were in and out of that house didn't ever seem to change to me. I mean, they were there some of the time and gone some of the time. So I don't know to answer. I don't know how to answer that question.
Okay. Thank you, ma'am. I have no further questions. Ms. Stern will have a few.
Stern,
Okay, and I need to be up in front of that one.
you do.
I'm a little bit shorter, Miss Nikirk. Can you see me?
Yes, I can.
Okay, a little bit, sorry.
Chin.
Sorry. Good to see you again. If I heard you correctly, are you saying you're no longer actively practicing real estate in the Atlanta area?
No, I'm a licensed Georgia real estate agent with Ansley, Atlanta. So I'm legally I'm an active agent. I just don't, as the years have gone on since we moved away, I do less and less business.
Understood. And did you knew Claire Anderson before you sold the property to the Andersons, is that correct?
I did. We have a mutual friend that we got to know each other through that mutual friend.
When you purchased what is now the Anderson property, was Easement 2 wooded?
Yes, it was.
When you sold what is now the Anderson property, was Easement 2 wooded?
Yes.
Okay. Tell me, did you ever walk the full extent of Easement 2?
You mean the depth of it going parallel to Habersham, going back into it? Like behind the former property? No, it was wooded and wild, and I did not attempt to ever walk that portion of the property. I'm sure I walked into it, but I never walked the length of it from West Andrews to behind the Darbys.
Okay, you never walked the length of it.
Correct.
When was the last time you walked in Easement 2?
I have no idea. It would have been prior to us selling, and it would have been just putting a foot or two into it. From the path, the only time I went toward Easement 2 was on the path on that NOLA property beside the garage that my yard person used to walk in to put the grass clippings and the sticks in. That's the only time I ever attempted to walk into that area.
Okay. And from your property, if someone was walking from the Darby property to West Andrews, you might not be able to see them in Easement 2. Is that correct?
Yes.
So you don't really know whether the Darbys were actually walking from their property to West Andrews through easement 2.
I would say there was no sign of activity on that property. It was wild and remained wild looking, so there was no sign of anybody walking through it, as far as trying to clear it and make it, able to navigate it. But no, I did not see anybody walk it, but I wouldn't know if they had or not.
You too. I'm on one.
Okay, you wouldn't know if they did or not. And when you say,
Better answer.
and yeah, if, for the court reporter, verbalize it.
I did not see anybody walk that property.
Okay.
You just asked 2 questions in a row. Just ask one at a time.
Yes, Judge. Ms. Nikirk, did you hear the, I believe you answered it. You did not see anybody walk through the property?
I did not.
Okay. And that's from your view, that's not necessarily all the way back to the depth of easement 2, correct?
Correct.
So someone could have been walking that you wouldn't have seen.
Yes.
Were you aware of the Darby's use of easement 2 as a wooded area?
Objection, assumes facts not in evidence.
I'm just asking if she was aware.
Well, it assumes facts not in evidence, that is a fact, and there's no evidence supporting that fact of which she is supposedly aware.
Every word I heard this witness say is that it was a wooded area, so I'm not sure why we can't ask about a wooded area. Why don't you ask the question again, Ms. Nikirk, you're free to answer it.
Ms. Nikirk, you talked, I believe you called it a natural buffer, easement 2, correct? Between your property and the back property. I don't remember the gentleman's name, but you referred to easement 2 as a natural buffer, correct?
Correct.
Okay. Were you aware of the Darby's use of easement 2 as a natural buffer?
Well, it appeared to me the entire time we lived at that house on that property that they were using it like we were and just leaving it as is as a natural buffer and not a space that either one of us were using on a day-to-day basis.
So we're using it in its natural
Yes.
form?
Yes.
Okay. Thank you. No further questions.
Do you have any questions for Ms. Nikirk?
No, Your Honor.
All right. Do you have any redirects?
Just one or two. Let's talk about this alleged use. Did you ever see the Darbys out there planting stuff in easement 2?
No.
Did you ever see the Darbys out there trimming stuff and clearing it out?
No.
Did you ever see landscapers other than your own landscaper out there?
No.
Nothing further.
Jurors, do you have any questions for Ms. Nikirk? Okay. Ms. Nikirk, thank you for joining us.
You're welcome.
You are free to go. Appreciate it.
Thank you, ma'am.
Pardon me? You can, in fact, ladies and gentlemen, I forgot to ask you because we were, no, I'll repeat it once you're situated. Because we were figuring out what to do with Ms. Nikirk. If you had questions for Mr. David, which you may well have had, and we didn't work through that process. Did any of you write down questions for Mr. David? Because I'll put him back on the stand, so you all can ask. It sounds like he's gonna testify again, but I didn't mean to prevent you all from, asking him any questions. No? Okay, great. Mr. Edwards, next witness.
Do you swear affirm that the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead and have a seat. Can you state and spell your name for the record?
Stacy, Stacey, David, David.
When you're ready, Mr. Burrow.
All right. Ma'am, what have your personal uses of easement area 2 been?
What can they be? Anything legal? Anything we choose for easement 2 to be legally?
What have your personal uses been?
My personal uses have been not much. I have rarely been out there.
Okay.
But I've used it, my personal would be the enjoyment of my son.
before you ask any more questions, are you gonna, right now, we don't have the witness on the screen, we just have what might be
yeah,
a
okay.
screen share. And if you're gonna be sharing images, that's great, but if you're not, you should take that down. Great, and you're. Excellent, thank you.
Have you ever set foot on the easement?
Yes.
Easement 2?
Yes.
When?
I couldn't tell you exactly when.
Was it before or after you purchased the property?
Both.
Okay. Can we pull up 13?
Give me a minute, apparently
Uh-oh.
logged out of the meeting.
Well, so we're not having any dead time. Now, you took photos of trash that you found in your dumpster.
I did.
Did you take those personally or did somebody else take them?
I did.
Why'd you take those?
I'm sorry, repeat your question?
Why did you take those?
This is litigation.
Yeah.
It's me who's deliberating. I'm trying to shut that off. Give me a second. Let me share my screen and that way. Good Lord.
Try saying something to Rogan, see if we still got the video.
Testing. Yeah.
Disconnect audio there.
Okay,
Are we good now?
Yes.
Hello? Yes, we are good now.
What do you want?
Well, questions on the table. Why'd you take those?
Question again.
Yeah.
We took up the thought.
Why'd you take those pictures?
I took the pictures because when we had left the house, there was nothing in the dumpster. When we came back, there was trash in the dumpster. And I took the pictures so we would have a address of who it was that dumped them in, because there was an address on the box.
Did you take the pictures because you found the fact that there was some trash in the dumpster to be unusual?
Did I found it to be what?
Unusual.
I took the pictures because when there was nothing in the trash, and then when we came back, there was trash and there was no construction work going on. So we knew the trash was not from construction workers.
Right. So you expected the trash bin to be empty
Yes,
and there was something in it.
there was.
You didn't expect that.
No, I didn't expect there to be trash.
Is that why you took the pictures?
I took a picture so we had an address of who put it in there.
Now, circling back to your uses of easement area 2, can you please bring up P13?
The video?
I think so. Should be.
Yes.
Yep. Now, can you see the video?
Hold on, Your Honor. Should I stay muted or unmute?
Stay muted, please.
Can you play the video? Now, I want you to raise your hand, say stop, make some kind of indication when it shows where you accessed easement 2 from West Andrews.
I'm not going to be able to tell you where I accessed it from West Andrews unless you had a picture of it like this, not doing like this, because it all looks the same to me. So my answer is going to be, I don't know.
Was it more along the south end of the easement or the north end of the easement closer to Haversham? Can you tell me that?
I've walked on the easement from West Andrews up to the easement. I've walked on the easement from my property onto the easement.
How do you
We've
access?
seen, I'm gonna interrupt you for a second, just so we can clear this up. We've seen some pictures where there was a path made. Did you walk on the easement before that path was made?
Yes,
Okay, then we should keep going.
Okay, you said you accessed it from your home. How'd you get there?
from my yard, walk straight back.
through the grass or down the little brick path that we've seen?
I can walk straight through the back of my yard, through our wooded area onto the easement at any point. I don't have to walk that brick area. That brick area stops. It doesn't continue onto the easement. So when I've walked to the easement from my house, I've walked through pine straw, through grass, through a wooded area.
Is there a path in the wooded area?
Not so to say it's a path that someone built, no.
When you say a path, okay, you said a path that somebody built. Are we talking like pavers and?
There is not a
bricks or-
pavers, there is not a path. I could walk in any direction and get to the end of my yard onto the easement from any direction I wanted. I could go left and straight and here in the middle and straight and cut over. I could walk a little bit more over here if I wanted and go back and turn left. I can access the easement from anywhere going straight back from my yard.
After you make a turn?
Correct.
Can you bring up 22? Okay, can you, not that one, scroll. Yeah, no, go back, yeah, that one. Okay, ma'am, you said that, as you can see, this is a Google Maps street view from November of 2019. And when did you buy your property?
I can't see a date on this, on the screen.
Can you call it out again, please? You see that this is a Google Maps street view captured November 2019?
I do not see a date. Yes, I see that.
And when did you buy your house?
We bought our house in March of 2020.
Okay, can you go back to the regular image? Earlier, you said that we would need to show you the whole image and you could point to where you accessed easement to. I don't think the doohickey is working, so can you maybe get down and point to it? The touch screen, yeah, where she can draw.
Yeah.
That thing.
It doesn't
Yeah.
work with the child pad, so.
Right.
It's essential that you have, Ms. Debbie points them out, she will need to come to the big screen.
Or I can hand her the iPad and.
Let's have her go to the big
Yeah.
screen.
Okay.
So I can't tell you exactly where I walked, but I probably walked up through this way. I would have been more on the back of the easement and staying away from visibility from the Andersons. So I probably would have stayed away from his property. I would have gone more along this way.
Okay, and that was back when you first bought the property?
No, we bought the property, we went from our yard. We bought from, I mean, before the property, we accessed it from the back of our yard. With Alden Potts, with the agent.
Okay. Now, you can sit back down if you want.
Alden Potts, is that the name of your?
Alden.
Okay, now, you said that you didn't want the Andersons to be able to see you.
Just that if I've walked the property since February 24th, I would have walked the property in a way that I did not have to view the Andersons.
I thought the easement had already been cleared by February 24th. Did the easement not already been cleared by February 24th?
That's not your question.
Well, ma'am, you just said that you walked in the back of the easement so that the Andersons could not see you after February 24th.
Correct?
My question is, was the easement cleared by February 24th?
If I was to walk from West Andrews up to the easement, they have not cleared the part that Atlanta City has the rights to. They have not cleared that part. There is
front.
still ivy, the frontage. They have not cleared that.
Don't talk over each other, so you wait till she's finished answering and then
I
you can
understand
say
that.
frontage or whatever it is you wanna ask her about.
What about behind that?
It's cleared.
And it's been cleared since February 24th of 2021.
It was cleared February 24th.
Once you get past the frontage, it's wide open, correct?
Correct?
So how are you going to walk through the easement in such a way that the Andersons don't see you after February 24th?
I don't mean that they don't see me. I purposely stayed away from the easement, so stayed away from the front towards their house, so I didn't have to see Mr. Anderson. So it wasn't for Mr. Anderson not to see me, it was for me not to see Mr. Anderson. So if I was to walk the property, I would have walked in the back, so I'm looking and going where I want to go and not having to see Mr. Anderson.
But how wide's the easement?
I don't know how wide the easement is. I mean, it's more than 10 feet.
More than 10, less than 100?
I don't know, less than 100. I don't know.
Okay. So Mr. Anderson can't see you if you're at the back of the easement, but he can see you if you're at the front of the easement and vice versa. You can see him.
I'm talking about coming from West Andrews.
I understand. I'm saying if you go from West Andrews through the easement to your property. and
Mr.
you're-
Anderson could see me, yes.
So in the same way, you have to wait till he finishes.
I'm sorry.
This question may pivot in a way you're not expecting, so please let Mr. Logan finish the question. He'll give you, I'll make him give you, if he doesn't, all the time you need to answer the question.
Sorry, yes, sir.
So I feel like we're talking past each other. So let's kind of turn it back. We have along the street, there is this frontage area, correct? And there are still ivy, trees, shrubs, whatever along that,
Yes,
right? Behind that, between that and the property line that the Andersons share with you, the easement area has been cleared, correct?
correct.
So my question to you is, if you're at the back of the easement area, you can't see Mr. Anderson? But if you're at the front of the easement area, you can see Mr. Anderson.
If I'm on the edge of West Andrews, walking up, there's shrubbery there, and there's shrubbery in front. If I'm walking here, there's shrubbery in front, so then I don't directly see him right there. Would I see Mr. Anderson if I walked up on the property? If he was there, yes.
So
If I walked up on the easement.
so you haven't walked up on the easement,
I have walked up on the easement.
just to the frontage area.
Can you put
I've
the
walked-
picture up so we don't?
I've walked the
Yeah.
entire easement from left to right, north to south.
Yeah, just pull up one of the ones that, yeah.
So which one?
No, well, yes, but keep scrolling. That's fine, just rotate it. Yeah, that's fine, just rotate it.
All right. let's have
Yeah,
this
there we go.
discussion One last time.
So my question is, do you see the area behind what appears to be a net?
I do?
And then that's covered in pine straw. And then behind that, you have what looks like some more trees and ivy. I'm asking you, would you walk kind of through the easement behind the net?
I have walked behind the net. I've walked in front of the net. The net is not always in the same spot.
So you walked in front of the net. When did you walk in front of the net?
I couldn't tell you the time I've walked in front of the net. I've walked all over the entire easement.
Did you do that before or after February 24th, 2021?
I couldn't tell you. Before, I've walked on the entire easement before February.
I'll just move on. Let's go back to, we had been talking about the trash in the dumpster. Now, you say that you took a picture to have an address.
Yes,
Is that so that you could leave and you'd still have it?
it's so I would have it without climbing in the dumpster.
Understood. And whose address was it?
Tracy Anderson.
And did either you or your husband or anybody go and speak to Mr. Anderson? Not asking for what was said, but do you know if anybody spoke?
My husband spoke.
Okay. And after he spoke to Mr. Anderson, did you ever again see any trash in your dumpster that you believe should not have been there?
I don't know. There was always trash in the dumpster afterwards.
Was there any that you attributed to someone other than your own trash generators because of the work we've done at your house?
No,
And did you take any more pictures?
no,
Is it fair to say then that that particular issue, not asking about everything, but that one issue, Mr. Anderson putting trash in your dumpster, was dead and buried after your husband had a conversation with him?
yes,
Did you ever take any pictures of a tree being removed from easement 2?
no,
Did you ever take a picture of a shrub being removed from easement 2?
no,
Did you ever take a picture of any ivy or ground cover or vines, trash or anything being removed from easement 2?
yes.
What was that?
It was a picture of equipment with the shrubbery in front of it, with the ivy and all in front of it. I took a picture of equipment.
Equipment. Can you pull that up?
And it's exhibit A. Has it been offered? Yes. So, sure.
Yeah, because yeah. Do you recognize this?
Yes,
Is that the picture that you took?
yes.
You took that personally,
I'm not sure if that's my picture or Jean Noel's picture.
but you recognize this.
I do.
Okay. When roughly, I'm not asking you for a specific date, but month generally, when was this taken?
April.
Of?
I don't know. April, September. I'm not sure when it was.
Was it after you bought the property?
Yes,
Did you take this picture because of the fence that was going up? Or did you take this picture because of the whatever kind of machine that is?
because of the equipment on the easement.
Do you know what kind of machine that is?
I do not.
Did you, after and before you took this picture, watch and see what the machine was doing?
The machine was not moving at the time when I took the picture.
Did you ask anyone what the machine was there for?
I did not. I would have reached out to Casey. I reached out to Casey and told her it was there. I didn't ask why it was there.
When did you do that?
I'm not sure when the date was that I would have sent out this picture.
Was this before you were served with a complaint? Or after?
When was I served a complaint?
there's not a fence up in this, correct?
There is not a fence.
And when was the fence put in?
October 6th.
So this would have had to have been taken before October 6th.
Yes,
And we're talking 2021, right?
yes.
Okay. Was it 2020 or 2021?
Don't know.
When did the fence go in? October 6th of 2020 or 2021?
I bought the house in March. The fence went up October of 2020. So this is 2020.
So you would have notified Ms. Sturm in October of 2020?
I don't know. I don't know when I notified her. I don't know what when I took the picture. I don't know if something would have been moving on the easement. I would have notified our attorney had we had attorneys at that time.
Would you have documented it?
No.
Why not?
Why would I document it?
You documented the trash. Why would you not document something happening on the easement?
Well, if you take a picture, isn't that documentation?
That is, yes, I agree, but I'm asking you, if you notice something going on the easement, you just said that you would document. You document these things, yes?
Taking a picture?
That counts, yes.
Okay.
Do you have any other pictures of any equipment, any landscapers, anybody doing anything on easement area 2, other than this?
On easement 2, I have a picture of the sod.
Did you take a picture of someone installing the sod?
I took a picture of the wheelbarrow and the sod on the side of the street and the wheelbarrow on the easement.
Did you produce those?
I gave all of our pictures to Casey.
When did you take the picture of the wheelbarrow and the sod?
On the day that they were installing the sod.
Did you take that picture from inside of your car or outside of your car?
From inside my car.
Did you ever speak to either Tracy or Claire Anderson about any trees, vegetation, shrubs, anything being taken out of easement 2?
No.
You did not. Why not?
I didn't speak to either one of them.
Ma'am, I guess my question is, if you observed easement 2 being disturbed,
Yes?
why would you not go and speak to Mr. or Mr. Anderson?
I spoke
Mr. or
to-
Mrs. Anderson?
Because I spoke to my husband and my husband would have taken care of that.
So any discussions with the Andersons regarding easement 2 would have gone through your husband?
I don't know if any discussions would have gone through my husband. All discussions about easement 2 went through my husband, yes.
Are you aware of where your contractors would access your property from West Andrews?
In my driveway are the ones I'm aware of. Anywhere else, no.
So you are not aware of any contractors parking on West Andrews and accessing your property from West Andrews across the Andersons' property?
I am aware because I was told that Mr. Anderson complained about it.
After you found out about that, did you take any steps to direct these contractors not to access your property over the Andersons' property?
Yes, I told our contractor
And what did you tell him to do?
that if they were to park on West Andrews, they needed to walk behind on the easement and not through the Andersons' yard.
Did you ever observe them walking through the easement?
I did not.
Let's go back to this issue with the sod. You said that you took a picture of it. Did you speak to anybody?
I did.
Who'd you speak to?
I spoke to two gentlemen that were laying sod.
What'd you tell them?
I said that they needed to speak to the property owner, that the yard was in litigation and that they were not on his sole property, that this was an easement that was shared.
The property was in litigation on February 24th, 2021.
There were talks. I don't know. Hold on.
Excuse
I
me.
told them that this was an easement. This was an easement and that it was not his sole property and that he needed to speak to the owner.
So you didn't tell him that it was in litigation?
I did not tell him it was in litigation, no.
Did you threaten to call the police on him?
I did not.
Why not?
Because it was a friendly conversation. I didn't need to threaten to call the police to them.
If it's friendly conversation and everything is all hunky-dory, why would you not then just simply go and knock on the Andersons' front door like your husband did with the trash and speak to them about this?
I didn't speak to the Andersons.
I
I
understand.
did not
you
have a
didn't-
relationship with them. And after the trash incident, I did not speak to them. I did not have a reason to go over and speak to them.
Is the trash incident the reason that you didn't have any reason to go speak to them?
Probably.
So you were so upset with them over a box in a dumpster that you refused to go speak to them?
I wasn't so upset. It was rude. It was disrespectful. The neighbors had not come over to say, hi, hello, my name is, but yet they just threw their trash into our dumpster.
You have just testified that after your husband went and spoke to Mr. Anderson, no more trash ended up in the dumpster, correct?
Correct?
Obviously, communication solved an issue. Why would communication have not solved this new issue?
I didn't say it didn't solve the issue, but I never still wanted to go over and speak to the Andersons. I had no reason to walk over and speak to the Andersons.
Instead, you speak to their landscapers?
I spoke to the person laying sod on the easement. Yes, directly to the person doing it, and told him to speak to the person that hired him to do it. I also asked for his business card, which he gave me his manager's business card.
Now, have you previously testified that these landscapers didn't speak very good English?
They did not.
So the communication with them was kind of spotty?
Yes, it was kind of spotty.
So, I mean, at that point, were you even aware that they understood what you were talking about?
No, they probably did not. So he gave me his business card. He said, here's my boss's business card. He handed it to me. And I then called his boss.
So you have what sounds like a somewhat unproductive conversation with some folks that don't really speak English. And you didn't think to at that point to go ahead and kind of address the issue, go and knock on the Andersons' door?
Yes, sir.
I object to the question's mischaracterization of the testimony, and it's also cumulative. He's asked this now 3 times.
So I'm gonna sustain it on the second part. I don't know if it's mischaracterization, but, I think the jurors get it. She didn't talk to the Andersons.
I'll move on.
Okay.
Prior to February of 2021, had you ever spoken to either of the Andersons?
No,
And since February of 2021, have you spoken to either of the Andersons?
Mr. Anderson,
On how many occasions?
once.
What was that conversation about?
On February 24th,
Yes, ma'am.
my only words to Mr. Anderson were, "You are a real gentleman, aren't you?"
And that's the only conversation that you've ever had with Tracy Anderson.
That's the only words that came out of my mouth to Mr. Anderson.
That is not what I asked you, ma'am. I asked you, is that?
That's the only
Don't
conversation.
answer.
That's the only conversation that you've ever had with Tracy Anderson.
Yes.
That's the only time that you've ever interacted with Mr. Anderson.
No, you asked, was that the only conversation? You asked it a few times and she's answered it now. We're not doing triplicate or quadruplicate of, did you go to their door after you talked to the sod layer? Did you have more than one conversation with them? So
Come on, I'll move on.
let's move on.
What did Mr. Anderson say to you in February 2021?
February 2021, February 24th, Mr. Anderson, without using words, spoke to me with his middle finger. And he said to me, "Roll down your window." So I rolled down my window. And he said, "You motherfucking fat bitch. If you ever come on my property again, I will run you over. I will sue you." And then he proceeded to say, after I said, "You are some gentleman, I am a gentleman." And then he said, "You are going to die." That was our conversation. He also said, "I play golf with someone who knows you and he hates you and he's not your friend and his wife hates you. And this person calls you a fat bitch. Everyone, you think you're so great that your kids go to Lovett. Everyone at Lovett hates you." Those were the words from Mr. Anderson. Those were his first words and only words to me.
Fair enough. And after that incident, you sought a restraining order against Mr. Anderson, correct?
Correct.
Now, was that asking for a restraining order because Mr. Anderson was stalking you?
It was asking for a restraining order because I was terrified of the man.
You recognize that man?
I have seen this.
Can you please read what it says there at the top?
So let's make sure that our lawyers know what you're showing her as well. If it's an exhibit, just give them the number. If it's not, give them a copy.
This mine.
And one of the exhibit books, you can say, 39, whatever it is.
Yeah. Does it say stalking ex parte temporary protective order?
It does?
And did we have, was there a hearing on this restraining order?
There was?
And during that hearing, did you acknowledge that you weren't even sure if Mr. Anderson had been stalking you?
I don't recall that. I don't recall having that conversation, whether he was or was not. Did I think he was? Yes,
You believed he was stalking you?
I did.
And you've interacted with him one time?
Correct.
Was the restraining order, was that your decision?
It was? It was a joint decision between myself and my husband.
Do you think Mr. Anderson's still dangerous?
Yes,
You're still afraid of him?
yes.
Initially, you stated that your use of the easement is your children's enjoyment?
That's part of it. My son, yes.
Okay.
How many kids do you have?
I have two kids.
Okay, boy and girl, boy.
I have a daughter who's older and a son.
Now, so presumably they use the easement, yes?
Yes,
In full view of Mr. Anderson's home, yes?
I've not been in Mr. Anderson's home, so I don't know if he can see them or not.
In full view of Mr. Anderson's property?
They can see part of his house, yes, the side of his house.
Can they see his driveway?
They can see his driveway.
Can they see his garage?
They can see the outside of his garage.
Can they see when he pulls up into the driveway in his car?
They can if they're looking, yes.
Are you sitting in your car when they're out there on the easement?
I have before. I've sat in the car on Andrews.
Have you ever walked out to the easement and kind of sat in the chair?
The chair's no longer there. The chair was removed the day it was put down.
Have you ever gone out onto the easement with your children while they're playing?
Yes,
Do you always go out onto the easement with your children while they're
No.
playing? No. Do you have any personal knowledge of Mr. Anderson waving firearms around?
That's a fine question, but I don't want there to be confusion. Can you explain to the witness
Yes.
what you mean by personal knowledge?
When I say
Told
personal-
You saw it, you read it in the newspaper.
When I say personal knowledge, I mean, have you seen him? Have you heard about him? Have you seen a picture? Anything like that?
I heard from the person that saw the
So
gun.
someone told you.
Yes,
Do you have any other reason to believe that Mr. Anderson owns any guns?
no, I have no reason to know anything about Mr. Anderson with guns
Do you believe that Mr. Anderson owns guns?
because he said he did. Yes,
Okay.
I believe that.
Now, you said that you were notified. I don't want to hear about any conversations, any content of those conversations, but you say that you were notified that Mr. Anderson had a firearm. Did you call the police?
I did not.
Why not?
I went straight to the situation. I didn't call the police.
When you say you went straight to the situation, what do you mean?
Your Honor, I'm gonna just forewarn her not to recite any communications she may have had with my firm.
Okay. Want to clarify a little bit of that forewarning. You, of course, can testify to anything you want. If you start talking about lawyer-client communications, that opens a door that your lawyer may counsel you not to do. And we may have to pause so you two can talk. It's not a problem for you to say, I reached out to my lawyer, but we stop there. It's not, and I told him X or her, and she told me Y. And that's not what Mr. Logan's trying to get out. He's trying to understand what you did if you didn't call the police. So
Yes, sir.
it's okay to say, I reached out to my lawyer, but then Mr. Logan ought not to say, what'd you say? What'd your lawyer say? If he does, I'll interview.
Okay, thank you.
So, without revealing any kind of the content of communications that you may have had that are privileged, when you say you said address the situation or went to the situation?
I went to the
Went to
situation.
the situation. What does that mean?
That means my son called me and said,
I don't want to hear what your son said, ma'am. That's hearsay.
okay,
I just
well,
want-
I went to the situation.
Object, she's entitled to answer. He's opened the door to ask what she did.
Okay, and she can explain it, but he's free to object to hearsay. So it's not opening the door where he said, what did you do next? And she says, I talked to your lawyer who called me. So don't talk about what your son said, but you can certainly talk about, you got a call from him and what he said to you made you hurry on out to the easement.
Yes. He called me and I was with my husband and we both got to the easement. Went to the easement. We were not home and we went to the easement.
Where were you?
I don't even remember where we were. We were somewhere we were able to be close enough to get there quickly.
I mean, are we talking like next door? Or are we talking you were having lunch 20 minutes away?
We were not 20 minutes away. We were somewhere in the neighborhood. I'm not sure where I don't remember where we were, but we got there.
So you were under the belief that a man that you believe is dangerous was waving a gun around and your first instinct was not to call the police.
First of all, no one said waving a gun around. I never heard anything about waving a gun. And you don't want to hear what he said, so I'm not going to tell you what he said.
You gotta make sure you're not creating what was said and saying you can't say what was said. If you want to tell you what her son said, feel free to ask, but otherwise you can't substitute what you think he may have said.
Yeah, I don't want to know what your son said. You were under the impression that Mr. Anderson had a gun, yes?
When he called me, I was.
You believe Mr. Anderson is dangerous, yes?
I do.
Why would your first response at that point not be to notify law enforcement?
It just was not. My instinct was to rush to my son. I did nothing but rush to my son. And I notified my attorney.
Did you have your phone with you?
I'm sure I had my phone. Yes, I had my phone. He called me.
Were you in the car or were you walking?
We were in the car.
After this incident, after the incident with Mr. Anderson in February of 2021, whenever, really, have you had security cameras installed around your house?
We have Ring cameras. Ring.
That's like the doorbell, right?
It's a Ring camera.
Does it have, is it just the doorbell or is it a whole system?
No, one of them is a doorbell and others are just cameras, but they are the brand Ring.
Okay, I understand. Where are they positioned around your house?
We have one at the front door.
Okay.
We have one in the driveway parking pad. And we have one onto our back patio.
Where are they pointed?
The parking pad is the one in the driveway. The front yard, front entrance of our front door and our patio.
Okay. Do you know about when those were installed?
After February 24th.
Do they capture audio?
They do capture audio.
Whose idea was it for your son to go and practice lacrosse on Easement Area 2?
It was his idea.
Where had he been practicing lacrosse prior to that?
Prior to living there,
Prior to living there, prior to, at any point, I mean, just all before. His entire history of practicing lacrosse prior to the first time on Easement Area 2.
so you want me to go back to the years that he started playing lacrosse and where did he practice? He practiced at schools. He practiced at lacrosse fields. He practiced in our yard.
Which part of your yard?
Which house are you referring to?
I don't know about any other houses, so the one on
You just
Haversham.
asked me for
Well,
every
narrowed it-
incident.
Narrowed it down, 'cause he should, and he's asking about the house at issue here.
The house at Cottage,
At-
where
on
we lived
Haversham.
at Haversham.
Yes, ma'am.
Before the easement, before he moved and put the nets up on the easement, he would have practiced. I think he had a bounce back. I think he had a bounce back in the front yard.
Is there grass in your front yard?
There is.
Is there grass at the school fields that he practiced on?
Some fields have grass and some have turf and some have pine straw.
Which ones have pine straw?
Some of the sides of Lovett's back fields.
The sides?
Denny, one of the fields at Lovett.
When you say the sides, I mean, are you talking like a side field or the periphery of a field?
Do you know lacrosse?
No, ma'am.
Okay, well, if you're practicing lacrosse, you also can practice on the side of a building, which you are throwing the ball back and forth. You throw the ball, you catch the ball. Back, it's called bounce back, and that's wall ball. So he does that on the side of walls. He's practiced lacrosse many places.
Okay. Have you ever spoken to either Diane or Lynn Darby?
Yes.
What did you say to him
Which time?
first time you met him?
Hi, nice to meet you. They owned the home I bought.
Is that the extent of the conversation?
I have no idea. I don't remember our extent of our conversation when I first met the Darbys.
Okay, let's narrow it down. Have you ever spoken to either Diane or Lynn Darby about Tracy or Claire Anderson?
I have not.
Yes, sir. It's down. It's passed, okay. So We have more time. How long do you think, the remainder of your cross-examination will go? You can say 6 hours. I'm not saying we're gonna finish today. But I'm wondering if we might finish it today. Because if not, we may just break. We need to pause for a minute anyway. But if you've got 20 more minutes, we'll take a quick break, let everyone stretch, and then we'll try to wrap up this cross, today.
It could be 20 minutes. It kind of depends, unfortunately.
Okay, well, let me ask the jurors. So we need to take about a 10-minute break now. We also, sorry, we also could just stop for the day and then we'd start tomorrow at 9, normal start time, not a 1:30 thing. Are folks okay waiting 10 minutes and picking up, or are there folks saying, I'm seeing a lot of nodding heads. Let's take a 10-minute break. If after the 10-minute break, some of you say, no, Mas, you have had a free 10-minute break here and we'll in for the day. But head on in there, please. We'll get you back out here as soon as we can.
All right, good.
All right, Mr. Logan, anything on the record before we break?
No, Your Honor.
Mr. Schneider? No. All right, let's take a break. Mr. Williams, I will just let us know when you're done. Do what you need to do. Please.
It's a quick one.
No. It is what you need. And I'm sorry, you should have flagged it earlier. I didn't mean to run you past that. All right, Mr. Williams, are you ready?
Oh, yes, sir.
We are back on the record. Deputy Gordon tells me that the jurors are ready and they want a hard stop at 5:45, which is about 15 minutes. So you'll cover what you cover in 15. You don't need to finish, but you'll cover what you cover. We'll also let you know that the jurors have reminded Deputy Gordon that several of them were the ones where we said, don't worry, Friday, you go to your funeral, you go to your et cetera. So we're not trying this again. If we need to figure out a day next week that I don't have, that we bring the jurors back, we can do that. But I'm also reading the jury's body language, and I get the sense they have their fill of two fancy households fussing over an easement, and they're ready to let you know what they think. I don't know that anyone will be happy with what they think. You asked for a jury, you got a jury. That said, I also appreciate that you have messy cases that you need to step forward, and folks have been hard at work. We haven't wasted time here. So just know that you may need to agree if you want to press on Friday rather than we find a date where all of us, including the 13, can come back with less than 13, maybe less than 12. I will poll them in the morning when they come back. I'm not gonna make them stay late, but they were reminding Deputy Gordon of some obligations that we said we could handle. And it could be that we carve out some time on Friday that doesn't start at 9 so people can do funeral or other things. We'll see. So I want to lay that out there. It's not an instruction, it's an observation and maybe an exhortation. Mr. Edwards, you look like you want to say something.
Yeah, in the interest of moving this along, we can stop right now. I don't know if they're going to ask any direct at this point. I don't know if Nedwick is going to have any questions one way or the other, but we can finish with her. We've got one more witness, and that is yours truly. My direct should take 5 minutes, if that. The cross should take 2 or 3 minutes or 2 or 3 hours, depending on how they want to go. So, I mean, that's where we are. We could conceivably finish today.
I mean, you could rest if,
Yes.
if there isn't going to be a direct or whatever we call Ms. Medwick's questions
If
for.
there's no direct, I'm not doing anything.
Okay. Mr. Schneider, I am not in any way precluding your full exploration of this witness at this point. If what we hear from Mr. Logan when the jury comes back in is actually we don't have any more questions, would you want to ask questions now? If so, would it be brief? Or would you just reserve your questions to the David's case in chief?
Your Honor, I would reserve it just for the sake of expediency on the case in chief.
Okay.
What I would ask wouldn't be satisfactory for us to do that now. So.
Okay. So why don't we have the game plan then? We bring the jury in. You're going to say, well, I'll just say, pick up where you left off. You'll say whatever you want to say in connection with actually I'm done. I'll get answers from Mr. Schneider, Ms. Medwick. And then do you envision pounding on Mr. Edwards on his attorney's fees, or is that not going to be a big cross-examination?
We have a couple of technical issues with it.
Okay. All right, well, we'll start the cross, and if we don't finish it, that'll be a short in tomorrow morning, and I'll let jurors know before they leave today. All that's left is a little follow-up. But when you say technical issues, Mr. Edwards presented that it could be 2 minutes, it could be 2 hours. I'm assuming it's not 2 hours, as technical as it may be.
Right now, I more of a legal technical issue, not
Is that something that we'll work through, or
Yeah.
you need to
Yeah.
lay some groundwork for questions for him?
I think it's something we could work through.
Okay. All right. Let's bring the jurors in, please.
All right, jury.
Going to the chief seats. Chief seats. Yeah, I'm going to the chief seat this time. Way up in the back.
Judge is present and accounted for.
All right, thank you for returning, jurors. Mr. Logan, you were going to get to your cross-examination of Will David. Pick up where you left off.
I have nothing else at this time, Your Honor.
All right, thank you, sir. Mr. Schneider, do you have any questions for Ms. David at this time?
We do not, Your Honor.
All right, and no, any questions?
Not at this time, Your Honor.
All right, Ms. David, you may step down. Thank you.
Thank you.
Oh, right, don't step down. There may be questions from the jurors. Do you have questions?
I have
And if you do, get them to deputy board. I don't mean to shortchange that. You just suddenly had some, yes, no question. And these jurors are slowing everything down.
Any more questions?
No, sir.
Thank you, sir. Okay. Ms. David, can you share with the jury a little more context about your loan interaction with Mr. Anderson? And by that, I mean, you were in a car, he was not in a car. How did the conversation start?
The morning of, I had taken my children to school, and that's when I stopped and talked to the yardman because that was on my direct path to school. Took my children to school, came home, went inside to get ready, came out, got in my car, and as I'm backing out of my parking pad, I realize as I'm backing out, Mr. Anderson is standing right behind the wall of my parking pad. So that is how it came about. And he's standing there with his middle finger and he's doing this, roll down your window.
And then the rest that you shared with it, that's how it then unfolded. Middle finger, roll down your window, you roll down your window, then the exchange that we heard.
Yes, exchange happened.
Okay. Mr. Logan, based on that, question, do you have any follow-up?
Just a couple.
Okay.
And ma'am, during this encounter, you were pleasant the entire time?
Excuse me?
You were pleasant the entire time with Mr. Anderson?
I said one thing to Mr. Anderson. I
You-
sat in silence and said one thing to Mr. Anderson.
You didn't tell him he was a horrible man?
I did not tell him. I don't know Mr. Anderson. I didn't tell him he was a horrible man.
You didn't tell him that he had multiple wives?
I don't know how many wives he's had. I don't know anything about him at this point.
All right, nothing else.
Thank you, Ms. Dubby. Appreciate it. Mr. Edwards, next witness.
Plaintiff calls Randy Edwards.
All right. You're gonna roll, Mr. Logan.
Raise your right hand. Do you swear affirm that testimony you will give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, I do.
Have a seat. State and spell your name for the record.
Randy Edwards, Randy Edwards.
Mr. Edwards, do you represent Tracy and Claire Anderson in this matter?
Yes, I do.
And have you reached a fee agreement with the Andersons in this matter?
Well, yes, we started with a fee agreement, and then over the course of time, we've modified the fee agreement. Originally, it was a straight hourly rate. Over the course of the case, we revised it to a reduced hourly rate with a success fee based upon what happened at the appellate level.
Can you explain what a success fee is?
Well, it's sort of like betting on yourself. We do a lot of contingency work, either full or partial contingency. And the success fee is, I want my clients to know that I've got skin in the game. I'm confident in my legal position, confident in my ability as a lawyer. Tell them, if we do X, I'll take a reduced hourly rate instead of charging you full boat where I've got no risk. I want to have risk with you. And I will tell them, in this case, we reduced my hourly rate from $425 to $250. And on the back end, assuming we had a successful result at the appellate level, my hourly rate would double, go up to $500 an hour. So that's what I mean by a success fee. We do that. We do a lot of, I do mainly straight contingency, but we do a lot of reduced hourly rate with partial contingencies. And Tracy and I agreed that was a fair structure here.
And have you tracked the hours worked on the case?
We do that on a regular basis. We have accounting software that we have actually changed during the course of this case. We used to use what was called tabs 3. You enter your time and it does it automatically. And now we've switched over to a My Case software. But yes, we keep track of our time, although giving my proclivity for contingency, I'm not real good at entering my time on a day in, day out basis.
And have you prepared a set of invoices reflecting the amount billed to Mr. Anderson?
Well, I can't say I've prepared them. Those are created in the ordinary course of business. And yes, those are in the regular course of business.
All right.
Now, we have redacted them because we don't want to reflect what we're doing. Don't want to say talking to Tracy about X. So that stuff is redacted.
Redacted meaning not that you didn't account for those hours, but there may be entries in there that say contact with client, and then what follows is marked out because that's not anyone's business but yours and your client's.
Correct.
Okay.
Now, as we get closer to the trial, just general trial prep is the description, and everybody knows that. General trial preparation is the description. That doesn't give away anything, so that's not redacted.
I'm showing you what has been marked as plaintiff's 61. Can you recognize that document?
Yes, sir.
What is that document?
This is a compilation of our exhibits, not our exhibits, our bills. I believe we've got a total of 6 bills. Again, being primarily a contingency lawyer, I don't send out hourly statements every month. Just when it gets up to a certain rate or a certain threshold, I'll send a bill out.
All right, and this is, this document is prepared in the normal course of business?
With the exception of the redaction, yes.
Move to admit plaintiff 61.
The objection of plaintiff 61.
Yes, Your Honor, I object to plaintiff 61. It's not competent evidence of attorney's fees, either reasonable or necessarily incurred in this case. A lawyer cannot submit in support of a claim for attorney's fees fully redacted statements as are presented throughout plaintiff's exhibit 61, with the exception of perhaps, I think, his trial prep time. So I would object to plaintiff 61 as being in violation of the burden, unable to establish the burden of proof and irrelevant.
Okay, I'm gonna allow 61 in, but before the end of trial, either I'll need to see an unredacted version, and it may be that ultimately you need to see some of the unredacted version, because I share your concern that almost every entry is redacted, and that makes it hard to assess what exactly is going on. So I know there needs to be a balance struck. So I'll admit 61 and let you proceed with the examination to establish that baseline amount, but it will be subject to the concerns raised by Mr. Snyder. I don't know that we'll need to resolve in the presence of the jury.
And what is the,
My concern is that he's going to testify as to the sum of these fees, that may be influenced by the outcome of our discussion about the redaction.
It may, and so the number may be lower that the jury ought to consider by the time they're deliberating about what attorney's fees will be. But I don't think we'll work through it at this juncture, but you are preserving that right to say the number was X. Now that we've seen what the redacted entries are that don't say prepare for trial, which is virtually everything else.
Right.
You know what, the number is now X minus Y.
I'm just preserving my objection, Your Honor.
And it is preserved.
Thank you.
and what is the total amount billed to Mr. and Mrs. Anderson?
Well, I can expand upon what we did on the reasonableness if you'd like, but the total amount billed through Sunday, or not billed, incurred through Sunday is $92,962.23, which includes an $18,475 success fee. I've also calculated additional time through the close of business yesterday for the trial, 36 hours for each of us at my rate of 500 and your rate of 400, 18,000 for me, 14,400 for you, total of 32,400. Add another 8 hours for today, whatever that math comes up to. Total subject to today and tomorrow is $125,362.33.
Okay, and can you explain the work done?
Yeah, if we look at the first invoice, this reflects our time from March 26, 2021 through April 15, 2021. What we were doing during this time was, number one, preparing to defend the stalking temporary protective order that was issued, a number of discussions with opposing counsel, and then drafting and filing of the complaint, which we also have expenses on here. We show the filing fee. That's the expenses or advances are not redacted. Filing fee, filing this case on April 12th, 2021. Some filing other documents. So the first invoice is for the initial defense of the TPO and the drafting and filing of this lawsuit and some communications with opposing counsel. The next invoice begins 6/18 of 21 and goes through August 18 of 21. Again, that's primarily going to be the discussions that were alluded to earlier between myself and opposing counsel, and also in the early or mid to late August, there is some time for a motion that we filed, an emergency motion that we filed in the court. We continue on. The third invoice reflects time from September 22nd of 2021 through December 2nd of 2021. One of the things in this case, seeing is how it involves what we call a quiet title action. It's automatically referred to a special master because surprisingly, Superior Court judges have better things to do, more important things to do than to deal with title issues. So that's referred to a special master. So we had to have a hearing before the special master on some issues related to the validity of the title and some other issues. So there wasn't a whole lot of time in this. The time for that was only 4,675. And let's see, we have a U.S. legal support. That was a transcript that was taken down. The next invoice is from January of 22 through February of 22. There was a lot of activity going on at this time. That's when we took the David's depositions. That's when they took the Andersons depositions. We also took Mr. Shostak's deposition during this time. So there's a lot of time preparing for and taking and defending depositions in a relatively short period of time. This is January 20th through February 2nd of 22. That's a total of 14,462 in time. Then we move forward. Not a lot of activity in this case. The next entry, and this is kind of out of sequence, the next entry is invoice number 141. Invoice date March 9th. This is unredacted. There's really only one redaction, and that is on March 4th, 2024. Correspondence from Eric Logan for 1 hour. I know what that was regarding. We can talk about that if we need. And then the very final invoice, which is actually out of sequence, is invoice number 142, and this covers time from September of 22 through August. Is that right? September of 22 through July of 23. And this is the appellate portion of the case. This is when we're drafting briefs at the higher court level. So in my experience, I've been practicing law going on 32 years. The time for the work we did is very reasonable. I imagine it's fairly light compared to what the Weissman folks had billed. And the rates, the original rate of $425 for me and $250 for you was reasonable. I believe the success fee, the reduced hourly rate was more than reasonable, and the success fee is also more than reasonable.
No further
Do you have
questions.
any questions?
No.
All right, Mr. Schneider, do you have questions now? Do you want to wait till tomorrow morning, or is your main focus what we work through outside the presence of the jury in connection with the sparse nature of the written bills as supplemented by what we've heard from Mr. Edwards?
I would prefer not to take up the jury's time on that. And I
Okay.
believe we could probably just work through it if I can be provided with an alternative version of this.
Okay, we'll talk about that outside of jury's presence.
Thank you.
Mr. Logan, next witness,
We rest.
plaintiff rests. All right, ladies and gentlemen.